Every day in the USA, people find themselves in court.
All right, Trenton Berry. Okay. This is in the matter of the people of the state of Michigan versus Trenton Berry, file number 24-21813FC. I have Douglas Hartung and Alexander Bayonetto appearing on behalf of the people, and I have Salvatore Malaro and Matthew Murphy appearing on behalf of Mr. Berry. I have a May 13 of 2025 report from the Forensic Center on competency. Has that been admitted for the record?
Yes, not yet.
Okay, Mr. Malaro, you also received this competency report?
Yes, we did, Your Honor.
All right, and Mr. Hartung and do you stipulate to entry of this report?
We do, Your Honor.
And Mr. Malaro, do you stipulate to entry of this report?
Yes, we would stipulate to the entry of the report.
All right, so the report is dated May 13 of 2025 regarding competency to stand trial. The back of it. Looks like he was seen by Dr. Edward Rodriguez. Let me get going back here. And the report was submitted by a Samantha Baker, licensed psychologist for the Forensic Center. And the findings are that Mr. Berry was an 18-year-old male referred for evaluation regarding competency to stand trial. They reviewed his prior records, school records and mental health issues, showing that Mr. Berry had been compliant with both psychotherapy and psychotropic medication, both prior to and following his arrest, received consistent treatment. There is an intellectual disability, and that is noted and evaluated in the records. During the evaluation interview, Mr. Berry demonstrated the ability to engage appropriately with logical thought processes and fair insight. His speech was linear and relevant throughout the interview. He knew who he was, where he was, the exact date, and understood the purpose of the interview. He appeared to be a low average intelligence. His emotional expression was relatively unremarkable. He was polite and cooperative with the interview and denied any current thoughts of suicide or self-harm. Mr. Berry was aware of the underlying allegations against him. He demonstrated an understanding of his current charges and the associated maximum penalties. He demonstrated capacity to discuss the allegations against him in an organized manner. He spoke at length about the roles of various persons and roles related to resolution in this case, including judge, defense attorney, prosecuting attorney, witnesses, defendant, and jury. He understood the implications and definitions of various pleas, including guilty, not guilty, no contest, and not guilty by reason of insanity, either following education or prior to receipt of such education. He understood the concepts of plea bargain and a trial and discussed these contents in the context of his current charges. He recognized the utility of working with his defense attorney despite his expressed concerns. He expressed a desire for a positive outcome, which to his case, which demonstrated self-interest and flexibility. And they end with, while I acknowledge that the ultimate decision in this matter rests upon a judicial determination, in response to the request of the court, it is my opinion that Mr. Berry was competent, is competent, and was competent to stand trial at the time of the evaluation. That is to say, he was capable of understanding the nature and object of the proceedings against him, as well as assisting rationally in his own defense. Anything to add, Mr. Hartung?
No, Your Honor, thank you.
Anything to add, Mr. Malaro?
No, Your Honor.
So I do have a finding in order on competency. I'm going to make a couple copies because I think they need like 5 originals. So we will make those copies. The court will find that the defendant is competent to stand trial. The The case shall continue to the next stage of the criminal process. And at this time, are the parties requesting a pretrial date?
Judge, we'd request a trial date.
Okay, so Ms. Adams, I'll put that finding in order on top of the report, and then I'll just need 4 copies.
Okay.
And Ms. Adams, would it be possible to get the book? Oh, thank you. No, everyone. Take this. And bring this. Yeah. All right, hold on 1 second. Mr. Malaro, how many days do you think you need for trial?
I expect the defense to put on 2 to 3 days worth of testimony.
Mr. Hartung?
This was originally set for 2 full weeks of trial, including Monday,
Okay,
back when we had originally set the trial.
okay, so. One second. Miss Adams, what does Monday, September 29th look like in the morning? Or, I'm sorry, yeah, September 29th.
Judge, I'm not available that week.
Okay. Thank you. All right, I have Monday, October 6th.
That's no good. That whole section's no good for me, Your Honor. I'm sorry.
Guys are like divorce attorneys. I can never schedule them. Now, for the record, our Mondays are scheduled out like 4 months, and there'll be 40 cases scheduled on a Monday. So the best.
Yeah, I mean, do we have to start on Monday, Mr. Hartung?
We don't have to. You just said it that way before to get it through the 2 full weeks.
Right. So we're not available September 30th that week, right, Mr. Malaro?
Yeah, I'll be out of the office that week.
You're not available October 7th.
That whole middle chunk of October is bad for me. End of October, 1st November, would probably be better from my standpoint.
That's where I'm ending up. I'm sorry. So we're closed November 11th for Veterans Day. So we have a closure on that day. But if I go back to November 3rd, we would have, I could start a Monday trial date, but understanding we're closed for Veterans Day.
That's
So,
fine with us.
okay, so trial date starting November 3rd, November 3rd, hold on. Well, let's see here, November 3rd. No, because family law, no. When is Florence due? Oh, that would work. So 2 weeks starting November 3rd, Mr. Malaro?
Yeah, that's fine. That'd be perfect, actually.
Mr. Bernetto?
Yes, sir.
And Mr. Murphy?
Yes, that works for myself. Thank you, Your Honor.
All right, so the November 3rd of 25 at 9 AM. Obviously, our trials start at 9 AM. Except for Wednesdays, we start at 10:30 AM. I'm going to. Are you here October 24th, Mr. Hartung?
I'm sorry,
Are you in town October 24th?
I'm not all here by Zoom.
Well, I would like a day to sit down and do jury instructions with both of you, like have them submitted and then all of us sit down and finalize them before the trial. But I could do,
The 24th should be fine.
I could do Halloween, October
That's fine too.
31st. Mr. Malaro, you available October 31?
Yeah, says I am.
All right, so I'm gonna set pre-trial for October 31. It's a Friday. So that's not my typical time at 8 AM. And that'll be in person, so we can sit down and go through the already submitted jury instructions, because I'm going to require them to be submitted by October 24.
Your Honor, we already submitted ours quite some time ago,
Good,
and board year and witness list.
okay. Just in case there's any changes, I'll put another date on there. Because that'll give you both an opportunity to make any changes if you need to. And I'll make that the final motion date too. On that Friday morning,
Is that filed in Urge, Your Honor?
always, yep. Let's see, today is June 4, 5. All right, so I have a scheduling order trial again, November 3rd of 2025 at 9 AM. It's scheduled for 9 days, but obviously jury deliberations can go into the next week. Motion deadline filed and heard, and motion and limine deadline October 31. Obviously, you guys have had plenty of time. Any amended jury instructions or any jury instructions due October 24 of 25, as well as voir dire questions. There will be a final pre-trial conference in person on Friday, October 31 at 8 AM. Do you want Mr. Barry brought in person as well, Mr. Malaro?
For the final pretrial?
Yes, sir. I mean, you're
Sure,
gonna be
yeah,
in person. Okay, so I'll put that in twice in person, so maybe. All right, I have finished the scheduling order and we will get copies out to everybody. Is there anything else we need to address?
I have one thing. We don't have the witness list for the defense. It was scheduled to be delivered to us on February 12th. We had a bench conference in this court on February 11th. They said they had, at that time, they said they had their witness list prepared. They told us they would get it to us. They never have. On May 7th, I texted Mr. Malaro and said, I'd like to have your witness list so we can get our investigators to, interview anybody as necessary. And he said he would. Still haven't got it. It's been 28 days later now. Still don't have the witness list. It's kind of become a practice by the public defender's office not to give the prosecutors the witness list. And I don't understand why the courts continue to put up with that, because the court has issued an order. They have been required to do this. They don't follow these rules consistently as it relates to murder cases. I recall one recent case where I got the witness list 18 hours before the trial was set to start. And I guess the court felt that there was nothing they could do about it at that point in time. We don't want to risk an ineffective assistance of counsel argument, but we're all officers of the court here. And I think it's incumbent upon all of us to follow the court's rules. Thank you.
Deadline of June 20th.
Fine.
Mr. Malaro, you can provide that by June 20th.
Sure. But to respond,
right.
Judge, I think I deserve to respond to that.
You can.
Likewise, our office gets reports, witness lists, amended witness lists, right up to the moment of trial. I don't think there's the insinuation here I resent, and Mr. Hartung knows better. There was a competency evaluation. Until we knew what that was, there's no point in doing this extra work on this matter.
But
So
was
it
already
goes
done,
both,
Sam.
it goes both ways.
You told me you had it already done and prepared.
All right, thank you, gentlemen. We will see you back on October 31st for a final pretrial settlement conference. Thank you.
Thank you, Your Honor.
Ms. Demont,
Judge.
I have Ms. Winters. Let me take her real quick. All right, Ms. Winters, go ahead and start your video, please. Thank you. Go ahead and unmute your device, Ms. Winters. Thank you. This is in the matter of the people of the state of Michigan versus Jennifer LaShawn Winters, file number 25. I called the jail for your other one too, all right? Okay, so I have Mr. Coast. All right. Okay, so this is in the matter of the people of the state of Michigan versus Israel Vila Jr., file number 25-22210FH. I have Rhonda Underwood appearing on behalf of Mr. Vila. I have Isaac Sneed appearing today on behalf of Mr. Vila for Miss Arnold. And I did have a meeting with Miss Arnold as well as Miss Underwood at Miss Underwood's request. Yes.
No,
Yes.
it wasn't at my request.
I don't know, somebody's, oh, it's my request.
Thank
And
you.
so I didn't have an opportunity to meet with them. I have Darren Coast appearing on behalf of pretrial services. Mr. Coast, do you have anything to report from Mr. Vila?
Well, Judge, as part of his bond, he is supposed to do 2 times a week drug testing. He hasn't done any tests since March the 17th. I know he's been incarcerated for some time. The last 2 tests that he did was back in March 10th and also March 17th, and he was positive for THC only on both. So I did talk with Miss Arnold yesterday. I know there's talk about him being released possibly to inpatient. Miss Arnold is against that, just because of his record and history.
Did you assess him at any time?
I did not, Judge, because typically that's done for the arraignment, but I can do that.
Okay, thank you. All right, so Miss Underwood, I think the plea offer that I had for both of you, well, I want to address that on the
There's
record.
no, Your Honor,
Miss Underwood, I have a plea offer in my file. Is
Right.
there no plea offer?
that's the only plea offer.
So the plea offer was to plead to count 1, which is possession of methamphetamine with no drug sup and no supplements, correct?
Correct.
Okay, and then he's to plead in district court file number 25-0653FY. There would be a possession with intent to deliver with no sups and no drug sup, with a sentencing agreement of a Killebrew agreement between you and the people. Evidently, they offered a Killebrew to 51 months in the Michigan Department of Corrections concurrent. I'm just verifying for the record, Miss Underwood, if that was the plea offer that
That
was
is the
made.
plea offer.
And then Mr. Sneed, is that the plea offer that you show in your file?
Yes,
That's
Your
the
Honor.
one I wrote down. Okay, so the maximum penalty, were he to be convicted at trial, would be it's a third offense notice, so he'd be looking at a maximum penalty of up to 40 years in prison. But there's a drug sup, so that makes, yeah, so he could be facing a maximum penalty of up to 40 years in prison if he was convicted at trial. So, Miss Underwood, now you may proceed.
Okay, thank you, Your Honor. First of all, that plea offer has been relayed to Mr. Vila. He knows it backwards and forwards.
Yes.
Second of all, I would highly object to any change in the bond today, Your Honor, for one simple reason. Number one, first of all, the court was aware of this exact situation when Mr. Vila was last in court. There has been no significant change. None. Mr. Vila has been
Well,
incarcerated.
he's been incarcerated.
And so there has been no change since the last time Mr. Vila was in court and Ms. Arnold addressed these issues with him here. Second, Your Honor, I think we aren't asking for Mr. Vila to be out running the streets. No one's asking that. What the court, because there's a significant bond on the case downstairs, Your Honor. But what they are offering Mr. Vila, and the judge has already signed off on, is treatment where he goes, as I understand it, at 3 o'clock this afternoon.
So what's the offense date of the offense downstairs?
I'm sorry.
Was the offense downstairs committed while he was on bond on my file, Mr. Sneed?
Yeah,
So any sentence he gets on that one would stack on this one.
right.
So he could serve up to 10 years minimum in prison and also another prison term on top of that. Because he wouldn't get any credit. Okay. All right. So Ms. Underwood's correct. I mean, bond has never been addressed up here because he was in custody. So I didn't know he had a PR bond anyway. So his bond was set in district court on this file.
But you addressed bond when he was here the last time with Ms. Arna. We had a whole conference about it, and then we addressed it on the record.
Maybe, I don't know.
And the court didn't change the bond.
Okay. So,
Mr.
now.
Angelo, can I say something before, before
No,
you?
no, not yet. It's not your turn to talk yet. So when I became aware that he was to be released to treatment, I requested a meeting with Allison Arnold from the prosecutor's office and you both came in to talk to me about it because the jail was asking me for permission to release him. That's why I set up the hearing. So, Mr. Sneed, you've heard the statement from Ms. Underwood. What is the position? Like right now, he has a PR bond on my file, but evidently your office is objecting and wanting that bond changed, which is why we're here. So it's kind of a reverse bond hearing. Usually it's Ms. Underwood requesting bond. So, Mr. Sneed, what are the people's position?
Your Honor, the people would request that the cash bond, in this case, be set at $50,000, which is what the district court file is as well. I think the court's well aware of our petition or our position regarding drug treatment. It appears the defendant's only tested positive for marijuana when he was tested. So if he had an issue with a more serious substance, it stands to reason he would have tested positive for it. And I don't think people go to rehab for marijuana these days. So we just asked the court to set the $50,000 bond in this case. And again, we would restate our position that there should not be a condition for release to rehab.
Evidently, that is a condition obviously out of district court. I think that people opposed it in district court and the district court judge did, that's my notes, agree to release.
That's correct, Your Honor, and we would ask the court to reconsider that.
Ms. Teskey, do we have a history with Mr. Vila of him being sent to treatment and entering? I don't have audio, Ms. Teskey. For some reason, I can't hear you. No, you're unmuted.
Can you hear me?
Yeah, I can hear you.
Okay. Your Honor, he was sent to residential treatment in the past and did not follow through or go to treatment. He absconded at that time. He absconded several times, but when afforded the opportunity to go to treatment in the past, he would abscond.
Has he done that more than one time?
Yes.
More than 2 times?
Your Honor, as a quick look on his prior case, he violated on 3 different occasions.
Okay. Mr. Coast, did we ever try to put Mr. Vila in treatment through pretrial services?
I don't believe so, Judge.
Okay. Okay. All right. And what is this treatment program, Ms. Underwood?
I'm it's inpatient treatment. I'm sorry, I'm not cognizant of what it is, but here's what I would say, Your Honor. Mr. Vela has 40 years incentive to complete treatment.
But he's still not gonna get a jail term.
Mr. Vela, this bond, Your Honor, this issue has already been addressed. If Mr. Vela does not.
What day did we address it? Because I can look that up.
The
I don't,
last pretrial, Ms. Arnold got up here and gave you chapter and verse, and the bond was not changed. You didn't add a rehab provision, but you didn't change the bond. There's been no material change.
so
If
Ms.
Mr.
Underwood,
Vela
what,
does not comply and to the letter of the bond, I'm sure if he absconds, Ms. Arnold, I'm sure, will write the absconding charge in her sleep, Your Honor. And also the courthouse would not be deep enough for where there would be incentive to put Mr. Vela.
so Mr. Vila, at the very least, is facing 51 months in prison.
Right,
He's not facing a county jail term.
right.
So.
He has every incentive to get this right.
But it doesn't matter if he goes to rehab or not, because no matter what happens, it looks like he's going to prison.
Well, we don't know that, Your Honor. That the case downstairs hasn't even went to a preliminary.
On this file, even if he takes the plea offer, he's looking at prison.
Right, but that's on the file downstairs.
No, this file.
That's well, if you want to send him to prison on his tenure.
No, I don't, I'm not saying I want to. I'm saying if he gets convicted at trial, he's looking at 40 years. If he takes the plea offer,
What's the worst thing that happened?
if he.
If Mr. Vila gets sentenced
Miss
to
Underwood,
prison,
but if he
he goes
takes,
clean?
stop, if he takes the plea offer, he's looking at 51 months. There's no county jail term here for him.
Right, correct. But what I'm saying is allow him, while these cases are going to.
All right, here's what I'm gonna say, Mr. Sneed, or Mr. Coast, what does your morning look like?
Judge, I have just a few more cases with you, but other than that, I mean, I could go over there this morning.
Do you think you could assess him this morning?
Absolutely.
All right, so I'm gonna have him assessed this morning by Mr. Sneed, and then I'll follow up with you guys at 1:30 today.
Your Honor, he's already been.
I said, I'm having him assessed by Mr. Coast, and then I will follow up with you at 1:30. All right, Mr. Vila, we'll see you back at 1:30. Thank you. All right, let's see. And then I have Angel Rosas at the jail, so she'll be zooming in. In the matter of the people of the state of Michigan versus Emmanuel Simmons, file number 24-22052 FH and 24-220. This is a bond conditions, and he does have an attorney. All right. All right, Ms. Rosas, can you hear me?
Yes, ma'am.
All right, this is in the matter of the people of the state of Michigan versus Angel Rosas, file number 25-22142 FH and 25-22281 FH. I have two files. I have one that is set for arraignment today, and that is file number 25-22281 FH. Miss Underwood, do you waive the reading of the felony information?
We do, Your Honor.
Have you received a copy of the prosecutor's request for discovery, witness list?
Yes, Your
All
Honor.
the
We
other-
would acknowledge the receipt. I'll be right in.
Would you need, wait, you're fine. She's gonna want to talk to you. Let me turn on
I don't
my
believe
thing.
so.
Ma'am, we're
Okay.
good. We're all set.
Hold on. Okay. I mean, All right, so, do you waive the reading of the felony information, Ms. Underwood?
I'm sorry, we do, we acknowledge its receipt and the receipt of the witness list. And we
Okay,
would ask the court to enter a not guilty plea on Ms. Rosas' behalf.
okay. So the court will enter a not guilty plea on her behalf and her bond's continued. So with regard to the pretrial, Ms. Underwood, on file number 25-22142 FH, are you on that file as well, Mr. Banetto?
I am, Your Honor, yes.
How do you wish to proceed on that file?
Your Honor, I would present to the court a signed plea agreement by Ms. Rosas. And also, if the court, Ms. Rosas did file some certificates of completion, Your Honor, but I believe I can submit those prior to
That can go to probation. Yep.
And I have, as you can see, I have reviewed that document in person with Ms. Rosas since she could not read it on the Zoom the last time, Your Honor. I believe she's already also signed a advice of rights.
Okay, so we will get that advice of rights from her. All right, so the plea agreement, as I see, is that, okay, that she will plead guilty on file number 25-22142 FH to count 1 and count 5. She also has contempt of court and a bond violation.
Your Honor, on the contempt of court, Ms. Rosas will plead guilty to that.
Okay, that's a bond violation. Well, she failed to appear for pretrial on March 19.
Right.
That's a contempt of court. And then she has a bond violation because she was in contact with the alleged victim in this case, creating, and that's the felonious assault charge that's being dismissed, right?
The plea will be delivered to a HIDA, Your Honor, and also the matter. Oh, and there is a restitution to the count to the city of Adrian of $900 some, Your Honor.
So is she pleading to the bond violation?
Yes, Ms. Rosas will plead
Okay.
to the bond violation.
All right, so she's gonna plead to the contempt of court, plead to the bond violation, plead guilty to count 1 and count 5. The other charges will be dismissed. The new felony file number will also be dismissed. But she will admit to count 2 in that new file?
She will admit only for the purposes of restitution,
Okay,
Your Honor. And this is a HIDA plea, and there is also a restitution on that issue is to be determined at a hearing if he submits any. And the restitution to the count to the city of Adrian, I believe it's listed.
it's $986.37. Right? Okay. Okay, so is restitution still to be determined on the new file though?
Correct.
Okay,
Yes, Your
so
Honor.
Mr. Banetto, is that a correct recitation of all the pleas in this matter?
It is, Your Honor.
All right, so Ms. Rosas, you want to raise your right hand for me? The other right one, there you go.
Sorry.
It's okay. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, will you state your full name for the record, please?
Angel Marie Rosa.
Okay, good. All right, so you can put your hand down. Let me get rid of these other jail rooms real quick. All right, so Ms. Rosas, you have heard the statement of your attorney. Is it your intention to plead guilty on file number 25-22142 FH to count 1, malicious destruction of fire or police property, which carries a maximum penalty of up to 4 years in prison, and count 5, domestic violence, which carries a maximum penalty of up to 93 days in jail?
Yes, ma'am.
Okay, and there any? And there's no sentencing agreement in terms of what happens at sentencing, is that correct?
Hideout,
Correct,
Your
Your Honor.
Honor.
Other, but jail
Outside of
term, any,
I don't believe there would be, I'm gonna,
I'm asking if there's any agreement between you and the prosecutor as whether there be no upfront jail or anything like that. I don't see it.
I would hope that would be the case, Your Honor.
No, I'm asking if it's in the agreement. I don't see it in the agreement. So Mr. Bayonetto, there's no agreement as to whether or not there would be a jail term at the time of sentencing, correct?
Correct, Your Honor.
Okay, that's all I was asking because I don't see anything in there. But Ms. Rosas, do you understand if you're eligible, you could be sentenced under the Homes Youthful Training Act, which means basically you're grounded for the next 2 years and you have to do everything I say and honor all the probation terms and not get in trouble. And then these would never go on your permanent record. Do you understand that?
Yes, ma'am.
Okay. Are you satisfied with your attorney and the advice that she has given you?
Yes, ma'am.
And then do you understand on the new file for purposes of restitution, you would have to admit that there was destruction of some property in that file and that you're also pay restitution in that one as well. Do you understand that?
Yes, ma'am.
All right. Now, we talked about whether or not there'd be jail. There's no agreement regarding that, but the maximum penalty could be up to 4 years in prison. That's not going to happen, but do you understand that's the maximum penalty?
Yes, ma'am.
Okay. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
Is that correct, Mr. Bayonetto?
That's correct, Your Honor.
And Ms. Rosas, is that correct as far as you're aware?
Yes, ma'am.
All right, if a guilty plea is accepted, there will be no trial. Can you hear me? Are you having a hard time hearing me?
Yeah.
Okay, do you have a hard time hearing to begin with?
Yes, ma'am. But I can read your lips a little bit.
So I'm gonna ask you to knock on the door. We have closed captioning available and you just need to turn that on your device. So let's see if someone will come in.
I can't hear them.
Just. So do you know how to turn the closed captioning on? I'm going to tell you if you don't.
Well, I do not. If you could let me know.
Okay, go down to the bottom of the screen and you see those 3 dots that says more?
I do.
Is there an icon?
Oh, yep, I
for
see it.
caption? Okay.
All right, they're on.
Okay, excellent. Thank you. All right. So Ms. Rosas, you should start to see words streaming.
Yes, ma'am.
Okay, and you can read, correct?
Yes, ma'am.
Okay, excellent. So are you satisfied? So I'm going to start back a little bit just to make sure that you got everything. So you heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, malicious destruction of fire or police property, which could carry a maximum penalty of up to 4 years in prison, as well as count 5, domestic violence, which carries a maximum penalty of up to 93 days in jail? So is it your intention to plead to those 2 counts?
Yes, ma'am.
Now, on the other file, there's a malicious destruction of property, and you're going to admit that for purposes of restitution. Do you understand that?
Yes, ma'am.
And the restitution in this file is $936 on the file we're pleading to is $936 or $986.37 payable to the Adrian Police Department. Do you understand that?
Yes, ma'am.
And the restitution on the file that's being dismissed has not been determined yet. Do you understand that?
Yes, ma'am. Now, would I have
All
time
right.
to find like a job or something before I?
Oh, yeah, you'll have a couple years probation to pay that off, okay?
Okay.
And then the other agreement is that if you're eligible, which I assume you are, your attorney wouldn't have done this, You will, if you are sentenced under the Homes Youthful Training Act and you're eligible, that means for 2 years, I'll put restrictions in place, like a curfew and no alcohol, and you're basically be grounded for, 2 years. Do you understand that?
Yes, ma'am.
And then if you successfully complete that, these offenses will come off your record. Do you understand?
Yes, ma'am.
Okay, do you have any questions about what you're pleading to today?
No, ma'am, just a question if I'm getting out or not.
Well, we haven't gotten that far yet, so we'll address that. So are you satisfied with Ms. Underwood as your attorney and the advice that she's given you?
Yes, ma'am.
Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
And Mr. Bandetto?
Yes, Your Honor.
And how about you, Ms. Rosas? Is that correct as far as you're aware?
Yes, ma'am.
If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
Now, this is important because your attorney may be addressing bonds, so I want to make sure you understand this part of it. Do you understand that if your plea is accepted and you engage in any misconduct between now and sentencing, the court will not be bound by any sentencing agreement or evaluation, and you will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding or failing to appear for sentencing, violating your terms of conditions on bond, or the terms of any sentencing or plea agreement, or otherwise failing to comply with an order of the court pending sentence. So basically what that means is if you violate your bond conditions, then I'm free to sentence you however I want. You may not be eligible for HIDA. Do you understand that?
Yes, ma'am.
Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
All right. So, Ms. Rosas, how do you wish to plead to the charge that on January 3rd of 2025 in the city of Adrian in the county of Lenawee, that you did commit the offense under count 1, malicious destruction of fire or police property? Guilty or not guilty?
Guilty.
All right. And how do you wish to plead to the charge that on that same date and time and venue that you did commit the offense of domestic violence in count 5? Guilty or not guilty?
Not guilty.
Are you pleading guilty to domestic violence? You're pleading guilty to count
Oh,
1?
yeah, sorry.
Okay.
Yes, ma'am.
So how do you plead to count 5 domestic violence?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to these charges other than what we've talked about on the record?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Ms. Underwood
No, Your Honor.
and Mr. Bayonetto.
No, Your Honor.
All right, Ms. Rosas, has your attorney promised you any particular sentence or estimated what your sentence will be in terms of probation, fines and costs, or anything else?
No, ma'am.
Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Ms. Rosas, on January 3rd of 2025, we're in the city of Adrian in the county of Lenawee.
Yes, ma'am.
Okay, so at some point you came in contact with an Adrian police car, is that correct?
Yes, ma'am.
And did you destroy it or damage that Adrian police car?
Yes, ma'am.
What did you do?
I broke the handle bars off the doors. On both sides. And I don't remember what else, but I was kind of blacking out at the same time.
Okay. Are you satisfied, Mr. Bayonetto?
Yes, Your Honor.
All right, and then were you in the company of the Miguel Rivera?
Yes, ma'am.
And was it your boyfriend, a sibling? Who is he to you?
An ex-boyfriend.
Okay, and you also injured or damaged him as well?
Yes, ma'am.
What did you do to him?
We were fighting, but he didn't go to the hospital or anything like that. Only I
What
have.
did you do? Did you kick him, punch him, knee him?
I punched him, I choked him.
Okay, okay. Are you satisfied, Mr. Bayonetto?
Yes, Your Honor.
All right. Has the court complied with MCR 6.302 B, C, and D? Ms. Underwood?
It has, Your Honor.
Mr. Bayonetto?
It has, Your Honor.
Okay, so now I'm gonna pause and I'm gonna grab your other file. So Ms. Rose says you're obviously not pleading guilty on this file, but on May 9th of 25, we're in the city of Adrian in the county of Lenawee.
Yes, ma'am.
And did you destroy a cell phone, a fish tank, a fish, which belonged to Miguel Rivera?
Yes, ma'am.
Okay, you understand that you're gonna be responsible for restitution on that, and it will be somewhere, is it somewhere between 200 and 1,000, I'm assuming, Mr. Bayonetto?
I would guess, Your Honor, that would be the case.
Okay, all right. I accept the plea. It's been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. I am going to set sentencing for July 16 at 8:30 in the morning. Are you available that day?
That's fine.
Yes.
All right. So before we proceed any further, are you addressing bond?
Yes.
All right. So go ahead and address bond.
Your Honor, Ms. Rosas has been in jail since May 9th. Ms. Rosas understands at this point, and I think has come to the brutal reality that this is just a toxic relationship and they cannot be around each other. She knows that. The last thing she's gonna do is go back to Mr. Rivera. When he is not involved, Your Honor, Ms. Rosas is not a violent person. She's not. I think it's a domestic situation that goes both ways. It's toxic. Ms. Rosas has used her time in jail wisely. She's completed parenting while incarcerated, anger management, and houses of healing. I know Ms. Rosas is going to reach out to Catherine Cobb, Your Honor, at this point. I think she's got a hefty restitution to pay. I think it would only benefit everyone, including Ms. Rosas, to, while she's awaiting sentencing, to let her out, let her get a job, housing, and stabilize herself, Your Honor. Because as soon as
I did, Judge. On June 2nd, I did speak with her over at the jail. Did a pretrial assessment. She did score a 5 on the assessment, which puts her in the moderate range to be rearrested while out on bond or not appear for future court dates. She scored points to where she has the one failure to appear. She also wasn't working and doesn't have stable residence. The good thing is, though, she does lack a criminal history. And she does not have any substance abuse problems.
All right, so we have no substance abuse, no prior record. She doesn't have housing stability, but Catherine Cobb and other places are available, and we have other people out on bond at those facilities. So Mr. Bayonetto, obviously, if she fails to appear for sentencing, she could now have all her charges reinstated, plus another charge of absconding and end up in prison. So, Mr. Bayonetto, what are the people's position?
I have no position, Your Honor. I would defer to the court's discretion.
So, Ms. Rosas, I am going to give you a bond today, but I'm putting bond conditions in place. Do you understand?
Yes, ma'am.
If you don't follow them, I'll issue a bench warrant for you, and then your plea bargain will go away. So it's very important that you follow these bond conditions. Do you understand?
Yes, ma'am.
So I
Thank
am
you.
going to require you to report to Mr. Coast once a week. Okay, you're not to
Yes, ma'am.
use any illegal, not to use any illegal controlled substances or consume any alcohol, and not to commit any new crimes. Do you understand that?
Yes, ma'am.
There is a no contact with Miguel Rivera, so you are not to be on his block, in his neighborhood, where he works, nothing. I don't want you to even, if you see him, you run the other way. Do you understand?
Yes, ma'am.
All right, and Mr. Coast will make arrangements with you on how to do that. So, do you have any questions about that?
No, ma'am.
All right, and
Your Honor, should she report to?
hold on, I'm gonna get there. Let me do this. All right, Mr. Jones, I'm gonna put you in a breakout room with her today real quick, but do you want her to report to the courthouse today when she gets out?
Yeah, actually, Judge, I won't need to be in a breakout one. Just she needs to report
Okay.
to office upon release.
All right, so Ms. Rosas, I'm gonna release you from jail today on a PR bond with those bond conditions. When you
Yes,
get out
ma'am.
of the jail, you're gonna walk across the parking lot to the courthouse and you're gonna take the elevator up to the 3rd floor. We go
Yes,
to
ma'am.
lunch from like 12 to 1:30. So if you come over, just wait for us to reopen. Mr. Coast, you're gonna wanna see Darren Coast, who you just asked for at the clerk's office across the hall from the elevator. And then you're gonna walk down the hall to the probation department on the 3rd floor and get your information from them, okay?
Yes, ma'am.
I'm gonna set sentencing in person July 16 at 8:15 in the morning, just what?
Would that be July 18th?
Oh, well, I've been telling
Sorry.
everybody July 16 today, so we gotta fix that. Or maybe I haven't. So July 18 at 8:15 in the morning. Ms. Rose says I'll make it in person because you are not stable right now, so it'll be easier for you to come in person. When you
Yes,
meet
ma'am.
with the probation department, they're gonna give you a time to come back and talk with them. Make sure you come in and talk to them, all right?
Yes, ma'am. Thank
I'm
you.
gonna have Mr. Coase have you sign an advice of rights form for us too, that goes over the rights that we've just done. Do you have it? Oh, I already got it. Never mind. Make sure you see Mr. Coast and the probation department. When you meet with the probation department, be truthful about your background and the events that occurred. They'll prepare a report. I'll provide it to Miss Underwood. And about a week before sentencing, you go see Miss Underwood to review that, all right?
Yes, ma'am.
Your paperwork from the jail will have your sentencing date on it, so don't lose that paperwork, all right?
Yes, ma'am, I will.
All right, so you're gonna get out of jail, you're gonna come see Mr. Coast, you're gonna come see the probation department. and we'll see you back for sentencing on July 18 at 8:15 in the morning. Ms. Rosas, remember, don't get in trouble, okay?
Yes, ma'am. I won't.
All right.
I won't mess it
Thank
up
you
this
so-
time.
All right, thank you. Anything else,
Thank you.
Mr.? No. All right, I
Thank you,
do
Judge.
believe that does conclude our docket. I don't know where Mr. Goldstein is, so we'll adjourn that with his schedule.
He's in the district court. He's good.
Well, I'm done. So we'll just adjourn it. All right, that concludes our criminal docket for the morning. Thank you.
John, can I just ask,
Never mind, hold on. Chris Jones, don't go anywhere.
By doing this, it will give me a chance to be better than the thief that I always been, the sperm donor, or the drug addict that I always have been as well. By not completing this program, I know it's going to put me at a higher risk of not being always being looked at as a liar. And of course, to not see that I do want to change. Thank you for your time.
Anything else, Ms. Underwood, you want to add to that?
I don't believe so.
Mr. Sneed?
Well, I just want to point out that the circumstances have in fact changed. That circumstance being Mr. Coase has done the risk analysis, and now the court has that report in which to make a decision with respect to the conditional release. So thank you.
I would say that Your Honor, a risk analysis doesn't change Mr. Vila. It just puts on paper stuff we already knew.
What was the offense date?
It doesn't. Mr. Vila has been in jail. His circumstances haven't changed.
What is the offense date of the district court file? Mr. Sneed, are you able to verify the offense date of the district court file
I
that
am.
Judge Shadler calls?
April 1st, 2025.
So this is a hard one. And the reason it's difficult because if Mr. Vila were in front of me on a possession of methamphetamine that I knew for a fact he was going to get probation on, rehab would absolutely be a slam dunk for him because that would be an opportunity to get him clean and sober before sentencing and release him. We were here before and evidently there was some discussion on that because of the both valid sides making argument this morning. You know, it was a hard decision to make. I did request Mr. Coast and kindly he was able to go to the jail this morning. You know, Mr. Vila is always, you know, always appropriate in court for the most part. You know, he does have a history of not showing up. He has a history of not attending rehab. He has a history of walking out and, you know, at this point, he is facing a prison term, which unfortunately is an even bigger incentive for him not to show up. And, you know, I don't know what's going on with the district court file. Is that still set for probable cause? Like,
we're supposed to be a probable cause right now, Your Honor.
You got a probable cause right now? And what's he charged with? A delivery manufacturer?
Yes.
2 counts?
Right.
And so he's facing, what's the max penalty on that one?
40 years on each count, Your Honor.
Is that with a drug sup or a felony sup?
It's with a controlled substance sup.
Okay, but then how many prior sups does he have?
I don't.
It's still a third offense notice? Because
each one is 40 years, Your Honor.
okay. So, and that file stacks on this file because he was on bond at the time. So, you know, obviously Mr. Vila is showing maturity in his desire for treatment, but every time I've granted him the ability to go, he's not come back. And, you know, so at this point, I am going to change his bond to 25,000 cash surety. So, all right. Thank you.
25,000 cash security, Your Honor. Thank you.
Thank you. All right, thank you.
Judge.
See you downstairs.
Ms. Underwood, I would also give him any credit, even though he had the PR bond.
I'm sorry.
He had a PR bond on this file. I will give him credit going back.
Thank you.
You're welcome. All right, Mr. Sneed, thank you.
Thanks, Judge.
I'm gonna stop my live stream before we start the family law docket.
Every day in the USA, people find themselves in court.
Hopefully, that date works for Ms. Perrin. Otherwise, we will be scheduling it for one that works with everybody. All right, then we are adjourned. Thank you.
Thank you, Your Honor. I think that's all for me.
Mr. Feliski, do I have Miguel Morocho?
Yes, Your Honor, I just got off the phone with him. He is en route to the courthouse. He should be here in a few minutes. He is very sorry for his delay.
I'm not waiting.
Absolutely.
So what's his excuse?
I believe that he was just delayed by traffic.
And so you're able to speak with him where he understands you?
I was able to get on the phone with an interpreter.
Okay, because as you can tell, we have an interpreter. We can't see him, but we hear him because that's how he interprets better. He can't be late. I'm not going to wait.
Absolutely.
But do you have an update for me?
I do, Your Honor.
So then we'll go on the case and you're just going to have to update him with an interpreter. I do not have time to wait.
Yes, Your Honor.
We will go on the record in the matter 25 CM47 State of Wisconsin versus Miguel Morocho. The state appears through District Attorney Kevin Schmidt in person. We have Joel Feliski appearing in person. Mr. Morocho does not appear. He is apparently late. This matter was scheduled for 9:15. It is now 9:20. The court does not have the ability to wait. I have a full calendar. We do have an interpreter that the court is paying for per minute who is here by a telephone, as that is how he interprets better. So everybody is here except for Mr. Morocho. Mr. Feliski, off the record, you indicated that even though he is not here, you can provide the court with an update. What is the update in the case?
Thank you. Thank you, Your Honor. I have had some discussions with the DA's office regarding potential resolutions to this case. While we haven't come to a firm agreement, I believe that the matter is trending towards resolution. I have discussed as a potential resolution or as a potential road to resolution, Mr. Morocho enrolling in a diversion class with Dave Hatch, either with anger management or domestic violence or some combination thereof. I discussed this option with Mr. Morocho and he seemed amicable to that. I discussed this with Mr. Dave Hatch as well. He is not opposed despite the language barrier.
How will that happen with the language barrier?
Your Honor, I discussed this very briefly with Mr. Hatch. He was willing to work with me to figure out some sort of solution to that barrier.
And if there is a barrier and he's doing a diversion and that's part of the deal, you're sitting with Ms. Morocho during those classes and you will ensure that you have an interpreter that can fully interpret everything.
Yes, Your Honor.
All right.
I have to imagine there's probably just Spanish speaking classes he could do that Dave Hatch could find. That's what I assume. he would do.
He still needs, Mr. Hatch still needs an interpreter to interpret those things to Mr. Morocho. Mr. Hatch, to my knowledge, doesn't speak Spanish. So I don't care how the classes get done, if that's what it's going to do with the Spanish speaking class, but somebody has to be there with Mr. Hatch with an interpreter to ensure that there is not a language barrier. And I'm not going to put that on Mr. Hatch.
Absolutely, Your Honor. I would be more than happy to work with Mr. Hatch and on my own initiative to find an interpreter
All
to
right,
assist
thank
this
you.
process.
So please update Mr. Morocho and tell him how lucky he is. He didn't get a warrant today. He must be here on time. And on time does not mean at the exact time of the hearing. It means at least in my perspective, 5 minutes early. Whether or not you need him earlier, that's up to you. So let's get the matter scheduled for another return date. I'm not sure how long you're going to need to be able to do that. I have you coming back July 28th at 1:45. That should be enough time, July 28th at 1:45. Hopefully we'll have an update on where we are. If Mr. Morocho is able to get that class done prior to that date, probably better, because maybe we can resolve that and we don't have to get an interpreter for yet another hearing. All right, anything further?
Nothing further. Thank you, Your Honor.
Mr. Schmidt?
Not for me.
All right, then we are adjourned. Thank you, interpreter. You are released. Thank you.
Thank you very much, Your Honor. Have a good day.
You too. Mr. Wood, Glenn Wood. We will go on the record in the matters 24 CF 155, 20. We will go on the record in the matters 24 CF 91, 24 CF 109, State of Wisconsin versus Justin Starkey. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Starkey appearing in person in custody with counsel Glenn Keane. We're set today in this matter for the sentencing portion of these cases. Mr. Starkey pled guilty on March 7th, 2025 to two felony counts, one battery or threat to a law enforcement officer, and one count of, I believe it was felony prisoner throwing or expelling bodily substances, an I felony. The court ordered a pre-sentence investigation report. The court has received and reviewed the report. And in my review, even though I don't have as much detailed information as the counsels, the attorneys, I did not find anything that jumped out to me as being a material error or a fact that needs to be corrected. Mr. Schmidt, did you receive a copy of the PSI?
I did.
Any material facts or corrections to state on the record?
Not a correction per se, but he did get revoked in his Polk case and they just haven't done the sentencing yet.
All right. And do you know if that matter is currently scheduled for sentencing?
It was scheduled for sentencing yesterday, but Mr. Starkey didn't have an attorney. I didn't see when they pushed it out to.
All right.
Yeah, I can answer that. Scheduled for the 6th, and I work with the public defender because they'd appointed me, but I hadn't got the appointment, so I'll be representing them that as well.
Okay, excellent. Thank you. And we are in victims' rights compliance, correct?
Yes.
Ms. Bauer, Victims' Rights Coordinator, are we going to have any victim impact statements today?
Yes, Your Honor.
How many?
One.
Just one? Mr. Keene, did you receive a copy of that PSI report?
Yes, Your Honor, and I'm not noting any material errors either.
Okay, and did you go over that report with Mr. Starkey?
Yes, Your Honor.
Did you thoroughly go over it with him?
I had a limited time because we had a phone disconnection, but I went over the main points and the recommendations.
All right, and so you went over the bulk of the main information to ensure that he can review if there are any errors.
Yes, Your Honor.
Okay. We will begin with the victim impact statement. The victim may come forward, have a seat at the black bench. Victim may state their name if they wish, or simply the initials. Yes. And if you are going to read something, please make sure that you read it slow, you enunciate your words. The court reporter needs to take everything down accurately, okay?
My name is Jan Lodermeyer.
You can sit if you wish, or you can stand, whatever you prefer.
Last name is Lodermeier. Currently, I'm 911 dispatcher for Burnett County. First of all, I want to thank the court for giving me this opportunity. As a corrections and communications deputy for Burnett County, it was my job to keep inmates safe, secure, and hopefully healthy. When Justin Starkey was unresponsive in his cell the morning of 3/29/2024, sorry.
And that's okay. Take your time. You can take as much time as you need. We have the rest of the morning scheduled for this case. So if you need to stop, you need a break, you can take that time.
My partner and I at the time went into his cell to make sure he was okay, as he was unresponsive. I bent down to touch his shoulder. He didn't really respond. He started to respond. I thought he was going to sit up. He kicked me in my stomach. I went flying back into a cement wall and I fell to the cement floor. It's the last thing I ever expected from an inmate that was playing, in my mind, possible to attack myself and possibly my partner in the cell. As a result of that action that day, my life has changed drastically. There's things I can no longer do. Correction officer is one of them. As my surgeon is concerned that it could happen again. Maybe yes, maybe no, but after 15 months, the doctors tell me I'm as healed as I'm going to be, which means constant pain, constant numbness, and sometimes tingling down my legs. As for Mr. Starkey, my anger is never going to go away. I am not a vindictive person. But honestly, I hate that man for what he has done to me.
And I'm just going to say, I appreciate your emotion. This is not a time to.
I know. That's all I'm going to say. That's all I'm going to say about that. Okay. I am no longer a corrections communications officer, deputy. I am now a 911 communications deputy. My life now is to help people that appreciate what 911 communications deputies do. And that is to help the community and save the community when we can.
Thank you. All right, Mr. Schmidt, argument and sentencing recommendation, please.
Sure. I'm going to be arguing for what the PSI recommends, which is 2 years initial confinement. Let me just make sure I say it accurate. 2 years initial confinement, 3 years extended supervision on the battery, and 1 year jail consecutive to it on the other count. So effectively, the 1 year jail gets converted into a prison sentence by way of Wisconsin statute. Mr. Starkey has 338 days credit per the jail. This is a 35-year-old man with a traumatic brain injury that was inflicted on him when he was a baby. However, his criminal history only really began within the past 5 years. The implication there is that the criminal behavior cannot be solely attributed to the traumatic brain injury. He has been placed on probation 4 times and been revoked 4 times. He was on probation when some of the conduct at stake in these cases occurred. He is not a suitable candidate for probation. He gets disability, that's been confirmed, and at one point on information belief, I believe he was also getting civil payments from the result of how his traumatic brain injury was inflicted. I do not know if he still gets payments for that today. The core behavior of Mr. Starkey in most of these cases is him assaulting and harassing correctional officers. The assaults and harassment show patterns of deliberation and planning and intention. They were not reactive or in direct response to a frustrating stimulus, such as how people might react if they have a traumatic brain injury and fly off the handle. In 24 CF 91, Justin Starkey was apparently having a seizure when COs went in to address it. You heard an account from the victim in that jail already. As soon as COs were in range, Mr. Starkey shot up and assaulted them, in particular, the full force kick of JL that caused life-altering injuries. This happened March 29th, 2024. The PSI demonstrates a lot of additional information that the PSI writer acquired contacting other jails that Mr. Starkey was in both before this incident and after. And what the PSI writer discovered was that for over a year before this and sometimes afterwards, Mr. Starkey has been in other county jails and he has been doing the same behaviors. He has been faking seizures and medical issues to trick COs to try and come in and aid him. The jails have reacted in different ways. Eau Claire seemed to have figured out this and just wouldn't go in and expose their COs. They would see the fake seizures, document it, and then document Mr. Starkey's behaviors afterwards, which show he was clearly faking it. Sometimes his reactions have been violent to them not coming in and checking on him, say attacking the door or the cell. His assaultive behavior has also been directed at inmates in those jails. In 24 CF 248, COs came in to talk to Starkey to stop applying cleaning solution to the mirrors in the cells that they use to see in. They first tried to do it in a safe manner through the intercom. He wouldn't listen and kept doing it. The CO went in to talk with him. The CO's posture in the surveillance camera was very neutral. He was not approaching Starkey. He was just casually standing there talking. And then eventually Starkey got mad, assumed a charging posture and charged at the deputy. It was completely unprovoked. He wasn't even touching Mr. Starkey or approaching Mr. Starkey when he was attacked. 24 CF 109, Mr. Starkey urinated on the wall and floor of his toilet and used a Kool-Aid pack, like the powder solution, to put it on it so it would soak it up to make it clumpable so you could pick it up and it would be throwable, and threw it at a deputy, a correctional officer, I should say. Again, showing deliberation and planning and really an intent to humiliate, I would say. I specifically went through the facts in these jail cases because they show something you don't really see in some of his other cases, this planning deliberative element. Mr. Starkey is intentionally using, not just in these cases, but in the descriptions of these other jails, he's using the empathy of his COs, their desire to help him and to make sure he's not having medical issues to gain access and harm them. He's using positive traits and positive things they're doing against them. It's not just immoral in that sense. It creates a broader public risk to all of the other inmates that COs have to be thinking about and be cautious of other inmates who might be faking just to gain access to harm them. It also shows this more malicious element, because this wasn't a one-off in the JL case of the faking the seizure. We see from the Eau Claire logs this has been something he's been doing an extremely long period of time. It's a repeated plan that he keeps trying to do and presumably will keep doing in the future. I say that I presume he's going to keep doing it in the future because of how Mr. Starkey talked to the PSI writer about the correctional officer cases versus the case with his mother. The Eau Claire conviction mentioned in there is the one where he assaulted his mother in his home. So that's different than the CO ones. That was a public assault more akin to the first Burnett County case, the DC in public. And those two cases are more of the getting frustrated and attacking somebody cases. The way he talks about the case with his mother, it's because it's his mother, he says he's sorry. He says something to the PSI writer that when he's asked about whether he feels bad or sorry about what happened, he says just about his mother. He, even at the point when he was talking to the PSI writer, wasn't empathizing with any of these COs, not just the victims in our case, but really the Eau Claire ones, the other county jails where he's done this, the county jail where the CO is coming in with the medical cart, with the medicine that he needed, and he attacked them when they did it. So what am I highlighting? So I've already indicated we have to start first with considering probation. The statute requires that it should be rejected out of hand because of the failures on probation, because two of his recent convictions involved assaults in public in the community, the DC in Burnett, the Eau Claire incident with his mother. The fact he's a danger in the jail to correctional officers itself is also indicative. He can't be treated in the community. That's indicative he needs a higher level of confinement. And that would be the Wisconsin state prison system. They have much better resources. They can have a better documented file and establish easier to use protocols than the county jails he's bouncing to and forth from Polk to Burnett to Eau Claire, and better establish a protocol where Mr. Starkey cannot harm officers, correctional officers. So that brings us to McCleary. Gravity offense, protection of the public, rehabilitative needs of the offender. The gravity of the offense is severe because of the maliciousness of what's happening here, and because of the pattern that can be traced back into 2023 and also forward a bit as well, of really just wanting to attack these jailers. If you look at what is the intent, what is the impetus of why he's doing this, it's not, these are not contacts where the COs are initiating contact with him. He's initiating contact with them by faking medical issues or deliberately doing something he's told not to do. He's seeking provocation. He's seeking physical contact. And as a result, he's harming COs. He's humiliating them. He's caused an injury to one CO that has prevented her from being a CO. That Mr. Starkey has robbed from the county somebody who's extremely talented and experienced in that role forever. We can still keep her in another role, but losing her as a correctional officer is a huge blow to our county. We're constantly trying to recruit new correctional officers because that's a hard position to get people and find people who can do it. And Mr. Starkey exacerbates a real public problem. And that's indicative of a higher gravity offense and also the nature of the injury. We need to be able to protect our correctional officers. And I think that through the gravity of the offense, through McCleary is the way we address that. Because there are not special rules for the police or for correctional officers where people can swear at them or be mean to them or throw urine at them or assault them, and they can't for the public. The COs and the deputies are also the public because they're also people, and they deserve the same respect. And they deserve the same respect for their personhood and their bodily autonomy as anybody else. Protection of the public is odd here because, like I said, most people don't think of correctional officers or police officers as the public, but they are in the sense of how that term is used. when you have an individual who's incarcerated, the public, the seeking the correction, also the dangerous hierarchy. In case to our jail again with him in public and threatening a woman who again was just trying to help him. With the failures on probation, with him assaulting people in public, trying to help him, with him assaulting correctional officers who really just, their main goal is to have a neutral, safe environment for all the inmates and themselves to keep everybody happy. They're not going in there and picking fights. And his disruption of peace, both in the community and the jail, indicates a strong need to protect the public that I think prison is necessary. That brings me to rehabilitative needs of this offender. Mr. Starkey, I think we see a pattern over the past 5 years where he's growing increasingly antisocial and malicious in both his behavior and his thought processes. This can't be traced to his TBI from 1991 because he doesn't have this criminal history going back to 1991. It happened in the past 5 years. They're a result of him and his choices and his behavior. We really see in the PSI, in his statements, a profound lack of empathy for people he doesn't already have a personal stake in. That's why he feels bad about his mother, but nobody else, not the woman helping him at the hotel, none of the correctional officers he's ever assaulted or thrown urine at, of which there's no justifiable reason. They demonstrate an increasingly selfish view that Mr. Starkey has, where if someone makes him angry or he feels he's not being respected, he says to the PSI writer, he's justified in what he does. That's highly concerning because it shows a lack of respect for others, a lack of respect for bodily autonomy, which is really one of the cornerstones of modern society. If his empathy is non-existent to this extent, if he's this selfish in his worldview, if his locus of control is so internalized, what that means is we have to rely on punishment to deter his behavior. There's no other choice because the decision to change isn't going to come organically from Mr. Starkey. He's been continually assaultive for years now in these jails. So it has to come from fear of punishment. It has to come from deterrence. If we don't address punishment through the criminal justice system in that manner, my big concern with the implications of how Mr. Starkey talks about his TBI and his ADHD is he's going to come to the conclusion that so long as he ties things back to that or medical issues and he doesn't get punished, then it's going to reinforce the behavior. If he's able to use those diagnoses as an out to avoid punishment, then he's being told, you can still do that because of your condition. And I take specific umbrage at that in particular, because there's a lot of people out there with TBIs, with ADHD, and other conditions. These don't apply to Starkey in particular, like schizophrenia or bipolar, conditions that can cause a person to behave erratically or become violent or aggressive. And a lot of these people, most of these people, don't get assaultive. They don't have criminal histories. They aren't attacking people in jails. They're not even in jails because they're still capable of having free will. They can still make the choice to, hey, I want to better myself. I want to get along in society. I want to treat my condition. I want to be responsible. They're not playing up their injuries. They're not playing up their illnesses. They're being responsible members of society. And there's no reason Mr. Starkey can't either. Prior to 5 years ago, that's what he was. I asked the court not to reinforce that behavior. I asked the court to do a prison sentence to deter it. I think based off of the sheer volume of people hurt, the consistent pattern of behavior before and after these assaults, the nature of one of the read-ins being in the community, and the past conviction in Eau Claire not that long ago, also being with his mother in the community, I don't see how it's possible to supervise and treat Mr. Starkey safely in the community. We've seen through the facts of the case themselves, he can't be safely treated or rehabilitated or deterred in the jails. So the next step has to be prison. I'd ask the court to follow the PSI recommendation. Thank you.
Thank you. Mr. Schmidt, before I move on to the defense, one of your focuses was rehabilitation. Punishment was an aspect as well, but rehabilitation, where the court should look at that. And the fact that in this last 5-year history, that your argument stated that Mr. Starkey, excuse me if I'm not saying it as eloquently as you did, but Mr. Starkey was not availing himself to the rehabilitative services. What would you recommend as in at least conditions for rehabilitative needs?
That's the rub of it, because like I said, I don't think the 5-year behavior can be attributed to the traumatic brain injury. There has to be something else going on, which means I think he needs a mental health professional to assess him and work something out and potentially even get some sort of medical paradigm going, if a sedative. That's why I think the Wisconsin State Prison System is better, because they have a better medical system.
All right. Mr. Keen.
Well, Your Honor, first, acknowledge Dispatcher Lodemeyer's statement. It's powerful and sad, and no matter what you decide today, unfortunately, we can't go back to that time. Mr. Starkey can't go back to it and undo it. And I'm sure that, I presume the deputy dispatcher appreciates the support by many members of the local law enforcement, because in a department the size of Burnett County, that's a fair share of the number of officers who could be on the street. So now moving to a little to the fact of the matter here, but I wanted to acknowledge that first. Not going to deny that it's a serious offense. Dispatcher Lodemeyer has had a change in her career. I read her statement talking about losing her ability to golf. And to say that isn't a severe and a lifetime consequence would be, trying to make a mockery of things today. And I am not going to do that. And I certainly don't agree with the idea that, yes, law enforcement is by nature a dangerous job, because law enforcement officers are called to deal with people when things are at their worst. And in a correctional setting, the correctional deputies are there for people who have either been convicted or being charged with criminal acts in the community that often involve violence and or substance abuse and mental health issues. That said, I would never try and say that's like a mitigating factor because, well, that's part of their job, because, if we believe that, then trying to find anyone to be a correctional officer if they don't feel support is going to be harder than it already is. But the question you have, and the one I thought of, and the one the DA has thought of, is what should happen to Mr. Starkey from here on out. And if you look at his record from 2021, February 2021, so we're looking at a little over a 4-year period. We're looking at a time in Mr. Starkey's life where he's been, kicked out of his home, homeless for part of it, wandering around, in jail most of that time. The last time he was out of jail, I represented him on the probation revocation hearing where he got out. You know, he was put in a hotel for a couple days. And unfortunately for him, you know, trying to get assistance and getting back to housing because he'd been in custody so long, it was hard to do. And he wasn't able to avail himself of Burnett County's ADRC service because prior to incarceration, his last residence was another county and he'd have to apply there. So I'm not going to argue for straight probation either, because I don't think that the court would treat that seriously. My issue is that, because I've seen this here, you know, with the DA's recommendation and in Sawyer County, one of the issues we have is we have mental health care issues. I'm not talking just about TBI, because the DA's point out that for just TBI, you'd have a longer history or it wouldn't happen at all. But there's certainly some mental health issues that Mr. Starkey's been facing, and something obviously has increased them. But over the past several years, I mean, he had several competency reports because 3 different attorneys, 3 different counties thought something was up. And the competency barrier is fairly low. You know, it's just whether he understands the charges. And then, you know, if you're looking at, you know, mental defect or illness, you know, the standard for that is a fairly tough road to meet. He's in between, I would say. Not in between those, but in between a regular functioning person and someone whose mental illnesses are such that a mental defect defense would be in order. If you look at what's happened over the past 4 years, the vast majority of time he's been in jail. When he's been out, he hasn't really had much for services or time. And, you know, his relationship with his mother was, you know, damaged obviously for the Eau Claire case, and she chose not to participate in this hearing. So the state's effort here is to suggest that prison is the place where you can get services. And I think we're sort of doing correction officers, along with Mr. Starkey, a disservice, because we're trying to move along mental health services. You're using prison as a place to provide services that are probably more appropriate in other locations. Because if you didn't have some of these charges, I mean, you know, there'd probably be civil commitments and other items that would also be appropriate. Because there you have, you know, behavioral control issues. And then although he did not express remorse it appeared to express remorse in the PSI, he has expressed it other times when talking to officers. He's expressed that in court. He's expressed that in other situations. So I don't think characterizing him as a remorseless man is there. But, you know, Mr. Starkey's a man whose mood changes, because it's not about being cooperative some days, not so cooperative other days. You know, your impression of him probably depends on whether you see him on a good day or a bad day. So I think when you look at the rehabilitative needs, I don't think that a prison sentence is necessarily going to accomplish that, because Mr. Starkey has been in jail for most of the past 4 years, bouncing back and forth. And then when he's out on the streets, he's, you know, hasn't had a lot of the services. The PSI said that he hadn't had really much for mental health care in the past 4 years. So the question is how to deal with it. And I think one way to deal with it would be to, in 24 CF 109, I would suggest a sentence of time served, which according to the DA was 338 days, be appropriate instead of the 1 year in jail. And that in 24 CF 91, I would suggest a consecutive sentence with probation and a period of confinement as a condition of probation of 60 to 90 days from today for a specific purpose. So that probation can identify places for Mr. Starkey to receive, get some evaluations, mental health evaluations, whether he needs a inpatient stay at a mental health facility or some other resource, to allow time for that to happen. And because again, the thing that's startling to me is when I look at it, I mean, other than the harm to Deputy Lodemeyer, which I'm not going to at any point minimize, because that's the worst consequence of the case, because, regardless of what you decide, Mr. Starkey will presumably get out of jail or prison. But unfortunately for Deputy Lodemeyer, that's, lifetime consequences. But in terms of Mr. Starkey, like the last time he got out, he was on a street hotel for a few days. There's times he's bounced out. He has, 2023, he's kicked out of his residence. He's a man who, before he started getting in jail, had been getting services through Inclusa, and he'd had a representative payee and other things. And I think if we pursue prison at this stage, we're just setting him up, okay, go to prison. And then when you come back out, you're the same person. Mr. Starkey's, through the conduct, through the, there were four competency reports sought, and 3 different attorneys had some of the same questions. Mr. Starkey's talked about someone taking his word finds and a lot of other things that indicate some potential, and someone frauding his name and committing crimes. So there are mental health issues that frankly, I don't believe have been diagnosed, because Mr. Starkey has been in county jails for most of the past 4 years. And I think when you're dealing with rehabilitative needs, the way to get rehabilitative needs for someone with mental health issues is to get them diagnosed, because we don't know what medications may be appropriate, because Mr. Starkey's access to mental health in the past 4 years has been spotty at best and limited to what is offered in county jails. And another thing with the conditional jail is that during that time, the county, if they believe that that if probation is not able to, work on getting Mr. Starkey some inpatient treatment or intensive outpatient, whatever mental health provider recommends, because that's certainly not my role, then that would allow the county to file for a potential civil commitment so that Mr. Starkey could get mental help one way or another. Because somebody shows potential danger to the community, versus just going straight to we're going to use prison to warehouse him for a period of time, and then hope that when he gets out, he's close, he may be close to the same boat. Mr. Starkey does have some tools. He's qualified because he did qualify for SSI. He had a representative payee. He does need some time to get those services set back up, because since he's been in custody for so long, he, you have to start from scratch on applications. And I think the better way to focus on the rehabilitative needs and the protection of the community is to get focus on a program that gets Mr. Starkey mental health in the shorter order than, go to prison, go to classification, because they recommend 2 years. So, I mean, you're looking at almost half a year before civil services. And we know that the prisons aren't a panacea either, because the prisons talk about shortages in services, staffing for mental health, staffing for their own safety. So in essence, we're the DA's recommendation transfers the burden to the prison system, which, useful for Burnett County, but doesn't really do anything more in terms of rehabilitative needs than the proposal we would suggest is, to recommend that time served in 24 CF 109, which is the 338 days, 24 CF 91, consecutive, 3 years of probation with, I'd say 60 and 90 days of conditional jail to allow for probation to try and figure out, if there are services they can get them into through Department of Corrections, whether it's a halfway house or some other supervised environment. And if the needs are more severe, then the county could, through Corporation Council, consider, a mental health evaluation or hold versus just hoping that we make the problem go away by prison. Now, regarding protection of the community, and I will include the jail staff and I'll include the correctional officers in the Wisconsin State Prison System, focusing on the mental health treatment to deal with whatever Mr. Starkey's issues may be that go beyond TBI would probably do more to protect the community than just, go to prison for a few years and hope that they can provide you resources you haven't been provided in the past 4 years. Because Mr. Starkey is, like I said, he hasn't had them for the past 4 years, a supervised placement with mental health services would probably do more to protect the community than just make him the problem of the Wisconsin State prison system. So with that in mind, like I said, I'm not suggesting a pure probation. Suggested the 24 CF 109. I think our argument would be treat that as, use that for the time he spent in jail. And then in 24 CF 91, I'd say 60 and 90 days of conditional jail, and that's consecutive. So to the 24 CF 109 with 3 years probation to allow time to coordinate some mental health services and between probation and potentially the county, decide if that, how Mr. Starkey can get some of those services that he needs rather than just trying to turn the jail and prison system into the mental health providers. Thank you.
Thank you. Mr. Starkey, I'm now going to go to you and ask if there's anything that you would like to share with the court. And you can fill the court in with anything that you think that was missing with either attorney's arguments or anything that you think was missing from this PSI packet, anything that you think that you may have forgotten or didn't recall to tell that PSI author, or anything with regards to any remorse or any other thing with any of these cases. But you don't have to provide a statement today, but you do have that opportunity. Is there anything that you would like to say? And you can take as much time as you need or would like.
Could I
You can talk
talk
to your
to
attorney
him
too.
first?
Yeah, you sure can.
Yes. So, like, if you're talking, so your mental health issues you've been having. Because I really not the thing I focus on. I focus on what's going on in your life. It's constant. Decline since one. There are times you remember express your remorse to jails. Suggest that versus just okay. Okay.
All right, Mr. Starkey.
With the officer that I kicked, I'm very sorry that I did that. I didn't mean to do it. Right after I did that, when I got put in one of those single pods, I actually cried really hard. And I feel really horrible for that. When I cried really hard, I was looking up and I poured my whole bottle of soap all over myself. Still with my clothes on. Because I did that to a woman officer. I did not mean to do that, so I'm sorry if she is still here. And with any of my mom's cases, I've already said sorry to her. So that's pretty much it.
Right. Thank you, Mr. Starkey. And Mr. Starkey, if I am going over anything when I say anything here in my decision and you don't quite understand it and you need to talk to your attorney, you can just let him know, tap him on the shoulder, and we will stop so that I can make sure that you fully understand everything, okay?
Okay.
Now, we're here today for the sentencing portion of this case. And in preparing for this, you had to speak with a Department of Corrections officer to prepare that report, the PSI report right here. And so you provided a whole lot of information to the author of this report, as well as giving a whole lot of information to your attorney so he can better understand you and the cases and where you were and where you are here today. Now, in sentencing an individual, a person in front of the court has to look at certain factors. I have to look at first the nature and the gravity of the offense. How serious is this case and the other matters related that may have been dismissed and read in, those other cases that you may not have been convicted of any charges, but they are a part of this matter. The court also has to look at the defendant, your character, your past criminal record, and your needs for rehabilitation, if there are any services that could better help you or help you fit into the community and not be a danger or a risk. The court also has to look at needing to protect the public. And here the court looks at protecting the public as a whole, the entire public, and in particular, other groups of the public that may have been impacted by your behavior, by your conduct here. And in this particular case, it would be not only this case, but the other corresponding cases and other cases that you've been convicted of that the court reviews would be those jail-related cases with the correctional officers or other law enforcement officers. The court also has to look at the effect of the victims involved in the cases and hear their statements and how it impacted them. The court also has to look at any what's called undesirable behavior patterns. If there is a pattern which can come out of the cases and out of the facts, and if it's undesirable, if it shows any negative traits or negative characteristics. I also have to look at culpability, meaning your ability or your making these decisions and your guilt, if there was any intent, deliberation, planning, maliciousness, those types of things. I look at your education and your history, which would include that TBI, that traumatic brain injury, and any other mental health conditions that may have already been diagnosed, as well as the other medical conditions such as your ADHD. I have to look at deterrence, and deterrence means to try and stop others from doing something. And that would be the general deterrence, stop other people from committing similar crimes or crimes of this nature, and specific deterrence, meaning to deter you, to try and stop you from committing these types of crimes in the future. And the court also needs to first look at probation. And Mr. Schmidt, the district attorney, went over that in his argument, that I am directed by my higher courts to first look at probation unless confinement is necessary to protect the public from further criminal activity from you, the defendant, unless you need correctional treatment because any types of treatments or other services outside of the correctional institution has not yet been successful or been sought after, or if probation would unduly depreciate the seriousness of the offense, of the crimes here. When I'm looking at this case, I look at the matter of all of the charges in all of these cases together. And you had multiple cases. I believe there were 4 cases that were in front of this court that you were engaging in litigation. All right. And in looking at these cases and in adding the maximum possible penalty, if you were to go to trial on each of those cases, and if you were convicted on each of those charges in those cases, the maximum possible penalty that you would face would be, it would be a total of 20 years and 9 months of initial confinement. That means initially serving within the confines of a prison and or jail cell, and 20 years of what's called extended supervision. That would be similar to what people think of as probation or parole or something like that. In Wisconsin, we call that extended supervision after release from prison. So 20 years and 9 months of initial confinement with 20 years of extended supervision. That's a lot of time. So a total of over 40 years of a prison sentence with some jail mixed in, because there were, I believe, 3 A misdemeanors and 1 B misdemeanor. The rest were felonies. Through negotiation and discussion and plea talks with your attorney in the state, and in reaching this global agreement, that agreement lowered the amount of potential incarceration and extended supervision. And in the case, the maximum possible penalty that you would face with this agreement would be 4.5 years of initial confinement with 5 years of extended supervision. So there was an extended substantial benefit for you in reaching this global plea agreement. And so you did receive a really good deal in reaching this agreement. The primary dispute here today is I need to determine if this is a prison case today, because I have the state arguing for immediate prison, and I have the Department of Corrections making a recommendation for prison. And I believe the state and the Department of Corrections are on the same path, the same avenue with regards to their recommendations, or whether or not this is a case, as your attorney argued, for probation with some conditional jail. And so in looking at those 2 things, because they're so vastly different, the court will need to look at those rehabilitative needs. And quite honestly, the most serious here, this is a serious offense, everybody acknowledges that, but the protection of the public. And what can the court do to try and ensure the protection of the public? I can't guarantee protection of the public, but I can try and ensure to the best of the sentence's ability for public protection. So that is where the court is looking at here. Now, I did review very thoroughly your pre-sentence investigation report. And as argued by the district attorney, your criminal career, your criminal charges and convictions are not very lengthy with regards to your history. Just in the past 5 years or so. You are 34 years old, so that would mean they started around when you were 29 years old. And what happened at that time, the court is unsure, and I'm not even sure if your attorney is aware, or even if you are aware of what may have happened or why you have may have went down this other path. Because from the time you suffered the TBI, and that is indicated from 1991, when you were approximately 6 months old, you had that head injury. And from the time that you were a baby until the time you were 29, although you were suffering from some disabilities and suffering from some mental incapacities, you were still able to perform and to be conforming to the public and what a law-abiding citizen should be. You were not engaging in any criminal activities. But then approximately 5 years ago is when it started, and it seems to have derailed because we have multiple cases with multiple convictions, with multiple victims. And if you look at the cases, I don't believe you're necessarily selective at your victims. I believe it's victims of opportunity. And it would not matter because it looks like you have individuals that you know, individuals that you don't know, people that you may be close with, like your mother, or people who may have authority over you or have the ability to enforce authority to you. If you look at the facts of the cases in front of the court today, and if the court does review your criminal history and those convictions, the court feels that the state is making a very strong argument. The facts play out as the state has argued, that in your conduct and your behavior that harms and hurts individuals, it has been deliberate, it has been planned, there is intent to do harm or intent to be in a position where you could cause harm. And it is apparent with some of these victims being individuals who, as the state has said, has shown empathy to you, has tried to ensure that you are not in harm's way, that you are not injured, that you are not at risk. And when they come and assist you, you hurt them. And it's essentially as a lying in wait, as a tiger waiting and watching its prey and then attacks. And it causes serious injury to individuals. I believe in the Eau Claire case, I think that it was alleged that you had maybe broken your mother's wrist. In this matter, you have kicked the correctional officer so hard with such force that she was thrown across the room and hit the concrete wall and suffered extensive injuries, where she is now in a form of disability herself and cannot return to a job she loved. And now she is in another position she likes and is doing and is helping people, but that is not the career that she had wished to be a part of. And so you're not only taking away people's health and people's physical health, people's mental health, but you're taking away livelihood as well. Their ability to not only provide for themselves financially, but to feel fulfillment in what they may have been doing as a career. And that's where it becomes a little bit more aggravated when you see the gravity of the offenses, the gravity of the actions, the severity of the actions, and the fact that they are so malicious and deliberate and have so much intent. And there is a pattern that this is what you do. Again, a tiger lying in wait for its prey. So there is that undesirable behavior pattern. And it puts the public at a severe risk. And the issue here is not only the public as a whole, the public in general, because lay people, other people who are not connected to this judicial justice world, are at a higher disadvantage than the officers or the correctional officers that you engage with, because they're not aware of how dangerous you could be or the threat of harm that you cause. But when we're looking at having you in a confined setting and we're looking at the public as the correctional officers or law enforcement officers, they're aware or potentially aware of the fact that you are a danger, you are a risk, but they can't be removed. They're in that position. That's their job. Their job is to ensure that everyone incarcerated is well taken care of and that they are not a danger to the other jail community. Because it seems like in these cases from 5 years ago until present, they continue to escalate. They continue to escalate in harm, in actions, and in damage caused. And with each passing year, with each passing case, without having the punishment to deter, you become more of a ticking time bomb where you're waiting to just go off and explode on a poor individual who may or may not be aware of the risk. And then you cause serious, sometimes irreparable damage. And I've heard your statement, and I hear that you have remorse for the injury of the correctional officer. And I'm glad to hear that today. In reading the PSI report and your statements to the author, those statements from you were more so like you feel you are the victim. You feel you are the one who is being damaged and controlled because you're in custody. You don't believe you're being treated fairly. You don't believe you're being treated the same as other individuals. And I'm going to say, if you're not being treated as the same as other individuals, it's because of your aggressiveness, your violence, your danger, that the officers need to be in a higher alert. They need to protect more. They need to ensure that you have more restrictions and control so you don't explode and cause damage. In cases where a court sentences, I have to look at the least amount of incarceration to accomplish the goals of the sentence and to ensure that there will be compliance. And so I have to look at the minimum amount of jail time or incarceration to protect the public while looking at the gravity of the offense and the rehabilitative needs. The court also, in some cases, looks at punishment. And punishment is a factor, especially when we have this progressive history of increased aggravated actions and conduct towards helpless, sometimes helpless individuals or clueless individuals, and even towards, as I stated, the correctional officers who may be aware of or should be aware of the extent of your violence. The court can't get around the fact that you are an extreme safety risk. And the number one goal here is to protect the public. I need to protect the public, and I need to do so in the minimum amount of time, which would be consistent with those factors and the needs of the defendant. I do recognize and understand that there are rehabilitative needs and that there could be other mental illnesses or disorders, as your attorney is arguing and stating, and the fact that there should be a mental health evaluation because there could be a need or a potential need for medical treatment. So the court addresses the rehabilitative prospects and will do that with the conditions of either probation or extended supervision to ensure that that can be addressed. The court wasn't aware to the full extent, at least until the argument of the state, that it's not just the jail in Burnett County, it was the jail in the other counties where you are housed, that they knew or were aware of the potential violent propensities, that you could be a weapon, a dangerous weapon. And so if the court were to place you on probation and have individuals who are not protected with tasers, that are not protected with weapons, that are not protected with other things, it would unduly depreciate the seriousness of these offenses and this aggravated, and they continue to cause more and more harm to the victims. Incarceration in prison is the only sentence that the court finds to be appropriate. Because again, it would not only unduly depreciate the seriousness of all of the offenses, the court would not be in a position to protect the public if you were not confined. And the fact that correctional institutions can provide you with treatment and or services before you are released. Your attorney made a statement that everybody would be, if you're sent to prison, that everybody would be just hoping the problem would go away. No one's hoping that. No one believes that that is even a possibility. That is not the purpose of prison. The purpose of prison is punishment, and the purpose of prison is to ensure that the public is protected for that ability, or protected for that amount of time to a high ability for the time that the defendant is incarcerated. That's the goal of prison. Rehabilitation is a goal of prison, but it's not hoping the problems go away or hoping that the defendant gets quote unquote fixed or cured. That doesn't happen. A person can change, a person can make changes in their lives, and they can do so while in prison, but that has to be a conscious choice. The person has to be making the steps while in prison to do that, and doing the classes in prison to make sure that that can occur. With each of the charges, the court is only going to assess $250, the DNA surcharge, You have $500 posted, and that will go towards the surcharges. I'm waiving the rest of the court costs and fees. Your ability to pay is very little. You're on SSDI, but you would need to reapply once you are out of custody and out of incarceration. So I'm waiving the rest of the court costs and fees and only doing the mandatory DNA surcharges. With regards to 24 CF 91, which is battery or threat to a law enforcement officer, a class H felony. The court believes that that is a very serious offense, and it caused serious injury and an impact on the victim. And the court needs to not only deter you specifically from engaging in this type of conduct and behavior while incarcerated at any point in your life, if ever again, and also has to generally deter the public from this behavior, because correctional officers are doing their job. They should not have to worry whether or not they're going to be maimed, whether or not they're going to be disabled, whether or not they're going to break a bone, or whether or not they may not come home at night on their jobs. And people who are incarcerated need to understand that they must follow the rules, and they must not engage in this type of conduct or behavior, or there will be punishment. With regards to that count in that case, the court is going to sentence you to 3 years of initial incarceration and 3 years of extended supervision. With regards to 24 CF 109, which is throwing or expelling bodily fluid or substances, a class I felony, the court is going to sentence you to 1.5 years of initial confinement and 2 years of extended supervision. They will be consecutive to each other and consecutive factors. Conditions on extended supervision: absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. A mental health evaluation, which would include the MMPI-3 test and or any other similar evaluative test as your agent would deem appropriate and to your comprehensive level. The court will order that you have a psychiatric evaluation and exam, and if prescribed medications, you take them as prescribed. You follow all recommendations of both of those evaluations. I said absolute sobriety. No contact with Burnett County Government Center unless it has court-related matters or you have other county business. No contact with the victims or their residences or their employment. Your no contact will be able to be reviewed at any probation review hearing upon request of yourself through your agent. You are a resident of Polk County. You've always been a resident of Polk County, or for the most part, and not a resident of Burnett County. So this should not impede your ability to travel. You were to have no contact with Burnett County except traveling through. If you need to get to other medical appointments, your probation appointments, those types of things, unless there is approval from the court. And again, that can be received through a request and a probation or extended supervision review hearing. You have 338 days of jail credit that the court will provide to you to use towards your sentence. As to your mother, I don't have to provide that no contact. That is something for the Eau Claire matter and her desire to have contact with you. The court is also going to order that you engage in some type of mental health or therapeutic class or course as it relates to self-control and self-regulation. The court believes that this sentence is not only necessary, but it's imperative to assure the public is protected because you continue to be risky and violent and engage in escalating criminal behavior and contact with victims. And the court is concerned that the next contact you would have could cause more serious damage than disability. It could cause death. The court is ordering your DNA. You must provide that to the jail. You are not eligible for the challenge incarceration program. You are not eligible for the substance abuse program. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that covers everything, Mr. Schmidt.
There's one thing we need to cover yet. At the plea hearing, the defendant stipulated to restitution. The restitution was $1,500 to the victim JL and what workers' compensation had paid for a certain period of time, which totaled $8,866.91. In between the plea hearing and the sentencing hearing, the workers' comp paid out more money or approved more claims to be paid. So the insurance company updated the restitution claim and submitted that. So the new total is $24,956.09. I would inquire of the defendant if he stipulates that new claim or if there needs to be a restitution hearing for the difference between.
Mr. Keen.
I think a restitution here would probably be in order.
Well, I'm going to order, how much was directly owed to victim in this case? 1,500?
1,500 is directly to victim. At the plea hearing, they already stipulated to $8,866.91.
Well, I'm only going to order what's stipulated to the $8,861.91. He has no ability to pay now while he's incarcerated. Plus, when he's released, even if he were to apply for SSDI, he would only receive about $900 a month in what I'm getting from the packet. And it's workers' comp. It's not the direct victim. So the court is going to grant the stipulated amount in $8,866.91.
With that in mind.
Because I believe that would be your argument, inability to pay.
Yeah. Yes, you are.
Anything further
No.
from you, Mr. Keen?
No, you are.
All right, then we are adjourned. Thank
Every day in the USA, people find themselves in court.
We did receive discovery.
All right. All right, so for those of you who remain in the case, I look forward to seeing you either at some other conference or at trial. And thank you all. I love the word settlement, consent, agree. Those are beautiful.
Thank you. Judge. You have a good one.
Your Honor.
Take care. All right, it is Jessica Wilson versus Jamario Terrell and State Farm Mutual.
Your Honor.
Go
Good
ahead.
morning, Your Honor. Abigail Moody for the plaintiff, Jessica Wilson, and we are
on schedule for a summary judgment hearing this morning.
All right. I see that the defendant is listed as pro se on my calendar. But is there anyone here for the defendant?
Your Honor, Ryan Brightman here for State Farm. The named defendant has not made an appearance as far as I'm aware.
Okay. All right. So this is the motion for summary judgment.
Yes, and so we'll be ready to proceed on that. I would anticipate 5 minutes.
All right, no problem. All right, let me go ahead and run through the rest of the calendar. Lisa Matthews versus Cerberus SFT Holdings, First Key Homes, Georgia, First Key Homes of Georgia, LLC. Then there's a second First Key Homes of Georgia, and then for FHK SFR, Proco. Ooh, that's a lot. All right, anybody here for any of those entities?
Jordan Mahoney here, present on behalf of the defendants.
All right.
We have a motion for summary
You're
judgment.
covering all of those people, all of those
Correct.
corporate people. Okay,
That's right.
thank you. That makes it easier. All right. And anyone here on behalf of the plaintiff? Okay. All right. So what I have, yes, Deputy Whitson, thank you. All right. All right. So let's begin with Wilson versus Terrell. No, I'm sorry, Green versus Johnson. Sorry, Wilson versus Terrell. I was right.
Thank you. I'm Abigail Moody for the plaintiff. It's defense's motion for summary judgment. So do you want them to go first?
Yeah.
Yeah.
Okay.
All right. Good morning, Your Honor. Ryan Brightman here for State Farm. I think this is a relatively straightforward question. Really, just one issue is in default. In dispute. There's no real factual questions as pertinent to our motion. State Farm is moving for summary judgment on the single question, single issue, an argument that there is no coverage for this loss under the plaintiff's uninsured motorist coverage. This accident is a single vehicle accident that involved a horse that belonged to Jamario Terrell. Apparently, Mr. Terrell's horse became loose at some point, some way, and Miss Wilson vehicle struck the horse. As you alluded to earlier when Your Honor was calling the calendar, Mr. Terrell has not answered or made an appearance on his own behalf, but we're here just to arguing that as a matter of law, State Farm is entitled to judgment because a horse is not an uninsured motor vehicle.
Could have said it, but I wanted to hear you say it.
Yeah. So, and I'm not trying to make light of any situation.
No, I get it.
Yeah. But
because I was going to ask if this was part of a homeowner's insurance policy that I'm not aware of, or because it's that doesn't support. But yeah, so they're bringing it on behalf of the person owning the horse as a vehicle.
So yeah, Miss Wilson has served State Farm as her uninsured motorist carrier. So yes, it's a pretty straightforward question, I think. And so a few different places that we can look for a definition of an uninsured motor vehicle. First, we'd look to the statute. The uninsured motor vehicle statute tells us what an uninsured motor vehicle is, but it doesn't define motor vehicle. For a definition of motor vehicle, we could look to the liability statute, which is OCGA 3334-2, and that defines motor vehicle in the liability context as a vehicle having more than 3 load-bearing wheels of a kind required to be registered under the laws of this state relating to motor vehicles designed primarily for operation upon public streets, roads, and highways and driven by power other than muscular power. And it talks about trailers and low-speed vehicles. Now, there is case law that has, and we cited in our brief, and as did Miss Moody, that has held that the definition of motor vehicle that I just read you is broadened in the uninsured motorist context. For example, the more than three load-bearing wheels. The court has suggested in the case of Hinton versus Interstate Guarantee Insurance Company, and that's cited in our brief. The court in Hinton suggested that, for example, a motorcycle only has two wheels, but could be an uninsured motor vehicle under the UM statute. The case in Hinton actually involved a tractor that was towing a trailer on the public highway. And so a tractor, of course, would not fall under a motor vehicle required to hold liability insurance as a regular car. But in that context, the Supreme Court held that that tractor did fall within the definition under the statute and Georgia law of an uninsured motor vehicle. So as far as that's the statutory and case law authority that we have from Georgia about what an uninsured motor vehicle is and what a motor vehicle is. There is the case of, pardon me, Georgia Farm Bureau Insurance versus Claxton, where the Court of Appeals was faced with a factual scenario after a parade. A couple of gentlemen were driving their mule-drawn carriage, and the Court of Appeals there found that the mule-drawn carriage was not an uninsured motor vehicle. And the only other case I could find on point with involving animals is another case would be Persuasive Authority from Kentucky that found also a horse-drawn carriage, whether it's a mule or a horse, was not an uninsured motor vehicle. I understand. Yeah.
May I ask, there was only the horse, there was no structure attached to the horse, no vehicle, no trailer or anything, horse wasn't pulling anything?
So in the case of the Farm Bureau case, the Court of Appeal,
in the present.
In our case, no, Your Honor, it's just the horse. Okay. No trailer, no other structure attached to the horse. So yes, in the Court of Appeals case involving the trailer, part of the argument was about whether the carriage qualified as a trailer. But there was no such issue in our case. So I understand that the plaintiff in response argues that the UM statute is remedial in nature. The courts have held that it's to be interpreted in a way to protect the public. However, I'd argue that there still has to be, the words still have to have a meaning. The commentator Jenkins and Miller, they have referred to coverage as insurance against lack of insurance. So even
that's the broadest interpretation of it.
Right. So here there's no law that would require it might have been a good idea. And who knows, we haven't been able to speak with Mr. Terrell to see if he had a homeowners or umbrella policy that might cover him. But there's no legal requirement that people hold liability insurance on their horses. So this isn't a situation where the coverage is essentially insurance against lack of insurance.
All right, the closest, I guess, scenario that I could figure that happens commonly is if someone's car gets hit by a deer.
Yeah. Yeah.
Like, they come out of nowhere, it's an animal, they're definitely not insured, but there have been no cases where someone can claim from their policy coverage for that type of scenario, is there?
No. So, and that's what I didn't want to, again, make light of the situation, but
not making light.
It does, you wonder if we go down, if we accept that a horse in this case is a motor vehicle, then, is a deer, is a cow, is a goat, is a dog, is a cat, is a squirrel, if somebody just sees the squirrel in the road and swerves into a tree, is that that squirrel an uninsured motor vehicle at that point? So in the response, the plaintiffs argue again for the remedial nature and protection of the public for the UM statute. They argue that the horse was could be used like a vehicle. Mr. Terrell apparently may have ridden his horse to a restaurant that evening and tied it up. Not well, apparently, but tied it up. So the language that the plaintiffs focus on in Hinton is that an uninsured motor vehicle, an uninsured motor vehicle is a motor vehicle that is not designed primarily for use on the public roads and are not required to have liability insurance, but which at the time of the accident are being operated on the public roads like a vehicle designed primarily for that purpose. So even if we go with that definition from Hinton and accept the remedial purpose, the entire reason that there was an accident here is because the horse was not being operated, at the time of the accident. That's the part of the Hinton language that the plaintiff leaves out or doesn't recognize in their argument. So for those reasons, we would ask the court to find, as a matter of law and a matter of contract, that State Farm does not owe coverage to Ms. Wilson for this loss and issue judgment in State Farm's favor. Also included, I did not go into the policy language definitions, but the policy language definitions as well, I'm sure Your Honor can imagine, do not include animals and horses in the definition of cars or motor vehicles or uninsured motor vehicles. And all that has been included and attached as a certified copy of the policy to the brief.
All right, Ms. Moody?
Yes, Your Honor, thank you. So as the defense counsel said, this accident was back in February of 2024. And my client is basically traveling along a public road, Anvil Block Road. And what happens is a saddled up horse comes out and hits her car. She tries to avoid it. And as defense counsel also pointed out, we don't know a ton about the circumstances. We know from the accident report, and then the defendant is in default. And so, of course, the allegations in the complaint are considered true. But what we have gathered is the defendant rode this horse up to a place called Aquatic Blue, which is a restaurant bar, from what I can tell, tied the horse up outside. And then at some point, we don't know when, the horse gets loose and comes into the roadway. Pretty extensive damage here. The vehicle, I don't know if I can share my screen, but
You may.
Let's see if I can see it. How do I do this? Let's see. Sorry, Your Honor, I'm trying. Let's see. This is what her car looks like, just so you can have an idea. You got that? Okay. And so yeah, it's a pretty extensive damage. And it's about $63,000 in bills. She has dental work, she has glass, all that stuff. And so what happens is, of course, the defendant doesn't answer, and we've been able to find no other insurance for this. And so now UM is, in our case, what we consider up. And so State Farm's basically saying that the horse is not an uninsured motor vehicle, and therefore no coverage. And as counsel stated, the two arguments that they're using is, one, livestock are not uninsured motor vehicles under Georgia law, and second, basically the policy language. And so before I go into why I think he's wrong, I would first state, the summary judgment standard, which is that when the facts are viewed in light most favorable to the non-moving party, which is us, plaintiff Jessica Wilson, there must be no issue of genuine issue of material fact, and the fact must support judgment as a matter of law. And here I think that there is at least an issue. Now, what that issue is, but it has to be no issue to grant summary judgment.
Ms. Moody, if you can't articulate an issue, then how am I to assume that one exists? So here's where I am. The reason I asked about the deer And the reason I asked about structures attached to the vehicle, to the horse, is if you're telling me he's pulling a trailer or a wagon, then I can say, okay, it might not be motorized, but it is a vehicle. So that may be something that a jury, and I'm willing to take my chances with the appellate court. Not that I'm scared of them or anything, but you know, at that point, it's worth it. But at this point, I've asked if there was a structure attached to the horse, no structure attached. So I've asked about a deer, like if a deer comes out, it's not owned by anyone. If it hits your car, it can do the same amount of damage to personal and property to personal injury, but there's no way to sue a UM carrier for that.
Yes, Your Honor. And so what I would argue in defense of this, what I would articulate is this. So first of all, the UM, as I said, is supposed to be remedial in nature, right? And in that case of Hinton that he's talking about, there's two prongs that they get. They said there's at least two prongs that have to be included as what is a motor vehicle. And the court clearly says at least two. So they don't say exactly what those are, right? But the second prong, which is the one that, you know, I keep on harping on, is the one that says that motor vehicles have to be included, motor vehicles that are not designed primarily for use on public roads and are not required to have liability insurance. And then, which at the time of the accident are being operated on public roads like a vehicle designed primarily for that purpose.
Which I would assume would be a dirt bike or an ATV.
Well, so I would say operated for that purpose. Okay. So when we say that someone took the vehicle, took the horse, saddled it up and took it just as you would a vehicle to a public place to have dinner, that is using it as a vehicle. I also have one other thing to show you, Your Honor, from the, if I can try to share it again, if you see, hang on, I'm sorry, I'm trying to do it. Share screen. Why is it not going? Let me see, I'm sorry. Here we go. This is where Your Honor, this is where the aquatic blue is. And this is somewhere around Boulder Crest is what we have the address for the defendant. We don't know how he got there, but clearly to get there, you have to cross some sort of a public roadway. So is it being operated in a public roadway? Yes. I mean, I would argue that yes, there's at least a genuine issue that it could be considered a vehicle in this. It's literally a vehicle transporting him into the lounge. So, I mean, that's how it's being operated. It's different than a random deer coming out, because a deer isn't that's just a random deer that's coming out into roadway, or cow. This is something that is being used as a transportation in this case. Like the horse was taken as a vehicle to take the person as a car would to this restaurant. And so I would say that, you know, that can fall, there's at least an issue that falls within the second prong. And then I would say in that Hinton case, again, the court articulates that at least those two categories. So even if you didn't think that matters, the court says at least. So I would say, again, that there's a genuine issue there. And then for the contractual part of it, I think that the contractual part is not as clear as Mr. Brightman makes it sound. It's clear that the uninsured motor vehicle in the policy, which we have as well, is defined as a land motor vehicle. But that term in the policy is not articulated. So hang on one second. So what is articulated in the contract is the term car, which is in one place. It's on page 4 of that policy, where it talks about the 4 or more wheels. And what Mr. Brightman wants you to do is use the term car in the term of basically transport that into the uninsured motorist definition, but that isn't there. In the uninsured motorist definition, which is, I can share that as well. The uninsured motorist definition, there's no place that it says car. And so I would argue to you that if they meant 4 or more wheels needed, then they should have used the term car. In this uninsured motor vehicle coverage, the term car is used in different parts of this language and the property damage and the insured definition, but it is not used when it says uninsured motor vehicle. We only have land motor vehicle. And so because it does not have the term car, and yet car is articulated elsewhere in the contract, I would argue that there is some ambiguity there. And any ambiguity in a contract, of course, is strictly to be construed against the drafter, which is State Farm. So I would argue again, and that there's a genuine issue of material fact there. It's not enough to grant summary judgment and read my argument. And so for both the horse under Georgia policy and law and under the contract, I would argue that there's a genuine issue and that I would ask the court to deny summary judgment.
I did notice that you're staying away from the word motor.
Your Honor, motor, we talk about like horsepower as motor, and I understand I understand. I can't argue to you that there's a motor on a horse. I mean, obviously I can't argue that. But what I can say is that, it's being used as a vehicle in the sense.
Your Honor, if I could just very, very briefly respond. I think we've covered most of the issues, but just in response, as far as land motor vehicle is the term used in the UM section of the policy. I think there's no ambiguity. The words have to have meaning. If it's not defined, you look to its plain meaning. A motor vehicle is a vehicle with a motor. Whether it has 4 or more wheels, 1 wheel, whether you 2 wheels, something with wheels and a motor. Lastly, to the point about the Hinton language, and the Hinton language says that it's being operated at the time of the accident. If this were a case where Mr. Terrell were riding his horse from his ranch to the restaurant to the bar and got in an accident, I still don't think it would be a motor vehicle, but we'd be closer to the Hinton definition than we are here. That's very different. It was not being used as a vehicle at the time of the accident.
All right. We will look more carefully at all of these definitions and give you an order.
Okay.
Thank you, Your Honor.
Thank you, Your Honor. May we be excused?
Yes.
All right. Thank you. Bye.
All right. The dispossessory Unvi Turner. Is everybody ready on that?
Yes, Your Honor.
Has not made an appearance as far as I'm aware.
Okay. All right. So this is the motion for summary judgment.
Yes, and so we'll be ready to proceed on that. I would anticipate 5 minutes.
All right, no problem. All right, let me go ahead and run through the rest of the calendar. Lisa Matthews versus Cerberus SFT Holdings, First Key Homes, Georgia, First Key Homes of Georgia, LLC. Then there's a second First Key Homes of Georgia, and then for FHK SFR, Proco. Ooh, that's a lot. All right, anybody here for any of those entities?
Jordan Mahoney here, present on behalf of the defendants.
All right.
We have a motion for summary
You're
judgment.
covering all of those people, all of those
Correct.
corporate people. Okay.
That's right.
That makes it easier. All right. And anyone here on behalf of the plaintiff? Okay. All right. So what I have is that the case was dismissed recently. Did you not get?
Oh, sorry. Go ahead, Judge. I didn't mean
No,
to
I
cut
was
you
going to ask you, had you not gotten that information, Mr. Mahoney?
off. I had not gotten that information. I haven't had a dismissal come through on my end.
Okay, Ms. Powell, I have that it was dismissed with prejudice on May 31st. Have you seen the actual document, the actual dismissal?
Pulling that up now, Judge. I will send it over to you once my CPU 8 comes back together.
No problem. All right, yeah. So Mr. Mahoney, that's what you're looking for. If you want to check the, and this is Matthews versus Cerberus et al., right?
That is correct.
2021 CV 00549. So my note says it was dismissed, but I'm not infallible. So we'll look it up and make sure and determine whether that's actually, because I can't imagine that they wouldn't have sent you like an email or a phone call or a text that said, hey, we're not doing this anymore.
Thanks, Your Honor.
I do have, and I'm pulling up the actual document now. Again, things are running slower than I'd like, but I do reflect in the system that on 5/31, the case was dismissed without prejudice.
With or without prejudice?
Without prejudice.
All right.
Okay, and the document has just loaded, and it does say that appears now the plaintiff and directs the clerk of this court to mark the above civil action dismissed without prejudice against the defendants herein named, and to enter same upon the docket of the court. So everyone's good to go.
All right, let's make Mr. Mahoney's life a little easier and shoot him a copy if you can. Do you have his
Yes.
email?
Would you mind just dropping it in the chat to me, Mr. Mahoney?
Sure. And that's much appreciated, Your Honor.
No problem. All right, Jashin Un versus Avis Turner.
Good morning, Your Honor. Daniel Moore on behalf of the plaintiff, Jashin Un.
Okay.
This is a dispossessory matter. And as they're not here, we ask to strike the answer and ask for judgment. We have also moved for judgment on the pleadings, but I don't know if we need to go into that.
Send us an email or file something saying that he wants a bench trial versus a jury trial, or he wants to maintain his jury trial.
Okay, yes, ma'am. Thank you.
All right. And Mr. Hudson, please be mindful that whatever the next step is, you'll be getting notice from the court, okay?
Okay, thank you.
All right, thank you.
Thank you.
Your Honor, excuse me. May I speak? Jordan Mahoney, counsel for defendants on that Matthews versus Cerberus case
Yes.
et al.
Yes.
So we spoke earlier when you called our case, and it appeared that plaintiff attempted to voluntarily dismiss the action, but that's not allowable anymore under OCGA section 91141. Voluntary dismissals now must be done with the consent of both parties. Or they must be done within 60 days of the opposing party filing the answer.
Right,
so,
and how far outside the 60 days is it?
I can tell you when our answer was filed, Judge, 1 second. All right.
All right, while you do that, let me.
Sorry. Go ahead, Judge.
I was just gonna, because I'm in the middle of the 11 o'clock calendar. I have, I think, 2 more cases to do.
My apologies, Judge. Our answer was filed January 10th, 2023.
Mm-hmm.
And so what I was going to say,
so that
Judge,
was 5/31. That would make the dismissal outside the new rules.
Right. We answered on behalf of all defendants on that date in 2023. So
oh, I'm sorry, 2023. Yeah.
That's right, Judge. All I was going to say is that
well, now for cases that were filed before the
pending cases, Judge.
I'm sorry.
Sorry, I didn't mean to cut you off, Judge. I apologize.
No,
I was going to say it's for pending cases.
For pending cases. Okay, so it doesn't matter when it was filed, because we're all learning this. These are new rules for me too. So
yes, Judge. And I double checked. It says effective April 21st, 2025. I can actually screen share what I'm seeing right here from West Code of Georgia Annotated. I'm using Westlaw to look at it. Okay, I'm using Westlaw.
I got a whole video that they sent us about it. I think it's a PowerPoint or something. So yeah, they just came. I think they're probably not even aware. Do this for me. Call them Because sometimes they're not aware. And
Yes, I believe they're probably not.
yeah, I think they may have thought that because their case was pending before, because I think that's a misconception about the new rules, is that if your case was pending before the rule became effective, that it won't be affected, but that may be their issue. So just give them a call and let's see if we can do this old school lawyering style and figure it out. And if you all need to come before me for something, then I'm more than happy, even for a conference if you want.
Right. I was going to propose that I guess we could because we do want to the motion decided. So
Yeah,
I was going to
that's
propose that
fine.
we do like a proposed order.
Yeah, I'll
But
put you back on the calendar now that I'm clear. But yeah, I can put you back on the calendar, but call them and let them know that this is outside the limits of the new statute.
right.
And
And I was
they
going to send like an
may,
email copying
yeah,
him saying that we appeared for the hearing on this date and they apparently filed a involuntary dismissal that may not be authorized anymore under the new
yeah,
statute.
yeah.
And we would go from there.
Because I think them filing without prejudice means that they intend to awaken this case, and they may not be able to if they, under the new rules with the way they've done it. So, all right, just keep in touch with Ms. Powell if you all need to be put back on the calendar. Otherwise, we'll look at the case based on what's been filed.
Excellent, Judge.
All right.
Are we, and one more request, are we permitted to submit a proposed order?
Certainly. We love proposed orders.
Will do. Thanks, Judge.
We may not
May I
use
be
them, but we like them.
May I be excused, Judge?
You may. Thank you.
Thank you so much.
All right. So, Mr. Austin, thank you for your patience. When I think an issue is going to be a little bit meaty, I'll hold it for a second so I can figure it out. All right. So this is Kamara and Jola. Is that correct? Versus Doe Turner and Atlanta Realtors LLC.
Yeah.
Okay, this motion was withdrawn and excused. All right. Fazito Chancey versus Cedric Hudson and Property Rental Company.
Good morning, Your Honor. Josh Samuels for the plaintiff.
Good morning. And I thought I saw a Cedric Hudson.
Yes, ma'am, I'm here.
All right, Mr. Hudson, is anyone representing your property rental company?
I have no clue.
They're separate defendants, Judge. That's his landlord.
Okay, all right.
But they are also in default and no one's appeared for them.
Okay, no problem. And next is Devontae June Taylor, Denise Tuckenberry versus Michael Corday McKinney.
Good morning, Your Honor.
Good morning.
We're both here.
All right, anyone here on behalf of Mr. McKinney?
No, he never answered.
All right.
Just emailing it to me and I'll chat you my email.
Yes, that'll work.
Thank you.
All right. All right, Chancey versus Hudson.
Yes, Your Honor. This is a dog bite tort claim, and this is a discovery motion to strike Mr. Hudson's answer. I don't want to rehash the brief because I think we kind of go through the timeline on that already. But essentially, it's no responses to written discovery, 3 depositions missed. Well, sorry, excuse me. 2 were attended, but both had objections to providing any information to us. The 3rd one was missed after we obtained an order from you ordering Mr. Hudson to deposition. It's a 2022 case. It's been pending for almost 3 years now. There's no insurance. The landlord's defaulted. And so we think the only sanction that cures the prejudice here and allows us to move forward with a damages hearing is to strike the answer. Otherwise, the other sanctions available, like awarding attorney's fees and things like that, Mr. Hudson's probably not going to be able to pay those, and they're not going to put us in the position that we would have been in if the discovery was had. So I know it's a harsh sanction. I know that he is pro se, and that's why we're not asking for fees in addition to striking the answer. But when you exercise your right to represent yourself, you're treated to the same standards that attorneys are. And if it were my client that did all of this, that, you know, as we laid out in the brief, I don't think you'd have a problem dismissing our case for want of prosecution. So that's why we're asking for that sanction.
All right. So, Mr. Hudson, you understand what Mr. Samuels is asking me to do?
No, ma'am.
Okay, let me explain it. So this is the issue with representing yourself, especially in a civil context, because it is very, very technical. But when a civil case is filed against you, and you have you answer that case, that means you're putting yourself into the litigation, which means that they have an obligation. That this means you will exchange information, and there are rules to it. But they get to send you questions, they get to send you statements that you have to verify, they get to have depositions where they ask you questions regarding anything that could lead to information that might be relevant and produced at trial. And so all of those things, they have that responsibility and you have that responsibility. My understanding is that they have tried to engage in discovery with you and you have been what is essentially non-responsive. They've set up depositions and you've refused to answer or provide relevant or information that might lead to information that is necessary for trial. And so with that being said, I can't treat pro se litigants any differently than I treat people who are trained in the rules of procedure, evidence, who are attorneys essentially. So if you put yourself at a disadvantage when you don't have an attorney, and I know attorneys are expensive, but what we do, we as attorneys, is we understand the rules. And so we know how to guide you by the rules. And my mom's an attorney and she says a lot of her clients say to her, well, it's just talking. I mean, I know how to talk, but do you know how to say the right words? Do you know?
Well, see, I really never understood when he was calling for the dispositions. I never really understood what disposition was. I never went through it, never had to deal with it. I thought once I sent the copy of the video to the courts, because he was asking for a copy of the video, well, I turned it over to the courts. It's at the courthouse. I don't have a copy of the video. The video is literally, when I answered to their question, I figured once I answered their question and answered it with the video, that the courts would give him the video. I didn't know that I had to provide him a copy of the video, but the video is at the courthouse in the file.
Unfortunately, Mr. Hudson, that's not how it works. So we're the courts are the neutral party. We stay out of it as much as possible. I hear as little as possible until you all come to me for either a motions hearing or a trial. And so all of the responsibility for the litigation of a lawsuit is between the parties. So Mr. Samuel says he's done his part, but you failed to do your part. And he's asking me now to change your posture in the litigation. He's asking me to remove your answer and put you in a default. And if I put you in a default position, that means you have not answered. There's no dispute. Mr. Samuels will win by default. His client wins by default, and he will ask me for a judgment. All he'll have to do is prove the damages for the judgment. Now, you still have the opportunity to weigh in on the damages phase. If I were to do that, you could say that I've paid this or I challenge this as with respect to damages. But essentially, if I remove your answer, he wins the case. I don't mind explaining as much as I can, but the problem when you represent yourself is you don't understand things like the responsibility to participate in discovery, what a deposition means and what it requires of you, what it means to turn over discovery to the other side. So the courts, you don't have to, you can file discovery with us, but the most important part is exchanging discovery, sending it to the other party, them sending you what you asked for.
Okay. Well, I explained to him that I didn't have it. I explained to him that it was at the courts. When we went in the first deposition, I explained to him that I didn't have a copy of the film. It was at the court. I don't know how to go back up there and get it from him. What do I go ask him for it back and then send it to him? But I don't know how to go up there and get it. I turned it in when I turned it in with the answer. I figured once I answered and gave them a copy of the film that was me answering him and giving him what he needed. And I understand you're telling me now that it don't work like that. I do understand that now. But that's how I figured that was my answer was answered, because if had I known it, I would have kept the video for myself, and then I would have been able to present it had I known that's how it goes. But I didn't know it, and I understand that you're explaining it to me now. But when he was asking me questions, I was thinking like he was just, I don't know, just trying to build a case, really, honestly. So that's why I refrained from giving him any of the information, because I felt he was trying to build a case. It was like being attacked. So that's what really kept me from even talking to him, period, at all. But it is, like I said, it is a video on file that's showing where the Chancey did whatever he did. I'm not saying that the dog did not bite him, but I'm saying that he was aggressive towards the dog. That's what shows on the video, that he was aggressive towards the dog, and that's what made the dog attack him. So I figured once I sent that into the courts, and one say this case was dismissed in another court. It had been dismissed, but I understand.
Mr. Samuels, do you have the video that he's talking about?
I don't, and I'm concerned that if it's been spoliated, even if unintentionally, that's really going to prejudice my client's case at this point. It's direct evidence of what happened that day.
Okay, I'm not sure where he said he brought it down to the court. I don't know what that means. I don't know what form it was in.
Okay.
I have every confidence that our state court clerk is stellar when it comes to preserving documents and submissions. Even if they're in video form, she will take whatever they give her and maintain it in the way that it was given. However, I don't know what was given. There's no way for me to know that. If you can access whatever the clerk has, that's fine, but I'm not sure how this all went. But like I said, I don't have any idea of how this all kind of went. But unfortunately, Mr. Hudson, the part that I guess is most important is I can't treat you any differently than I would treat Mr. Samuels' client if he did the same. So if you sued Mr. Samuels and he said, my client's not answering any questions, I'm not participating, and I've had some attorneys do that, we've had to walk them back to what the rules say. But I can't, because you're a pro se and you didn't know, I can't use that as an excuse to not respond to the motion that Mr. Samuels has had.
Okay.
Okay. All right. It's not, I don't know. It's hard, I know, because what people see on TV about how cases go, what they understand from the barbershop. My husband and I joke all the time about barbershop law versus actually law. And at some point, we're going to talk about that. I may do a podcast when I retire, because what they tell you in the barbershop or wherever you get information about how a case goes, it is so different from the way a case actually goes. And so, yes, Mr. Samuels was attempting to get information for his case, but you have the same right to get information to defend. I guess the landlord are in default. I would like to place the damages hearing on another motions date, because Mr. Hudson does have the opportunity to challenge any damages that you assert from your client. If he has documentation, if he has anything, video, even if he wanted to present it, or anything else with respect to the damages hearing, then I would prefer to have it at a different time.
Yeah, I think that's fine. I just need to confer with my client because we originally filed a jury demand, and what I want to ask him is whether he's willing to withdraw that so we could do a bench trial and get it done more efficiently that way.
Either way, a bench trial, jury trial, either way, but it's going to be on another date.
Okay.
All right, so I think we have your motion, your order, your proposed order. So,
can I ask how many days do I have before I can challenge the order that we're signing right now?
once you get it, you have 30 days to challenge it. But Mr. Hudson, this is where it gets important. There are rules to this, and so just you saying I just want to challenge it, that's one thing, but challenging it properly so that you actually can have an effect that you're looking for, that's different.
I got you.
Okay.
Yes,
all
ma'am.
right. All right. You're excused at this time.
Judge, before we excuse these parties, is Mr. Samuels going to file a motion letting us know how we're going to move forward, and then we'll file an order about what happened here today, or do we go ahead?
No, we'll go ahead and file the order granting the default, and then Mr. Samuels just can send us an email or file something saying that he wants a bench trial versus a jury trial, or he wants to maintain his jury trial.
Okay, yes, ma'am. Thank you.
All right. And Mr. Hudson, please be mindful that whatever the next step is, you'll be getting notice from the court, okay?
Okay, thank you.
All right, thank you.
Thank you.
Your Honor, excuse me, may I speak? Jordan Mahoney, counsel for defendants on that Matthews versus Cerberus case at all.
Yes.
So we spoke earlier when you called our case, and it appeared that plaintiff attempted to voluntarily dismiss the action, but that's not allowable anymore under OCGA section 91141. Voluntary dismissals now must be done with the consent.
No problem. And next is Devontae June Taylor, Denise Tuckenberry versus Michael Corday McKinney.
Good morning, Your Honor.
Good morning.
We're both here.
All right, anyone here on behalf of Mr. McKinney?
No, he never answered.
All right, and that's it. All right, so Kamara, Jill, give me a minute on that one because I think that's going to be a little bit complicated.
Okay.
Flexibility Capital versus Prince.
All right, Emery Potter for Flexibility Capital, Your Honor, pursuant to our affidavit in January 22.
And Denise Eli Tuckenberry versus Michael Corday McKinney.
Yes.
All right, so Mr. McKinney is not present. I see a Miss Bagwell. Miss Bagwell, are you here for this hearing?
No, Your Honor, I'm not. I'm a summer associate. I was just observing for educational purposes.
I hope it's been educational.
It has, Your Honor. Thank you.
Welcome. All right.
Thank you.
So, Mr. and Mrs. Mr. I guess Taylor, Miss Tuckenberry, you are here for alleging that there was some sort of fraud.
Yes.
Okay, hold on. All right, here we go. All right, so you have filed an affidavit and a request for default judgment. Tell me what happened.
Okay. A loan was made to a friend of mine who I hadn't seen in years. We were going to go into some kind of business, into lawn care. Okay. He asked me to loan him my money so he could start the business.
Okay, so hold on. So this is Mr. McKinney.
Yes.
All right. So Mr. McKinney and you haven't talked in years, and then y'all start talking to each other about a business.
Yeah, he found me on Facebook, and we We like knew each other from high school.
Okay.
Okay. So he was talking to me about the lawn care business and it sounded good to me because I know you can make money off the lawn care business. But like I said, he asked me for the loan and I loaned him the money. And when I loaned him the money, we had a verbal agreement that he would pay me back my money.
Did you just listen to the last hit case, Ms. Tuckerman?
Yes.
All right, so you're starting a business with somebody who you haven't seen since high school.
Yeah, we weren't starting a business together. I was loaning him the money.
Okay, so why couldn't he go to a bank?
He has 3 jobs. He works like 7 days a week. He has money.
So then why did he need your money?
Oh, I had money. I had money saved up. So I was going to start a business. But when me and him started talking, it sounded good what he was talking about. He was going to start the lawn care business and then he was going to come and train me on the lawn care business. I was going to get my own set of lawn care equipment.
Okay, so what was the money how much did you loan him?
Okay, I loaned him $56,000.
Oh my God.
Like from
wait, whoa, $56,000?
Yes.
Did you have anything in writing?
No, just a verbal agreement, and I have like my receipts from the bank and everything else. But 56,000 is not the total amount. The total
Go ahead. Mr. Taylor, how are you involved in this?
He's severely autistic. It's
Okay.
just that some of that money was his money, our money saved.
Okay. All right. So, Miss, why would you give somebody that amount of money with no documentation or anything?
Because by him having all those jobs, he gets a good amount of income.
Which
And
means he could have paid himself, but why would he need your $56,000 plus?
his money was already tied up in things. Like I was so anxious. I wanted to get this business started and it can make money. But the defendant,
Ms. Barry,
yes,
you're one of those people where if you get an idea in your head, you're not going to be dissuaded. And unfortunately, you got an idea in your head that you were going to start a business and you took $56,000 plus and just handed it to somebody with no documentation.
yeah, Your Honor, may sound strange, but I've never done anything like that before in my life. I know about scams. I know about romance scams. I know about all kinds of things that happen, but I think I'm under so much pressure taking care of my son. I take care of him totally. You know, he has so many needs.
I have a son who's on the spectrum.
Okay. Yeah, it's a lot of stress. And I think that he got the loans because I was vulnerable and I was distracted because I've never done anything like that. And I needed something like I'll be 65 in September. I needed something like to make some money, to like, you know, build for my future, like to have some kind of income. And I had a business plan in mind. It would work, but I just didn't think that he would steal my money. I really didn't think that he would do that.
Report it to the police. Did you report it to the police?
Did I just set up, you know, this case?
Okay.
Yeah.
All right. So you said that he came to you and asked for a loan. What were the terms of the loan?
Okay. He got the loans and he was supposed to pay me back June the 10th, 2024. Everything, every penny. But
and how much did he get from you?
Oh, totally he got like $65,750. And this is why it jumped from the $56,000. I sent him a wire transfer of $9,000 from Wells Fargo Bank to Fifth Third Bank, his bank. Fifth Third stole the $9,000.
Next month.
Well, I'll say it. I've been in contact with Wells Fargo and Fifth Third for like 7 months trying to get my money back from them. Whatever they did with it, it was in their system.
You sent it to whom?
I sent it to the defendant.
And now Fifth Third and Wells Fargo are saying they don't have that money.
No. It took me 7 months, and I finally got in touch with the president's office of Fifth Third Bank, and they found the money. But the defendant set it up where it still went into his account. So that's why my $56,000 went to $65,750. Well, I mean, Fifth Third Bank had my $9,000 I was sending to him, and they kept it. And nobody would answer questions or anything. And then the Financial Bureau made Fifth Third Bank give me my money back. But when they were giving me my money back, the defendant had it transferred into his account because originally it was supposed to go to his account. After it was lost with Fifth Third Bank, I sent all kinds of letters and everything else. So they would return that $9,000 to me. Now this is another part to that. When Fifth Third Bank had my money and they didn't return it, the defendant was pressuring me because he needed the money to get more lawn care equipment. And so I gave him $9,000.
Did you ever see any lawn care equipment?
He showed me some pictures, but it didn't even occur to me that he may not be telling the truth about the lawn care stuff. I mean, I was so wrapped up in thinking, okay, I'm gonna get my business started. I'm taking care of my son, totally distracted because I have to think for me and for him. And I didn't think that the defendant would scam me. Yeah, he showed me some pictures. He showed me pictures of the trailer. He showed me pictures of the riding lawnmower, and then things need to do.
I can show you pictures of a rocket ship. It doesn't make
exactly. I swear, my mind frame, I don't know where it was because
I'm just breaks my heart. Miss Tuckberry. Miss Powell, was Mr. McKinney ever served in this case?
1 second, Your Honor. Let me check.
He was served by me like 3 times, and then
hold on, ma'am. Hold on.
Okay.
Not legally.
Okay. Your Honor.
Yes, ma'am.
He was served, like I said, by me, and I turned those papers into you all, into the court, and they're filed. And then Miss Kiera sent them one last week.
So the affidavit of service the date for that is March 26th.
Okay, and who was he served by?
Certificate of service. I'm sorry, the certificate of service was March 26th. The affidavit of service was filed on April 14th. And then we did send service as well for the Real Nice Eye.
Okay, when I said who was he served by, so the original complaint was served by the sheriff's office?
Yes, ma'am. I'm looking into it to double check, but I believe so.
Yeah, did he file an answer of any kind?
He has not responded to the case at all.
Okay. All right. So the court is going to grant you the amount of $73,960. That's $65,700 in principal, $4,000 in attorney's fee. Well, no, you don't have an attorney, so I can't give you attorney's fees.
Yeah.
$537 in court costs, and you're asking for prejudgment interest. And I'll go ahead and grant you whatever prejudgment interest you're entitled to. Okay. All right. Now, Miss Tuckerberry, listen.
Yes.
Carefully. I don't understand why people don't understand this. But you don't ever give anybody money on just a say so.
Yeah.
You don't ever exchange money for anything that doesn't have paper backup with it. If somebody tells you, well, I'm going to start a business and they have a business, well, you want to know, okay, well, who've you worked for before? Can I get, can I talk to your clients? Can I see your work? Can I see the actual, because you weren't even giving him money to start your own business. You were
Right.
giving him money to support. If somebody's telling you, I'm working 3 jobs and I have all this money, doesn't it, think about now what sense it makes to be working 3 jobs and you can't get a loan and you don't have any money to do something else that you working 3 jobs and your money is tied up in other stuff, but you don't have any money and you got to come to a vulnerable person who's taking care of another vulnerable person and take their money.
Yeah. All my life, I've seen all kinds of scams and everything else. I didn't think I was in one.
People get excited when folks start talking. I've seen it so many times. Well, we're going to start a business and we're going to do this. And they get that hype language.
Yeah.
But they never see profit and loss statements. They never see tax returns from his current business. They never see anything in writing that says, I have successfully started a business and I am going to use the money in the right way. Everything he showed you, he could have gotten off the internet.
Yep. Yeah. And I didn't think that all the way until the part where he told me, well, I think we should just like separate and all of this kind of stuff. And I'm like, what about the lawn care? It never entered my mind for this person that he would do this. It just never, and the pictures, you know what I'm saying? I saw the pictures. Okay.
So, ma'am, I'm going to give you the judgment. I don't know that you're going to be able to collect it, but if I were you, I would get an attorney to help you collect.
Okay.
Because you're not going to be able to navigate what it takes by yourself.
Right. Your Honor.
But number 2.
Okay.
This sounds like a classic romance scam or fraud. So you may want to report it to the police. I know sometimes people get embarrassed, but he may be doing this to other people.
Okay.
If I were you, I'd file a police report. So just go down to the police station or call the non-emergency number. Because he not only defrauded you, he defrauded your son. Your son has a disability, so he's taking money from a vulnerable person.
Yes.
That's somebody we need to get off the street.
Okay. Those numbers that you quoted to me, can you quote them to me again?
It'll be in the order.
Okay, thank you.
A copy of the order, but yeah, you're not entitled to attorney's fees.
Okay.
But like I said, collecting money is hard. So you may wish to get you an attorney, because if he's doing things that are fraudulent, that money ain't gonna be easy to find and he's not gonna willingly give it back.
Okay.
All right, but Ms. Tuckenberry, please. Like think critically about stuff. He may be talking sweet in your ear, but think about the fact that, why would a man who is so successful need your money?
Right. Absolutely.
All right, so we'll get the order out to you.
Okay, thank you so much, Your Honor.
Welcome. All right. All right, Miss Powell, we're in recess until the 1 p.m.
Hey, Judge.
calendar. Yes, ma'am.
Okay, will you send me a picture of the notes that you took, of the numbers that you have?
I have the affidavit, so $65,700, $537.
Wait, you're pulling the numbers directly from the affidavit?
Yeah. She's not
I
entitled
can
to
read that.
attorney's fees, and she's asking for prejudgment interest. So if she pled for it, so she's entitled to it.
Okay.
All right.
Okay, see you soon.
Good afternoon. I'm Judge Tammy Long Hayward. This is the civil calendar for June 4th, 2025, Clayton County State Court. I'm going to call the calendar. Huff as surviving parent versus College Park Retail, Jailus Inc., Hale Retail Group.
Good afternoon, Your Honor. I'm John Christie with my colleague Jamie Christie here for the Move-Ants, Hale Retail Group LLC, and Jailus Inc.
And Alex Brown and my partner Mike Rafey here on behalf of the plaintiff.
Malfred Colley versus Greg et al. Versus Crestwood. Okay, so let's start with Huff. Did anyone show for Colley versus Crooks? I don't believe so. Yeah. Okay, so let's start with Huff. All right, Huff and surviving parent versus College Park Retail. They've been dismissed. It looks like, is it Jailus or Hollis?
Jailus,
Jailus Inc. versus Hale Retail Group. All right.
All right. Good afternoon, Your Honor. I'm John Christie here with my colleague Jamie Christie. We represent the Move-Ants. Move-Ants are Hale Retail Group LLC and Jailus Inc. Also on the Zoom call is Mr. Antonio Santos, who is the principal of Jailus Inc., and also Mr. Sam Hale, James Hale, and Adam Smith, who are the principals of Hale Retail Group. This is a motion brought by the defendants pursuant to OCGA section 9-11-55B to set aside a default and a judgment of liability entered by the court on March the 26th, 2025 in this case. This is a serious premises liability case involving the death of a young man. The Hale Retail Group was the property manager for the property. Jailus Inc. is the property owner. The plaintiff is the decedent's mother in both her capacity as the survivor of the decedent and the administratrix of his estate. The default arises from the fact that in March of 2024, the complaint was served upon the defendants. The evidence that's in the record through the affidavits of Mr. Hale, Mr. Sam Hale, Mr. Jeremy Borak, show that upon receipt of the summons and complaint on March 24th, 2025, the defendant, 2024, I'm sorry, March 24, 2024, the defendants immediately sent it and forwarded it to Mr. Borak, who was their insurance agent with the Baldwin Group. Mr. Borak then had a telephone conversation with Mr. Hale, Mr. Sam Hale, in which he acknowledged that upon receipt of the summons and complaint, he would forward to the traveler's insurance company, the defendant's insurer, for defense. In Mr. Hale's affidavit, as confirmed by Mr. Borak, the summons and complaint was indeed sent to Mr. Borak, and he acknowledges having received it. He also acknowledges having provided assurances to Mr. Hale that the summons and complaint would be forwarded to the traveler's insurance company for defense. And subsequently, he just didn't do that. And so as a consequence, in March of 2024, about a year later, when the plaintiff finally moved for the entry of a default, the court entered its March order. When the defendants received that order, they promptly took action to file this motion pursuant to OCGA section 9-11-55B to open the default. As I said, George, this case is a premises liability case, which is affected and impacted some by the changes in the tort reform and the premises liability law recently enacted by the legislature. So not only is it a serious case because it involves the death of a young man, but it also implicates serious and important issues of Georgia law, namely the application of Georgia tort reform.
So I get it. Let's test the new law, but my default when entered was valid because y'all didn't perform. So why aren't y'all suing Mr. Borak? Why are y'all coming back to me to open up this case instead of suing the person who failed you?
Well, Your Honor, because we have a right to assert our meritorious defenses and to defend this case, and also to vindicate the longstanding Georgia policy and Georgia law, which favors opening defaults and deciding cases on the merits. The Georgia Court of Appeals has expressed on numerous occasions, including in the case of Kedler versus Atwell, 251 Georgia Appeals 270, that the rule permitting opening of default is remedial in nature and should be liberally applied. For default judgment is a drastic sanction that should be invoked only in extreme situations. Whenever possible, cases should be decided on the merits, for default judgment is not favored in the law. In addition, courts have routinely stated and repeatedly stated that a litigant should not be unnecessarily forced into default as a consequence of having reasonably relied upon the word of his fellow, in this case, Mr. Borak and his company, especially when no innocent party will suffer if the default is open. We've moved pursuant to 91155B, Judge, to set aside the default. That code section provides 3 separate independent tracks for opening defaults, which include providential cause, which is broad, excusable neglect, which is even broader, and where the judge from all the facts determines that a proper case has been made. In their reply, the plaintiff does not argue that we haven't complied with the predicate for 91155, namely paying costs, offering to plead in standard. What they argue is that we have failed to establish excusable neglect or a proper case. Indeed, as I'll explain to the court later, they haven't even argued prejudice in this case. In fact, if the default is not open, they will be prejudiced because the defendants will have no insurance coverage. Now, with respect to excusable neglect, plaintiffs rely primarily on the case of Flournoy versus Wells Fargo, 289 Appeals 560, 2008 case, in which the court, they claim says that, well, we didn't report the claim to our insurer, we reported it to our broker. Now, they also claim that our affidavits are self-serving and we didn't bring Mr. Borak to testify. Well, we've filed the affidavit of Mr. Borak, in which he confirms, as I said, the affidavit testimony of Mr. Hale. This complaint was indeed sent to Mr. Borak virtually at the day after it was served by the process server. That Mr. Borak assured the defendants the case would be forwarded to Travelers, the insurance carrier, for defense and handling. So they were diligent. They sent the complaint, as is customary in the property management business, to the insurance agent / broker for forwarding to the carrier for defense. They were assured that the case would be handled and defended, and that simply didn't happen. They are the victims, the innocent victims, you're right, of Mr. Borak, but they still have rights. And there may be issues that there's no claim against Mr. Borak for which they are entitled to assert those defenses. I might also point out the facts of this case are distinguishable from Flournoy, because in Flournoy, the defendant's lawyer said he never got the complaint. So he couldn't have sent it on to be defended or defended it because he never received it. In this case, Mr. Borak admits he got it and simply didn't forward it. So, moreover, I should add the case of Patterson versus Bristol, which is 286 Appeals 423. The Court of Appeals found that reporting the suit to the broker who assured the defendant that it would be defended is adequate. You don't have to report it to the insurance carrier. We would argue, to Your Honor, we have met our burden on excusable neglect because we have demonstrated that we timely submitted the case for defense. We were assured it would be defended, and it was not. We've satisfied that legal standard. But alternatively, and perhaps even more with greater applicability, is the proper case standard. Deciding whether or not there is a proper case to open default turns on each case's unique facts, which is why in their reply brief, they've got a number of a string side of cases in the brief that seem to go in all different directions, because each case is unique and has to be decided on its peculiar set of facts. No two cases, the fact pattern of no two cases are alike, and the purpose of this ground, proper case ground for setting aside defaults, is to have cases decided on the merits in the interests of justice and to avoid injustice. Now, the Supreme Court has defined very clearly what this proper case standard is in Bowen versus Savoy, a 2020 case. And they held in that particular case the proper case standard, unlike the exclusive neglect basis case, where injustice might result if the default is not opened. That again, the essence, and we'll get back to this much like in the federal standard, which Georgia is migrating toward. The essence of the proper case ground is the broad discretion of the trial judge to ensure that there is no injustice and in keeping with the policy of deciding cases on the merits. And that's what's key, the case being to be decided on the merits. The Court of Appeals has set forth various factors for the court to consider, whether the opposing party be prejudiced by opening the default, whether the opposing party elected not to raise the default issue until after the default, and whether the defaulting party acted promptly. Now, we assert to Your Honor that the facts of this case do present a proper case for opening the default. In her response, the plaintiff does not argue that she'd be prejudiced if the default were to be opened. Indeed, the default occurred almost a year ago, and the plaintiff waited a year before taking any action. The plaintiff also sued another party, which they ultimately dropped. To the contrary, and I think this is very important, to the contrary, and the reality is not only will my clients, but also the plaintiff be prejudiced if the default is not open because there will be no insurance coverage. We have attached, as part of Mr. Borak's affidavit, an email from claims counsel, in-house claims counsel at Travelers, which confirms the defendant's representations that there is currently no insurance coverage for plaintiff's claims because of this default. But that if the default is open, Travelers will provide a defense, and that Travelers is not, quote, currently aware of any facts which would eliminate its duty to pay for any verdict on the policy limits levied against Hale and Jallis in the event a verdict is rendered. Close quote.
All right. So, Mr. Christie, I actually, because this is kind of unique in the sense that the unique part of this is that you all assert that you gave it to the person who's responsible for initiating the information with the insurance company. That person acknowledges that they they received it but didn't do what they were supposed to do. So that's a unique twist on this. But essentially, the default's a default. So on behalf of the plaintiffs, why isn't this a consent? Since the win is that you get insurance coverage in this case, as opposed to an empty default judgment.
Well, Your Honor, I don't think the question of or the issue of insurance should really factor in here because
It doesn't really, but
there's solvent defendants who have hired counsel.
But usually in cases like this where you know that the tendency for a court, especially one where discretion is in place, and where the rule tends to be open default, so that these cases can be decided on the merit versus the draconian penalty of maintaining a default when excusable neglect and proper case and all of those things can be shown. So tell me what's the downside to me opening default?
Well, Your Honor, the passage of time, and I don't believe that the defendants have met their burden of showing excusable neglect here, that merely just forwarding it on to the insurance broker. And I admittedly have just started reading their response they filed today to our brief that attaches the affidavits from Mr. Borak and the information from Travelers Claims Counsel. But the original motion to open default, which was filed essentially a month after default was entered and on the eve of Your Honor previously having set a hearing, that's not what those actions aren't the actions of a reasonable property owner or property manager. The email where it's forwarded ends with, please advise the next steps. A reasonable property owner or property manager would follow up when there was no advice about the next steps. The next layer to that is Mr. Santos and Jallis, the property owner, was served later. And he, in his affidavit, I believe, states that he contacted Hale, and Hale said, our insurance broker is handling it. At that point, a reasonable person would have followed up. Someone else has called me. Let's make sure this is being handled. It wasn't. So there we would say that there is not excusable neglect. The cases we've cited, I think this is comparable to Flournoy as well as LSV 5-Star Dodge, which is 242 Georgia Appellate 474. And then on the proper case grounds, the issue is they didn't act promptly to open the default after they learned that no answer had been filed or timely filed. They waited essentially a month to file their motion to open default, which had some serious issues in it that they didn't attach the affidavit of Mr. Borak. It was just a self-serving affidavit from Mr. Hale and Mr. Santos, and then waited another month essentially to try to cure those deficiencies. We would suggest to the court that that's not evidence of someone who is acting promptly when they learned that an answer hasn't been timely filed. So we would ask that the court deny the defendant's motion.
All right, anything else?
Your Honor, I would just say that we cited the case in our supplemental brief saying that 30 days is found to be reasonable. The motion was filed in less than 30 days after the Hale parties found out about the court's order. So I would suggest to the court that we have made out a proper case for a proper case and that the court in its discretion should set aside the default and avoid the loss of insurance coverage and also probably would ultimately be a bankruptcy, because given the seriousness of the case, if there is liability and if the meritorious defenses are not successful, then there could be a catastrophic verdict in this case.
And Your Honor, one last thing.
Yeah, I'm not going to argue the motions of the merits of the, tort reform. I think you made a proper case. Go ahead and get me an order to open default. Make it simple.
Very well. I'll do that. I'll circulate it to Mr. Brown before submitting it to the court.
All right. And then, I think that in light of the new tort statutes, y'all, it may be, I'm going to see if what happens is more of a collaborative thing where, parties kind of try and get together on things as opposed to letting it play out, because it looks like the way it is going to establish itself with the bifurcated, trifurcated trials, it could be a lot more expensive in the long run. And so it's going to be interesting to us judges to see how this all works out. So it may just engender more collaboration between the parties.
Judge, this is Michael Rafey. I'm on a leave of absence, so forgive me for not appearing on camera. I did just want to mention that there's a very real issue on the insurance side that the defendant gave late notice to their insurance carrier. So this whole idea, I just wanted to at least mention that the idea
Are you representing the insurance company?
No, I represent the plaintiff, and
but if they're saying that they have assertions in writing from the insurance company that if default is open, then and the coverage will be provided, which I don't see why that would be something that we would challenge.
Because that's not my understanding of what the statement is. The statement from the insurance company is, we don't, and this was just filed today, and I'm on a leave, and we're trying our best here, filed I think an hour ago. But the statement is that there's a caveat for late notice. So I do want to at least mention that the insurance company can very well say they had late notice, which if they didn't have notice until recently, which is what the evidence seems to suggest, given the insurance company did not respond, did not hire a lawyer, there's going to be a late notice deck action, and the prejudice to the plaintiff is going to be severe because they're going to have to go out and hire lawyers to handle that case. They're going to have this case. We've waited a year now to try to cure default. So the prejudice will be extreme. And I would just suggest that a reasonable and proper party does not hand a lawsuit to someone who has no legal training or obligation to do anything and then doesn't follow up for a year. So I think
Mr. Rafi, I've been doing these civil cases since I was on magistrate court. The civil cases with small business owners, medium, but people who are business owners as opposed to lawyers. And the argument you just made is a lawyer argument. It's not a business person argument, because business people think that if they hand it off to the person who's supposed to do it and they're running their business, trust me, over the many years of argument I've heard with respect to something like this, your argument is more of a lawyers would do the follow-up, the due diligence, the staying on them because we know the timing issues. Business people, oh man, the stories I could tell. So I get from the standpoint that you're saying that there was a lack of diligence because he handed it off to somebody and didn't check. But I think that that's something we do as attorneys, and we're trained to do it. Not everybody does that, and business people aren't trained in the same way that we are. So with that respect, I just, this is just a different way to look at that argument. All right, but like I said, send me the order. I'll look at it all. If I decide I want to change it, I will. And then you all will get my order. But the law has not changed in this respect, that it favors cases being resolved on the merits unless something really egregious has happened.
Thank you, Your Honor.
Thank you, Your Honor. May we excuse?
Yes, thank you.
Judge, have a good day.
You too. All right, and the last case I think that we have is Moore, Trejo, Jimenez, Alvarado, John, Future Management, Delta Star. All right, and Mr. Santos, I think if you are with the last case, you're free to go.
The plaintiffs.
And Mark Bardak, Mark Bardak of Freeman Mathis and Gary for the defendants, Your Honor.
Judge, I'm in a different Zoom than co-counsel League and Brooks, but JL King here.
All right, next case is James Lee Jean or John, James Lee John, Future Management Corp, Delta Star Corporation.
Judge, that's the same case.
Oh, it continues. Oh, I was
Just got a lot of parties.
All right. North America Wells Fargo Bank versus Phillips Shaderu.
Good afternoon, Your Honor. Alex Kempers on behalf of the plaintiff.
Phillips Shaderu. Okay. Wells Fargo versus Hollows and Hale. We have Colley versus Crooks. Okay. And Moore et al. Versus Crest. Okay, so let's start with Huff. Did anyone show for Colley versus Crooks? I don't believe so. Yeah. Okay, so let's start with Huff. All right, Huff and Surviving versus College Park Retail. They've been dismissed. It looks like, is it Jollis or Hollis?
Jollis.
Jollis Inc. versus Hale Retail Group. All right.
All right. Good afternoon, Your Honor. I'm John Christie here with my colleague Jamie Christie. We represent the Move-Ants. Move-Ants are Hale Retail Group LLC.
Thank you.
Judge, have a good day.
You too. All right, and the last case I think that we have is Moore, Trejo, Jimenez, Alvarado, John, Future Management, Delta Star. All right, and Mr. Santos, I think if you are with the last case, you're free to go too, unless you want to watch, that's fine. So just hold on just 1 second. I just need about 5 minutes.
ensuring that he and we filed this amended motion to join parties just as a little bit of a background. This does involve a tragic wreck involving the estate of our client Stephanie Laura Mendoza and the defendant who is Future Management. This occurred in October of 2023, and we filed a lawsuit in November of 2023. We brought action against initially the driver of the
Every day in the USA, people find themselves in court.
Court is on the record in State of Ohio versus Cassandra Renee Kuhar, case number 25 TRC 90. In this case, Ms. Kuhar on April 29th, 2025, pled guilty to charges of operating a vehicle under the influence, a second offense in 10 years, a violation of section 4511-19A1A, and to one count of driving under OVI suspension. Both of those are first-degree misdemeanors, and the balance of the charges in this case were dismissed. The court deferred sentencing to today, and so we are ready to proceed to sentencing. Ms. Kuhar is present. She's accompanied by her attorney, Sean Martin. Also present is Law Director John Lewis. Okay, Mr. Martin, before the court imposes the sentence, is there anything you or your client would like to say?
Yes, Your Honor, thank you. Good morning, or good afternoon, I'm sorry.
It's all right.
Your Honor, I guess I think I could start off with the things that I think are, I think we can be thankful for here. Nobody was hurt. Nobody was injured. My client's vehicle was the only vehicle involved in this. No other property was damaged. I mean, those are good things, and it's never the best to say those are the good things, but still certainly the good things. Nobody got hurt, and that's, I think, the biggest thing. As far as the rest of it, Your Honor, Ms. Kuhar clearly is struggling with some issues right now, and I think you can see from the letter provided by Lark, she is engaging with them for programming. She is set up for the DIP program. She's attempting to now address some of these problems. That doesn't mean what's happened is acceptable, but at some point, Your Honor, it's still better late than never, and it's still better now than before somebody gets hurt or something irreversible happens. I know that still is not the way we want people to conduct themselves, but she is here today. She understands that there is mandatory jail time attached. She understands that there's the potential for a lot of jail time to be attached. There is also still the pending OVI out in Western County Court. She goes back for a pretrial on the 24th this month at 8:30. It's my understanding from speaking to the PD's office, they're waiting to see what happens here. I know you're probably all too familiar with one court waiting to see what the other court does, being on either end of it. But with that said, Your Honor, I do think that anything outside of the mandatory minimums is not the proper sanction. Obviously, she has to serve the mandatory minimums. We can't, there's no way around that. That's state law. There's no way for you to deviate from that. But we would ask that you impose the mandatory minimums there for her. Certainly, I know one of the options is for the combination of house arrest and detention, and then, Your Honor, we'd ask for that. It would limit the amount of time she's incarcerated. She still has a job. She's still gainfully employed, Your Honor. At this point, she does provide for her children. Certainly incarcerating her for a longer time. There's no guarantee she would be able to keep her job for the longer stretch of incarceration. And certainly that would just really, any kind of push everything back further. So we'd ask the court just keep it to the, and certainly I know my client is very nervous being here today. She understands that she's done some very serious things, and she's just here before the court to own up for what she's done. Thank you.
Okay, thank you. Ms. Kuhar, is there anything you would like to say before I impose sentence? Where is she working, Mr. Martin?
Are you still What's that? Yeah, you're still there. Your Honor, she's at Vibrance. Sorry.
No, that's all right. So she doesn't have anything else to say? Okay.
No, Your Honor.
Okay. Mr. Lewis?
Thank you, Your Honor. As Mr. Martin indicated, this was a result of a one-vehicle crash out on Plymouth Gageville Road in Sheffield Township. She did strike a traffic sign. I have received no information or anything about replacement of the traffic sign, so I don't think that there's anybody asking for restitution on that. But she did crash. Troopers went out to investigate, administered the field sobriety test to her, and she was placed under arrest for OBI. She refused the breath test. I did, when this plea happened, I did agree to recommend the mandatory minimums on the OBI, 2nd and 10, with probation. And I don't know if this has been brought up. I don't think that Mr. Martin and I have discussed it, but once maybe all of these cases are resolved, maybe a real court candidate here, Your Honor. I don't know. That's I don't think Mr. Martin and I have discussed that, but she still has that case pending out in Western County.
Yeah.
Thank you.
Okay. Okay, so I ordered Ms. Kuhar as a condition of her bond to go to LARC for an assessment and successfully comply with any treatment. I've been provided a letter from LARC. They did not provide this to me, I don't believe. I think this was provided directly to counsel.
Your Honor, that was provided to my client. My client provided that to me.
Okay. Which means she didn't sign a release, which is a bit troubling, but nonetheless. The assessment was done on March 3rd. So that's been 3 months ago. And I don't have anything, nothing's been provided to me about, because I did order that she successfully comply with any recommended course of treatment. What's being recommended in this report was the substance abuse group at LARC should be ordered or required to complete that. In the letter from the assessor, she did say that I have attempted to reach Ms. Kuhar several times via text, calls, and email, and I'm still waiting to hear from her and proceed, at which time I will let you know. Okay, Ms. Kuhar, what have you been doing with LARC? Did you ever pick up the phone and call them? Do you not realize I ordered you to successfully comply with any and all treatment recommendations at LARC? And this incident happened allegedly well, you've been convicted on February 8th. Here we are, June 3rd, and you've not been, other than being assessed, you've not undergone any treatment. Here's what I don't understand. Why should you wait to be told what to do? You got a problem. Why don't you voluntarily get help? Too many times it's the court being the one requiring people to get treatment. It should be the other way around. People should be voluntarily getting treatment and then coming to the court and saying, "Judge, look what I've done. Before you sentence me, look what I've done in mitigation of sentence." Instead, you're waiting for me to tell you what to do. And I will. Do these merge for sentencing? We have an driving under OVI suspension and an OVI.
No, I don't believe they would, Your Honor. I don't know what Mr. Martin feels about that. I don't think they would.
I think they would, Your Honor, but we would ask that the court consider that as a merged offense.
I am going to find that they merge for sentencing purposes. And so I will sentence on the OVI. 180 days in jail, 160 will be suspended. This is a commitment to the Ashtabula County Jail. This was a township case, so she will have to serve 20 days in jail. She is placed on supervised probation with this court for a period of 3 years. She's to have no criminal or traffic offense for 3 years. I'm required to, I'm the first to impose sentence, so whatever happens in Western happens in Western, but since I'm the first to impose sentence, she's going to be on probation with this court. She's not given any jail credit. I will allow her to serve 3 days of that 20-day jail sentence by attending and completing a driver intervention program in lieu of those 3 days. I will impose the minimum fine of $525. I'm suspending her license for 2 years. As a result of the refusal, I do believe she was placed under an ALS, but let me just double check. Yes, she was. Yes, she was. So this will become February 8th of 2025. So we will make this retroactive to February 8th, 2025. I will terminate the ALS to save her on a reinstatement fee. I will grant limited driving privileges. The hard time of 45 days has passed. So I will grant limited driving privileges upon a formal request for driving privileges, proof of financial responsibility, and other supporting documentation. Did you have insurance on the date of the offense?
Yes, I keep insurance because I saw my car.
I don't believe that. I believe we've been provided a proof of insurance, because the officer indicates on the ticket that we did not provide proof of insurance. So I will order her to provide proof of insurance on the date of the offense, that being February 8th, 2025, on the vehicle she was driving, to avoid any further non-compliance suspension. She's to do that by the end of the day today. I'm ordering her to submit to a comprehensive diagnostic assessment at Lake Area Recovery Center. I'm not sure, this being 3 months old, whether Lark believes another assessment ought to be done. But I'm ordering that she submit to a comprehensive diagnostic assessment at Lark for alcohol, substance abuse, and mental health purposes. She's to do that within 15 days and comply with any recommended course of treatment and then execute any necessary releases for probation to monitor. She's not to purchase, possess, or consume any alcoholic beverage or drug of abuse or any pseudoephedrine product, or go into any bar or liquor establishment for a period of 3 years. This sentence is consecutive to all other sentences, but will merge with subcase C, that being the OVI, or driving under OVI suspension charge. She is subject to a mandatory 1-year license. So I'm going to, I understand they merged for sentencing purposes, but there are other things that I need to do on the OVI suspension that are separate. I am going to impose a $250 fine, which is the minimum fine. The license suspension is a 1-year license suspension. That's mandatory. That's 1 year. I will commence that also on February 8th, and that will run concurrent. It's not going to be an addition. They're not going to be an addition to the 2-year license suspension I issued on the OVI. It will just run concurrent with the same license suspension. The vehicle has been immobilized, right?
It was, Your Honor, yes.
Okay, has that been released since?
Yes.
Okay. I did do an order, and that was clubbed, I believe. And so that vehicle, I believe that time was run. So I'm not going to order any kind of immobilization. So again, this will, other than the fine and the license suspension, this will merge for sentencing purposes with subcase A. Advising Ms. Kuhar of her right to appeal, without cost, of her right to have counsel appointed on appeal without cost, of her right to have documents provided or necessary to file an appeal without cost, and of her right to have a notice of appeal timely filed on her behalf. Your total fines and costs are approaching $1,000. They may even be more than that, Ms. Kuhar. How much time do you need to pay all of that in full?
Your Honor, if we could have 90 days for that.
Okay. Give her until Friday, September 5th. Pay all fines and costs in full. Have I advised her of appellate rights?
You did.
I did.
Your Honor,
Okay.
yes, you did.
I thought I do it so often I'm forgetting what I've said. Okay. Mr. Lewis, is there anything further?
No, Your Honor, thank you.
Mr. Martin.
Yes, Your Honor. As far as the matter of the 20 days, I know you mentioned for the 3 days.
Yeah, we'll give her a check.
If we checklist certain time, she would be able to keep her employment with the court, allow her to do non-consecutive terms of incarceration to maintain her employment.
Well, she must serve 10 consecutive days.
Yes.
So the 10 days have to be consecutive. So I will make a note that 10 days must be consecutive. Now, so that we're not having to entertain multiple motions after the sentencing hearing, what is her normal work schedule?
Monday through Friday.
What shift?
First.
So I'll indicate that 10-day balance to be served on weekends. And that would be five weekends. Where you go in Friday night and you leave Sunday night. So 2 days. But the 10 days must be, the law requires consecutive sentence the first 10 days. So. Anything else, Mr. Martin?
No, Your Honor, thank you.
Okay, Ms. Kuhar, you're going to go to the clerk's window. They're going to take care of you, and then you're going to meet with the probation officer. For the next 3 years, you're going to be on probation with this court. If over the next 3 years you're found to have violated any of the terms of your probation, you do face an additional 160 days in jail. I could extend your probation from 3 years up to a maximum 5 years, and/or I could impose more restrictive community control sanctions, more restrictive than what I've already done. So I guess my point is, Ms. Kuhar, is you're going to be under the court's thumb for the next 3 years. So mind your P's and Q's and do everything you're supposed to do. And if you don't, you're going to be facing serious consequences. Do you understand all of that? Okay. Okay. This matter is concluded. Thank you all very much. Thank you. Court is on the record in City of Conneaut versus Johnny Gregory Jr. Case number 25 CRB 107. On April 29th, 2025, Mr. Gregory pled not guilty to charges of criminal damaging, a second-degree misdemeanor, and criminal trespass, a fourth-degree misdemeanor. We conducted a first pretrial conference, or attempted to conduct a first pretrial conference on May 14th, 2025, at which time a motion to continue that hearing was granted, and I went ahead and rescheduled today's pretrial. So today technically is a first pretrial conference. Mr. Gregory, you sent a letter to the court on May 14th saying you couldn't be here. It was filed that day. Why weren't you here?
My kids. I had to go get them from school.
I'm sorry?
I had to go get my kids from school. They were sick.
You had to get your kids from school?
Yes.
Because they were sick?
Yes.
Do you have custody of your children?
No.
The reason I asked Mr. Gregory is because this court received a letter from Jenna Harrell. And for the record, Mr. Gregory is present with his attorney, Mafid Syed, also Law Director John Lewis. The letter was sent on the same day, May 14th. I, Jenna Harrell, are writing on behalf of my children, whom I share with Johnny Gregory. He requested a continuance. I don't know how she knew that. Claiming our children are sick, and that is why he was unable to attend court on May 15th. That is a lie. My children are perfectly fine currently at school. If they were homesick, it would not affect him in any way because I am the only provider to them both.
Yeah. She's full of shit. And she's been trying to get me locked up constantly for last year or 2 years. Constantly. Over and over again. Same with the
Mr. Gregory, enough. I've heard it from you.
Same with the protection.
I don't want to hear anything more from you. On that issue, I don't want to hear anything more from you. All I know is that if you miss one more court date while this case is pending, you will find yourself in jail again from me.
Yes, sir.
Okay? Okay, the court is in receipt of a pretrial report. Mr. Lewis.
Thank you, Your Honor. I spoke to the alleged victim here, Tony Moreno. He is present in the courtroom. I also spoke to him back in May when the first pretrial was scheduled. The offer that's been extended to Mr. Gregory would be to plead his charge with the parties arguing his sentence. I spoke to Mr. Marino about the issue of restitution. He is not seeking restitution in any dollar amount. That's all, Your Honor. Mr. Syed has indicated that he's asking for a second pretrial. I have no objection to that. However, I do not intend to subpoena Mr. Marino again unless there's going to be a trial, because I've already spoken to him twice. I know what his wishes are, and he's missing work right now. He's feels he's in danger of maybe getting in trouble with his work over missing work so much for this. And so, if it pleases the court, I would ask to not have him present unless we need him for a trial in the future.
What about a sentencing?
If there's a sentencing also, Your Honor, I would get him here. Thank you.
Okay. But it's just, his point is that Mr. Gregory plead to the original charges, not to any amendments.
That's correct, Your Honor.
Okay, well then I don't need to inquire of Mr. Marino if that's the case. So.
That's the case.
Okay. Mr. Syed?
Your Honor, given that this is our first pretrial, and I will admit, I've had some trouble contacting Mr. Gregory. He's contacted our office last time for me to file the continuance, but as far as me contacting him, I've been a little hazy as far as communications with him. So this is the first time I got to speak with him directly in face. So this time I'm asking for a second pretrial. While I do understand the law director's position, and if need be, go to trial, I know my office has no issue doing that. At this time, given that it's the very first pretrial, I do ask that this be set for a second pretrial.
Okay, I'll go ahead and set this case for a second pretrial conference in roughly 3 weeks. Mr. Gregory, when you leave the courtroom, you'll go to the clerk's room. They'll give you a date and time for your next pretrial. That will be the only notice you receive from the court, so make sure you're here on that date and time.
Yes, sir.
Mr. Marino, you'll be notified by the law director's office when it's necessary for you to be here again. Okay. Okay. Anything further, Mr. Lewis?
No, Your Honor. Thank you.
Mr. Syed?
Not this time, Your Honor. Thank you.
Okay. Thank you all very much.
Every day in the USA, people find themselves in court.
Here on this is a revocation and show cause docket. I only have one person here for show cause, so I'm going to focus mostly on revocation. So if you're here on a revocation docket, that means sometime in the past you signed up for what's called deferred disposition. When you signed up for deferred disposition, you had conditions you had to meet. Mr. Dylan Garza, I need to see you on the camera. So thank you. So one of those conditions was that you pay your ticket in full, or a couple of you may have had a different condition regarding paying your ticket in full. The next condition, and really the most important, was to not break the law during the term of your deferral. Then another condition was that if you move, you have to let me know where you move within 5 days of the date of your move. Finally, some of you had additional conditions. One of the conditions would have been maybe take driver safety course and get that course completed prior to the end of your Mr. Garza?
Yes, ma'am.
Did you receive an email from the clerk's office with your instructions on how to complete your driving safety course?
I believe I got a text message
No,
with
no,
no, it wasn't
no.
that?
No, we don't, that's, if you get a text message about driver safety course, that's from somebody trying to sell you the driver safety course. So we don't text you about stuff like that. We might text you to remind you of your court hearing, but we don't text substantive information. So we had 2 email addresses for you. One of them we're not using because I think that mailbox is full. That Just Living one, the iCloud
Yeah,
one. Yeah. And
yeah, I don't have
then,
that one no more. That's a long time ago.
okay, good. Well, I think Apple thinks you have it, or whoever does that, because they just said it was over its quota. Okay, so you sent us your proof of insurance, and then I literally I'm befuddled by what happened here. Maria, send him out. He needs the instructions. You have to take, you didn't get the instructions on how to take the driver's safety course, where you take it, your driving record, and an affidavit that you need to sign?
I do not believe so.
Okay, we're gonna send you all of that. Let me make a little note here. Do you want me to mail you or email you that? You have to be able to print it.
If you mail it to me, that'd be great.
And that address that you verified with the clerk is still good?
Yes, the 1700 Southeast.
That's the right address?
Yes, ma'am.
Got it. Southeast 5th?
Yes, ma'am.
Okay, so July 30th is your drop dead date. By that date, I need back a copy of your driving record. It's the 3A driving record. We're going to send you these instructions.
Okay.
It's the 3A driving record, a copy of your driving safety course certificate. We're going to send you a link that you can go to, and you choose your provider. That text message about taking DSC, that's from some provider who tries to sell their course to people. You pick the cheapest course. You can, and then if they will send you the certificate, you can email it to me or mail it to me, whatever. I would email it, therefore I still have a copy and a record. Send that to me by July 30th, along with this affidavit that we're going to send you. The affidavit needs to be signed in front of a notary, so you can take that to your bank and do it. If you don't have a bank or have a notary near, you're welcome to come up and sign the affidavit at the clerk's office. Okay.
Okay, sounds good.
Okay. You know what? I'm glad you were here today, because I think there was some confusion between your file and somebody else's. So
yes,
we
ma'am.
got
God's
that
word.
straight. Yeah, definitely got that straightened out for you.
Yes,
Okay, so
ma'am.
you're
Thank
free
you.
to go. Be looking for that in the mail. If you don't see that in about the next 7 days, please contact the court. Okay.
Okay, got it. Yes, ma'am.
Okay. Thank you.
Have a good day.
You too. No, it needs to be restatused. If it's status, it should never have been set. So it needs to be restatused back to, he's just on DSC. Right. So somebody got their wire. You see what I mean? I do. Thank you. Erica Nahira. Mr. Dylan Garza.
Yes, ma'am.
Yeah, let me take a look. So you didn't have insurance the whole time?
No, ma'am, I didn't.
Okay. Okay, well, that's unfortunate. That means that's gonna go on your driving record, and that's a no insurance second. I hate that for you.
What?
They may make you get SR22 insurance. Does
So,
DPS have a good address for you?
yes, ma'am. I currently have insurance now. I've had it.
Okay. Well, hopefully they won't suspend, but if they do, they'll send you written notice, okay?
Okie dokie, sounds good.
Okay, thanks, Mr. Garza. You have a good day.
Yes, ma'am, you too.
Uh-huh. Thanks. Jason Miller.
Hello.
Hi, Mr. Miller. I show that you received a new citation and then there was a lapse in your coverage.
Yeah, at the time I thought I paid my insurance at the time. And when I did a couple
Thank you.
Okay. Yes, ma'am, thank you.
Uh-huh. Marcos Garza.
Yes, ma'am.
Hi, Mr. Garza, you are on you were on a different program, the driving safety course program. You were supposed to complete the driving safety course, submit your driving record, your proof of insurance, get all that turned in by oh, your problem is you haven't paid your payment. So you came to court on 5/2, said you were going to sign up for driver safety course, and one of the rules of that is you have to pay the 144 immediately.
I believe I did pay the 144. I believe I have a receipt of it. I was confused too. I thought I still had more time for the driver safety course, but I believe that they.
Let me read the notes and see what they said. For some reason, somebody was unhappy, so let's figure it out.
Okay.
Oh, let's see. I don't know what they're talking about because I show you paid on 5/2. Maria, do you see anything for Marcos Garza? So you should have from 5/2 until July 30th to get me that driving record and that driving safety course certificate.
Yes, ma'am. Yeah, I was definitely a little confused on why I was here today.
Me too. Me too.
So it shows I did pay. I do remember paying after the court or during the
It
court
does
hearing.
pay.
Okay.
Yeah, it shows that.
Okay.
Mr. Garza,
Yes, ma'am.
did you receive an email from the clerk's office with your instructions on how to complete your driving safety course?
I believe I
Like-
got a text message
No.
with
No.
no, it wasn't
No.
that?
No, we don't, if you get a text message about driver safety course, that's from somebody trying to sell you the driver safety course. So we don't text you about stuff like that. We might text you to remind you of your court hearing.
Every day in the USA, people find themselves in court.
Mr. Harrison, are you representing the public defenders for today for arraignment?
I am, sir.
I have Ms. Reed in Grand Traverse County. Do you know, has anybody from your office had contact with her?
We have not had contact with her. We didn't know she was there. What do you want me to do? Do you want me to Zoom?
Yes,
To
if
you?
you would.
will
Yeah,
Zoom.
zoom into me and I'll put you both into a breakout room. Her charges
Okay.
are driving license suspended, revoked, or denied, but she's had a few fail to appear.
Okay.
And then we will hold off for a few minutes while you do that.
District 6310. Oh, I will have. Thank you, Your Honor. 317-6310, does that sound right?
Court date, make sure you pay very close attention to that court date, because next time I'm not going to be as lenient. Okay. All right, Wexford next to Raymond, and person at Grand Traverse, you're Rebecca Reed.
Yes, Your Honor.
This is the people of the state of Michigan versus Rebecca Jean Reed, case number 25896 ST. Time and date set for an arraignment. Wexford Jail is Mr. Harris. There it is. All right. Ms. Reed, what is a good mailing address for you?
I do not have one at this time.
Do you have a telephone number?
Nope, not at this time.
Do you have an email address?
Nope, I have nothing.
And why is that?
I have nothing because I don't.
Where do you live?
I live nowhere.
I can see this can be one of these days. All right. How long are you in the Grand Traverse jail?
I just got here.
And are you in there on a probation violation?
Yeah, I guess so.
Okay.
Mr. Harrison, do you know why she's there?
I do not. I had to rely solely on her disclosure, and we got to the same point, Your Honor.
Okay.
I am aware that she will be assigned counsel up there, and I've advised her to have her counsel contact us.
All right. Ms. Reed, I have a complaint that alleges that on or about March 14th, 2025 in Cedar Creek Township of Wexford County, it is alleged in count number 1 that you did operate a motor vehicle while your license was suspended, denied, or revoked. That is a 93-day misdemeanor and or a fine of $500 with possible vehicle immobilization. Do you understand those charges and the potential penalties?
Yes, Your Honor.
Did you read and sign a device rights form at the jail?
Yes, Your Honor.
Talk about your rights to a trial and your rights to an attorney.
Yes, Your Honor.
Did you understand those rights?
Yes, I did.
You have the right to be represented by an attorney at all phases throughout this process. And if you could not afford an attorney, one will be appointed to you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
No, Your Honor.
No what?
I don't. What would I need an
don't
attorney
what?
for? I'm guilty of driving with without a license. Just get to the point.
Miss Reed, I
Well,
don't need
what
the
are you
attitude.
saying then?
I'm just asking the
I
question.
do not feel well. I can barely keep my eyes open. What is it? Life is going to be great for the greatness out there. So great. Because, I'm done sick of 3 times fucking being the same fucking month. And I'm sick of being shifted. I'm sick of fucking time still. I'm sick of being
Corrections,
fucking
please take her
retarded.
away.
Sick
We
of
will
my life
arraign her
being fucked
tomorrow
up.
when she's
Take
more.
Take my license. No, get it over with. Take my fucking license.
Okay.
Simple as that. Get it done and over with.
Grand
I have
Traverse, can you
no
please remove
beginning.
her?
I
We
have
will
no
arraign her on a
beginning. I have
different
nowhere
day.
to start a new beginning.
I'm
I
not
have
going
no
to
way
arraign her today
start a
because I
new
do not
beginning.
believe she's in her right mind.
They don't sit in there too often.
All right, then we will get that set up with them
In my
later. We will
motherfucking right
remove
mind.
her
Let me
from
tell you what, honey.
the system.
Okay. Thank you, Your Honor. Wait for him. Yes, he's got it. Okay. He's putting that. Let's just give it a name. Oh, really? Oh, wait, I think I was calling him some.
Wexford, can we have your next arraignment?
I believe CO Spino is bringing him as we speak.
Thank you.
Yeah, good timing. Have a seat, sir.
Person at the jail, what is your name?
Ethan Hill.
Mr. Hill, do you have a mailing address?
I don't.
you have a telephone number?
I don't.
Do you have an email address?
No.
Your Honor, perhaps I can intervene. Mr. Hill was only recently released from jail.
About 45 seconds, it looks like.
Yeah, I did have an opportunity to meet with her, so good, Judge.
All right, well, we're waiting for them. Who do you have in the Wexford jail?
Heaven Follett.
All right. Are we ready?
Yes.
These are the cases of the people of the city of Cadillac versus Heavenly Gillette, case numbers 25-12550T and 25-1608OT. We're here for Raymond. Ms. Follett, what is a good mailing address for you?
914 Second Ave, apartment B, Cadillac, Michigan.
Apartment what, I'm sorry?
B.
E is an elephant?
B.
B is in boy.
E is in boy?
Never speak.
Okay. And that's Cadillac?
Yes.
Do you have a good telephone number?
231-337-0193.
How about an email address?
Heavenly24@icloud.com.
And because you're with a public defender, I assume you've had the opportunity to meet with a public defender today?
Yes.
That's true.
As I said, I have two files. In case number 25-12550T is alleged that on April 7th, 2025, in the city of Cadillac of Wexford County, that you did operate a motor vehicle without security or insurance. That is a misdemeanor punishable by not more than 1 year or less than $200 or more than $500. In case number 25-1608OT, it is alleged that on April 27th, 2025, here in the city of Cadillac of Wexford County, it is alleged in count number 1 that you operated a motor vehicle while without security. That again is a penalty with a fine of not more than $200, no more than $500, and or 1 year in jail. In count number 2, it's alleged that you did operate a motor vehicle with no license or expired license. That is a fine of not more than $500 and or a 90 days in jail. Do you understand those charges and the potential penalties?
Yes.
You read and sign an advice of rights form at the jail, talk about your rights to an attorney and your rights to a trial.
Yes.
Did you understand those rights?
Yes.
You have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes.
Do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
And,
Do you want a public defender? Do you want to defend yourself?
public defender.
What is your current source? What is your current source of income?
Is it muted on your laptop?
I don't know.
You're unemployed?
Yes.
How do you support yourself?
I just do, I babysit, but that's it.
The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea and will set the matter for a pretrial. The pretrial is a hearing that's held here in the district court in which the prosecutor and your attorney will get together to say if there is a way to resolve the case short of going to trial. You also have a right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. In counsel, so everyone's aware, I do not show any prior history, but in 25-12550T, I show 2 failed to appears, one from April 24th and one from May 15th. And then in 25-16080T, I show a fail to appear on May 15th. Mr. Harrison, any comment regarding bond?
Well, yes, Your Honor, she does live locally. This is a wake-up call for her. She certainly had no idea that she could be apprehended as a result of her not appearing on those court dates, and she won't do that again. Available for future court dates. She's a good candidate for PR.
So she could walk to the courthouse, just chose not to. Is that what I'm
She
hearing?
just, yeah, go ahead.
I actually did, oh, sorry. I didn't
Go
get anything in the mail because I had two addresses for it, or this is my,
Yeah, there may have been an address problem as far
And
as
then-
why she didn't get the notice.
I put off calling and then it just left my mind. I just forgot to call and check out, see what they do.
So when you got your second ticket for operating without security, the first thing, I mean, the same thing you got a ticket for 20 days before, it didn't ring a bell that you're supposed to appear in court?
I didn't know first, I don't know a lot about anything to do with court or like, citations or tickets. But the officer that gave me my first one, I couldn't read it at all. And I was gonna just call and see what it was supposed to say. Like I couldn't read his handwriting. And he explained, he said, just call this number, blah, blah. I couldn't read the number, but I was gonna call the courthouse anyways to figure it out. And then I just put it off and never did. When I got my second one, that was on my birthday at almost midnight. So I did not call right away.
Okay, any comment from the public defender's, I'm sorry, from the prosecutor's office?
Thank you, Your Honor. I do understand that the defendant is quite young and doesn't have any prior criminal history, but given the two prior failure to appears on this case, I do think a small monetary bond might be appropriate, but I'll leave it up to the discretion of the court. Thank you.
Ms. Follett, have we grabbed your attention now? Is there anything that's going to stop you from appearing if I were to release you without posting
No.
bond? And how do you plan to get to the courthouse?
Walking or the bus.
Bus, okay.
All right. The court is not impressed with your performance so far, but I am willing to take a chance with you. I will release you on a PR bond. You are to appear as ordered, to keep your contact information current, not leave the state without permission, and to commit no new crimes. No new crimes includes operating a motor vehicle without insurance or driving without a license. Do you understand that?
Yes.
If you are found in violation of your bond, you could be arrested without a warrant, brought back to court, and have your bond revoked. Do you understand that?
Yes.
Before you leave the court, or before you leave jail today, you'll be receiving your next court date. Make sure you pay very close attention to that court date, because next time I'm not going to be as lenient. Okay. All right, Wexford next to Raymond, and person at Grand Traverse, you're Rebecca Reed.
Yes, Your Honor.
This is the people of the state of Michigan versus Rebecca Jean Reed, case number 25896 ST. Time and date set for an arraignment. Wexford Jail is Mr. Harris. There it is. All right. Ms. Reed, what is a good mailing address for you?
I do not have one at this time.
Do you have a telephone number? All right, court next calls the people of the state of Michigan versus Chad Eric Farrell, case number 241696 SM. Appearances, counsel?
Joanna Carey for the people.
Robert Hartel from Mr. Farrell joins me at the table, Your Honor.
And we are here for a probation violation. And it is alleged that he was in violation of the may not possess alcohol condition of probation by possessing alcohol on 5/26/25 as reported by the Michigan State Police. The defendant currently has 11 prior technical violations, so this would make technical violation number 12 if found guilty of that. Mr. Hartel, how are we proceeding today?
With my client, he wished to do an admissions today.
Is that true, Mr. Farrell?
Yes, Your Honor.
All right, you both may have a seat. And Ms. Carey, is there any objection to that? All right, Mr. Farrell, will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Then to the allegation that you violated your probation by possessing alcohol on May 26th of this year as reported by the Michigan State Police, how do you plead?
Plead guilty, Your Honor.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So were you on probation with this court back on May 26th?
Yes, Your Honor.
And you can have a seat. And as condition of your probation, were you prohibited from possessing alcohol?
Yes, sir.
And on May 26th of this year, did you have interaction with the state police?
Yes, sir.
And during that interaction, was it discovered that you possessed alcohol?
Yes, sir.
And where was it that you were in possession of that alcohol?
I was in Save Lot parking lot, sir. I was cutting over some River Road. I was hanging left going home, Coach Curry Street, and he stopped me. And, I think I was too close to the center line and I was turning, but he stopped me there and he just searched my bag and I had 4 bottles, I believe, little bottles of alcohol.
Were you driving a car or
I was riding my electric bike, sir.
your electric bike? Okay, and he stopped you for being too close to the center
Center
line?
line. I was getting ready to turn, he was passing me on River Road and I was getting right here, getting ready to turn to Save Lot.
Okay. And you said 4 little bottles of
Yes,
alcohol, so like the shooter bottles?
Yes, sir.
All right. Do counsel believe that the defendant, well, let me first ask you, Mr. Farrell, has anybody promised you anything in order to get you to plea today?
No, sir.
Has anybody threatened you?
No, sir.
Are counsel aware of any other promises, threats, or inducements that have not been made part of the record?
I'm not. No, Your Honor.
Do counsel believe that the defendant has provided a factual basis in which to accept the plea?
Yes. Yes.
I agree, Mr. Farrell, I find you guilty of violating your probation. Make 12 technical violations. In particular, I show by your own admissions, you knew you were on probation, you knew that you were not to possess alcohol, and that you had possessed alcohol. Has everybody received Ms. Bismack's recommendation in this case?
I have. Yes, sir.
And I have also received a letter dated yesterday from Family Supportive Services of Northern Michigan. Ms. Carey, have you received that?
I did.
Mr. Hartel?
Yes, sir.
All right. Ms. Bismack, before we go into allocution, has your recommendation changed at all?
No, Your Honor.
All right. Mr. Hartel?
Yes, Your Honor. I would ask the court to adopt the recommendation of Ms. Bismack. I do realize that 12 is a large number, but I do believe that would still be appropriate in the nature of this particular situation. He knows he's not supposed to possess, and that's the term that he violated. For whatever weight it may have to the court, he did test the zeros. He had no intent, based on what he told me, to consume it himself. It was for his girlfriend. That's not a legal excuse, just for some context so the court understands. I have had, I'll call it a firm heart-to-heart with him, reminding him not to do that and why. If the court's able to adopt the recommendation of this Bismack, I don't doubt that he'll be very grateful and obey the terms of that. I am proud of him for starting some of the counseling he is doing. I'm glad that the court took the time to look that over to see that he is doing that. I do believe that him focusing on doing those positives can do just as much as, and perhaps even more than if we just put him in jail for a few days. And I ask the court to do it that way. Thank you.
Thank you. Ms. Carey?
Thank you. I am going to ask the court not to follow the recommendation. You can ask for a jail sentence. I think this court has been more than patient and more than accommodating to Mr. Farrell. He was directed to grief counseling. based on what he told Judge McNulty at the time of his original sentencing almost a year ago, in July 2024. This is his 12th probation violation. He is, I don't know, he's in possession of alcohol. Mr. Farrell knows the rules. This is not new to him. And looking at the letter from Family Supportive Services, he went 3 times since March. The way that it was, before that, he only had 4 at Paddock. So he's gone 7 times in 11 months. I don't think that's taking it seriously. I don't think he's dealing with what he needs to deal with. I think the probation department, frankly, has been more than patient as well. So I would ask for a straight jail sentence. Thank you.
Mr. Farrell, you have the right to address the court when it comes to sentencing. Is there anything you would like me to know?
Sir, I'm very sorry. I know, and I'm down to 3 months. I'm supposed to go to counseling once every 3 months. And that was recommended by Dave, my counselor. And I did not mean, I was stupid on possessing alcohol with my girlfriend. I was done with me. I was on from work. I should not have done it. Since then, I've learned I have not, thanks to the course, I have been sober for over a year now on alcohol. I've not had no dirty drug or alcohol test. I've maintained employment, Your Honor. I'm feeling good about things. I really am. I'm very sorry. I told my girlfriend, don't ask me ever to buy alcohol again. But she agreed, will not. With that, Your Honor, I'm very sorry to Miss Carrie and everybody that I've offended over this process, Your Honor. And I did not mean to make a mockery of this court. I do this court very seriously. So with that, sir, I'm sorry.
Mr. Farrell, why would you risk so much just to go get your girlfriend alcohol?
I wasn't thinking, Your Honor. I was tired. I went home from work and just, will you pick this up for me? And along with the alcohol, I wasn't even thinking. I got toilet paper, alcohol, cat food, whatever. But yeah. I just wasn't thinking. It was stupidity in my own thoughts. You never done it. I've been sober over a year now for alcohol goes May 30th, I think, for my last drink. And I said, thanks to the court. It did take a little push to get me going. And I did realize, I mean, I'm not getting any younger. This past year has been great. I have not screwed up anymore except my violations. There was stupidity on my own part. I got the marijuana situation taken care of finally. That has been for a while now. And then with that, sir, I will never purchase alcohol again for my girlfriend. I'm a church attorney for drinking, actually.
I'm trying to remember, I know your previous violations were testing issues, right? We didn't have, or we did have positive marijuana tests. Has he since got his, Mr. Farrell, you can have a seat. Has he gotten his medical card now?
Yes, Your Honor.
And is it true that there have been no positive alcohol tests?
That is correct.
How often is he being tested?
One to 2 times per month.
And last time we extended probation 6 months, right? So that puts us out to January of 26. Ms. Carey, is it true he was stopped for being too close to the center line?
No,
You don't have a police report.
He went to the center of the roadway, rode at the wrong lane of travel before riding down the center of the eastbound lane. He stopped at the intersection of Simmons and River Street and waited for me to pass and then turned onto North Simmons. I stopped in this same lot parking lot for the violation.
Mr. Farrell, where were you coming from?
Speedway parking lot.
Speedway.
Yeah,
Okay.
and the alley right there.
So you went about half a block.
It looks like he was on a bicycle.
I was on my electric bike, sir. I probably took the turn a little too wide coming out, I'm sure of it, but I seen him come, he was coming this way, I seen him, so I stopped there, I was gonna turn left.
All right. Mr. Farrell, you put the court, as you did last time, in a quandary. I mean, I specifically remember your last time you were here, and I asked you not to make me regret my decision on keeping you on probation. I mean, 11 prior violations is almost heard of that I would keep somebody on probation. And now we're on number 12. I will say it's to your credit that you blew zeros when you blew. And as Ms. Bismack states, you've not had any positive alcohol tests while on probation. We did have that marijuana issue, but I understand you've got that worked out now with a card. It just seems so bizarre to me. I understand the request to get alcohol, but number one, shame on you for saying yes. You knew you're not to possess alcohol. And number two, double shame on your girlfriend. That is a setup waiting to happen. And in the back of the court's mind, I can't help but wonder, were you going to consume that night?
I wasn't.
You've been on probation quite a bit throughout your life, right? How often have you completed probation successfully?
Once, maybe twice, no, I think, it was felony.
So even though we're on violation number 12, it appears that this seems to be the best you've been doing on probation.
I do want to do successfully, I really do.
Then why would you do it?
I don't know, sir, I really don't. I really don't. If I take back that night, I would.
I mean, you racked up enough violations now that I could put you in jail for the entire term of your sentence, or your charge, you understand that? So be honest with me, do you honestly think that you can complete probation successfully?
I do, sir.
Because the last thing I want to do is set you up for failure and have you continue to violate and then eventually wind up in jail.
No.
Which I'm telling you, if I do keep you on probation, the next violation will probably be a termination and you sitting in for the full period that I have available to me.
I want to do successfully, sir. I don't want to see you.
When were you put on counseling for every 3 months? Because it looked like the letter that you gave me, you were going quite regularly.
Once every 3 weeks.
Oh, 3 weeks, I'm
Yes.
sorry.
Yep.
So what happened to, and I realize this isn't part of the violation, but it was submitted for me to consider. Looks like you attended on March 17th, March 31st, April 17th, and June 12th. What happened to May?
Man, I thought about once in May, and then he was out and he rescheduled me and stuff. I didn't say, oh, I think it's one time in May, Your Honor.
Not in the letter.
Okay, good.
The letter says that you were seen on March 17th, March 31st, March 17th, and your next scheduled appointment is on June 12th.
Yeah, no, I could have planned May.
Mr. Farrell, Mrs. Carey is correct. By all intent and purposes, you should be done. I mean, you should be sitting in jail. And if this was the dumbest excuse I've heard of a violation. I am going to follow the recommendation of the probation department. This is gonna be the last time I do this. And I can see the look on Ms. Carey's face, and I'm wondering myself why I'm doing this. But I'll be honest with you, I think I see a spark of potential. And I would like to see that spark go to a flame. I'd like you to prove us all wrong, that you can do this. So I am going to continue probation. I am going to add additional alcohol testing. I will leave that at the discretion of Ms. Bismack as to how often she wants to do that. And for how long? Total on this case, there is it's like 5 days jail with 5 days credit.
There's 4.
There's 4. Yeah, I'm sorry, 4. 4 days jail with 4 days credit. Mr. Farrell, this is your last shot. Do you need him to report today, Ms. Bismack?
Yeah.
Mr. Farrell, go back out the front window where you checked in. You can get a copy of the order and then go down and check in at probation.
Maybe a translator zooming in soon as well.
Yeah, I've been looking, but not yet.
When they do, I think Robbie's is going to be on there as well, and that's be part of the breakout room.
Okay. Is this on the docket for today? I don't see it.
No.
Aiden Paris. This is the people of the state of Michigan versus Aiden Daniel Paris, case number 251606 SD. Appearances, counsel.
Robert Hertel from Mr. Paris, who joins me at the table now.
And it looks like we are here for a sentencing on a plea that was taken to operating while intoxicated back on May 21st of this year. We set it aside for a substance use assessment. I have actually received 2 substance use assessments, both dated the same day. Has counsel received at least one of those? Is this on the docket for today? I don't see it.
No.
Aiden Paris. This is the people of the state of Michigan versus Aiden Daniel Paris, case number 251606 SD. Appearances, counsel.
Robert Hertel from Mr. Paris, who joins me at the table now.
And it looks like we are here for a sentencing on a plea that was taken to operating while intoxicated back on May 21st of this year. We set it aside for a substance use assessment. I have actually received 2 substance use assessments, both dated the same day. Has counsel received at least one of those?
Yes, Your Honor. I believe Mr. Brian Henniger sent the second due to us being told it was the corrected version. As far as I could tell, there was maybe some small typographical corrections, but nothing of content.
All right, I could not tell the difference, so that's possible. All right. Do either counsel have any corrections to that assessment?
I do not.
Nor do we.
Allocution, Mr. Hartel?
Yes, thank you, Your Honor. I would ask the court to factor in that, to my knowledge, my client has done well on bond. I don't doubt that if given supervision, he would do well on that as well. I do realize the assessment does say that my client does have a problem with alcohol. I don't believe anyone here is going to deny that to be correct. But he does have strong moral support with him in the courtroom. I don't doubt they will continue to be strong support with him throughout any term of probation, the same way they were while he was on bond. I will, as a positive in the report, say towards the back, it does show that he's not going through any major withdrawal symptoms. I'd say that's true based on my experience with him. I don't doubt the court and people have seen some people are the opposite, and it's a really harsh situation. So I do believe he has an advantage when it comes to that. I do believe that he also is highly motivated by the fact that while being in court on multiple times, he's seen what happens when people do well on probation and bond, and he's seen the opposite. In fact, he just no doubt got a lesson a second ago about how the court can both be graceful and yet can also be very firm when you need to be. I would ask the court to give him that chance on probation. I really, truly do believe he'll complete successfully. I don't think we'll see him for a single violation. Thank you.
Ms. Carey.
Thank you. Hi, 0.191 on the tax bill. He was pulled over driving down US 131 without a driver's side wheel, throwing sparks on the highway and failing to maintain his lane. And I have concerns about the substance use assessment. He doesn't just have a problem with alcohol. It indicates he has a severe alcohol use disorder. I have concerns that he reports he has never been able to keep a job due to lack of motivation, yet he has one child. And he's only 22 years old. So frankly, I'm tempted to ask for at least a short jail sentence with a long term of probation. To make sure that maybe he can find some motivation and get some help with his alcohol use disorder, because it's dangerous. If you put a lot, it's dangerous. I want to what his behavior and looking at his record, 2 domestic violence and leaving the scene of an accident while under the influence in his past. So something needs to grab his attention.
You have leaving the scene of an accident?
That's what he reported to the
Oh, yeah, right. Yeah.
alcohol assessment. So I would ask the court for that statement.
Mr. Parrish, you have the right to make a statement before sentencing. Is there anything you'd like me to know?
Yeah, I apologize. I dug myself into a big hole, and it took being sober and being on the sober link to really, having a good job. I just got a good job. I had lost my job due to my incarceration because of this. And now that I have a good job and being sober actually really feels well right now. I feel more alive than I ever have. And I just got caught up on my child support payments not too long ago, and I really don't want to get far behind on those again. So I'm sorry.
Do you have a new job?
Yeah.
And where is that?
I work at Ford Warner.
Ford Warner?
Yeah.
Are you hired in there or on a temp?
I'm on a temp for right now.
Okay. And when did you start that job?
I just started it not 2 weeks ago.
Okay.
Yeah.
And the assessment said you were at Hudson. Is that Hutchinson?
I was at Hutchinson. Yeah.
Okay. How long had you been at Hutchinson?
I was only there for like 4 to 5 months.
I have to say, Mr. Paris, I haven't been a judge very long, but I was prosecutor and a defense attorney before that. You have probably the most honest assessment I have ever seen. For you to actually say that you have lack of motivation, I don't think I've ever seen that before. And I've read in here the reasons why you drink. I can tell you that those are not reasons to drink. That only makes the feelings worse. And, certainly drinking is not going to improve your relationship with your daughter. Have you started any type of counseling at all?
I just started like 2 weeks ago with CHS. So
And how are you finding that?
It's good. It's good to be able to talk to somebody about everything for sure.
Are you doing one-on-one sessions or group sessions?
Through Zoom right now.
Okay, but they're one-on-one?
Yes.
Okay. Have you had the opportunity to review this assessment?
A little bit, yes.
The parts that you looked at, what are your thoughts on what it says?
Honestly, I just I want to help myself, you know, any way I can, so I can be the father that my daughter deserves, so.
Well, and while that's a good goal, number one's got to be you right now. I mean, you can't be the daughter or the father your daughter deserves without making sure that you've checked all the boxes for yourself. And so Ms. Carey's right. There's some concerning things here. And one question I did have, you know, you said in the assessment, or at least the assessment says after leaving the bar, your tire fell off and the police pulled you over. Well, the question I had, and Ms. Carey clarified that, is did they pull you over or did they stop to assist? And it sounds like you were actually driving down the road, missing a wheel, and you didn't know that.
Oh, I knew I just was trying to get closer to where I was living at, and then I was gonna pull over and call somebody to come get me.
Okay.
Yeah, I was, yeah.
So how far did you drive without a wheel?
I don't know, not, just a few miles.
Okay. And
Yeah.
was this on the expressway or? And Ms. Carey shaking her head, yes.
Yes.
Was it the front wheel or the rear
It was
wheel?
the rear wheel.
Ms. Carey, what time of day or night was this?
It's like it's about 2:20 a.m.
In the morning? How far, where were you coming from?
I had just left the bar.
Which bar?
I don't even remember what it was called, to be honest.
Was it here in Cadillac?
Yeah,
And roughly how far had you driven?
like 3-4 miles before I got pulled over. My wheel had fallen off like a mile before I had gotten pulled over.
I'm going to say something and I don't want you to take it the wrong way, but to drive a mile with no wheel at a .208, that's pretty impressive. And I'm not saying that in a good way. The fact that you were at a .208 shows that, and your assessment would show this as well, you're a very experienced drinker. You're 22 years old and show severe. You know, there's 4 ways that you can test, and you're at the very, very top of that. Do you understand that? And so, you know, on one of the screening assessments, a score of 4 or more indicates a need for full intervention. You scored 9. And then some of the other ones that I'm not going to address by name, but you scored very high on those as well. In your past, you self-reported a failed to report an accident. That does not show in your CC8, your criminal history, or at least the copy I have. But what does show is the 2 domestics, and then a fail to appear out of the 61st District Court from March for an open intox. I don't know if alcohol had anything to do with the domestics, but clearly this is not the first time you've been at least attempted to brought to court on an alcohol related offense. Have you done anything to take care of the one down in the 61st?
When we had talked, when I got arraigned the first time, you said that was the first thing you wanted me to take care of. And he waived the warrant, but I just got a call from Vernon there, the probation office, and they said that something happened with the judge there, and I wouldn't have court with them until August, and then just to let him know what happened with everything that was going on after this.
Okay. how many, so I had placed you on random testing. Are you actually doing the random testing or are you doing the daily testing?
I'm doing the daily testing.
Okay, how many times a day are you blowing?
3.
Are you finding that helpful?
Yes, I am.
How are you finding not consuming alcohol? Are you having a struggle with that?
No. This is frightening. It's been really scary. This is it's a real eye opener for me. So yeah.
Okay.
I don't wanna.
Do you think continuing with a daily blow machine is going to be beneficial for you?
Yes.
All right. All right, based on the defendant's history and how he tests for a severe disorder and the allegations as presented by Ms. Carey, I do find that it would be appropriate for probation for you. I'm going to put you on a period of probation for 24 months. That's the longest period I have. But because of the type of offense this is, you are eligible for early release. So if you've done everything we've asked you to do, you are eligible to be released at halftime, which will be 12 months. During that time, you're not to violate any law. Report is ordered. Not leave the state of Michigan without the consent of your probation officer. Keep your contact and employment information current. I'm going to order that you attend the alcohol highway safety education class and the victim impact panel. Consume no alcohol, no illegal drugs, including recreational marijuana. I'm going to order that you continue the daily testing for 60 days. All right. Now the cost for that will be cheaper. I think it's basically cut in half.
Okay.
And then I'm going to order you to be subject to testing pursuant to the terms of your probation officer.
All right.
You are to follow the substance use assessment recommendations. No bars where the primary source of alcohol or the primary source of business is the sale of alcohol. Restaurants that serve alcohol are fine, just no bars. No alcohol or illegal drugs where you reside. I'm not going to order that you attend a recovery program, but I highly encourage you to look into it. I'm going to order that you continue counseling. That's going to include drug and alcohol counseling if your probation officer determines it's necessary, and any additional programming that she believes will be beneficial. There is a $75 crime victims' rights fee, a $50 state minimum fee, a fine of $250, $150 court costs, $150 attorney fee. I'm only going to charge you for the 12 months of probation. So if you get off early, you're done. But if you don't and you have to stay on longer, you'll be required to pay a monthly probation fee. So that's $360. Ms. Carey, law enforcement or prosecutor fee?
Both, please. 100.
$100 prosecutor fee. And what agency was this?
Sure.
I believe that's $100 as well.
Thank you.
1 day jail with 1 day credit. That means you've served your time. If any balance remains unpaid for more than 56 days, there's a 20% penalty that gets assessed to that. And technically, because I did sentence you to a term of jail, even though it's time served, you do have the right to appeal that decision. If you decide that you want to appeal it and can't afford an attorney to assist you with that, you have 14 days from today's date to request the appointment of an attorney. Do you understand that?
Yes, Your Honor.
Mr. Paris, I hope you're truly honest when you say this has been an eye-opening experience. I think it's been eye-opening for a lot of us here. You have good insight as to why you're drinking the way you are. Again, as I said, this is one of the most honest assessments I think I've ever seen. So don't let this be a setback. Let this be a stepping stone. Learn from this and move on. I don't want you to put it behind you, but I want you to be able to move on from this.
Thank you.
All right. Go back out to the front window where, I'm sorry, Ms. Carey, anything in a judgment of sentence I missed? Mr. Hartel?
No, thank you.
Mr. Paris, go back out to the front window where you checked in, get a copy of your judgment, make payment arrangement if you're able to do that. And then you'll need to go downstairs and get signed up for probation.
Thank you.
All right, thank you. Person on the Samsung, what is your name?
My name is Fazia Rasool. I'm an interpreter for Mr. Kulwaran Singh.
Okay, I'm going to put you into a breakout room with Mr. Gurmurthy. He's the attorney on the case, so give me just a moment to do that.
Yes, Your Honor. Thank you.
Mr. Hartel?
No, thank you.
Mr. Paris, go back out to the front window where you checked in, get a copy of your judgment, make payment arrangement if you're able to do that. And then you'll need to go downstairs and get signed up for probation.
Thank you.
All right, thank you. Person on the Samsung, what is your name?
My name is Fazia Rasool. I'm an interpreter for Mr. Kulwaran Singh.
Okay, I'm going to put you into a breakout room with Mr. Gurmurthy. He's the attorney on the case, so give me just a moment to do that.
Yes, Your Honor. Thank you.
Court next calls the people of the state of Michigan versus Orlando Gonzalez Jr. This is case number 251222 SD. Appearances counsel.
Nick Carnes on behalf of the people.
Thank you, Honor. Taylor and on behalf of Mr. Gonzalez, who's present in the courtroom to my right.
All right, and we are set for a, what do we got going here? We've got a sentencing and a show cause. Am I correct on that?
Yes, sir.
And so the sentencing would be to a plea that was taken on May 22nd, 2025 to operating while intoxicated. We'd set it aside for Okay, court next calls the people of the state of Michigan versus Kulwaran. Mr. Gurmurthy, how do you pronounce the last name?
It would be, first of all, it would be Kulwar, last name would be Singh.
Singh. I'm sorry for that. Appearances counsel.
Joanna Carey for the people.
Thank you, Reverend Gurmurthy, on behalf of Mr. Singh, and he's here seated to my right as well. Then we have Ms. Rasool, who's going to translate.
All right. If I didn't say it, this is case number 25907 ST. We're here for a plea, and I assume a sentencing. Is that correct, Ms. Carey?
Yes.
All right. Translator, could you please state your name for the record?
Sure. My first name is Fazia, Fozia. Last name is Rasool.
Could you pronounce your last name for me?
Rasool, Rasool. Fazia Rasool.
Okay, I just want to make sure I had that correctly. Ms. Rasool, are you a certified language interpreter or qualified, I mean?
I'm assigned by my by the company certification. I don't know, but they assign me and I know the language.
Okay, so I'm going to have some questions to ask you. Give me just a moment.
Sure.
Will you please raise your right hand? Do you
Yes,
swear or
Father.
affirm that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, I do, Your Honor.
And do you have training or credentials as an interpreter in Michigan? You can put your hand down.
Yes, I've been doing interpreting for almost 6 years.
And what is your native language?
Punjabi and Urdu.
All right. And you obviously understand the English language?
Yes, I do.
And can you interpret simultaneously?
I'm trying my best.
Okay, all right. Do either counsel have any concerns with her qualifications?
I don't either, Judge.
All right. Ma'am, will you please raise your right hand? I have another oath for you.
Sure.
Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications to the best of your ability, translating English to Punjabi and Punjabi to English?
Yes, I do, Your Honor.
All right, you may put your hand down. Ms. Carey, what is the plea agreement?
As charged, Your Honor. No contest as charged.
Can you speak up so she can hear you and translate that?
I will. It's my understanding the defendant will plead no contest to count 1, moving violation causing death.
ਮਿਸਟਰ ਸਿੰਘ ਉਹ ਕਹਿ ਰਹੇ ਨੇ ਕਿ ਜਿਹੜਾ ਅਸੀਂ ਡਿਸਕਸ ਕੀਤਾ ਸੀ ਕਿ ਤੁਸੀਂ ਇਹਨੂੰ ਕੋਈ ਵੀ ਕੰਟੈਸਟ ਨਹੀਂ ਕਰਨਾ ਤੇ ਜਿਹੜਾ ਤੁਹਾਡਾ ਮੂਵਿੰਗ ਵਾਇਓਲੇਸ਼ਨ ਹੋਇਆ ਜਿਹਦੀ ਵਜ੍ਹਾ ਤੋਂ ਕਿਸੇ ਦੀ ਜਾਨ ਗਈ ਹੈ
And the reason for the no contest plea?
ਕਹਿੰਦੇ ਨੇ
Go ahead.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਵਜ੍ਹਾ ਅਸੀਂ ਪੁੱਛਣੀ ਹੈ ਕਿ ਇਹਦੀ ਵਜ੍ਹਾ ਕੀ ਹੈ ਕਿ ਤੁਸੀਂ ਕੰਟੈਸਟ ਕਿਉਂ ਨਹੀਂ ਕਰਨਾ ਚਾਹੁੰਦੇ
Civil liability.
I'm sorry if she can say a little bit louder because I can't hear.
Civil liability.
ਹਾਂ ਕਹਿੰਦੇ ਨੇ ਕਿ ਤੁਹਾਡੇ ਤੇ ਜਿਹੜੀ ਹੈ ਨਾ ਲਾਇਬਿਲਿਟੀ ਪੈ ਜਾਵੇਗੀ ਹੋਰ ਤੁਹਾਡੇ ਤੇ ਜਿਹੜਾ ਨਾ ਜ਼ਿੰਮੇਵਾਰੀਆਂ ਪੈ ਜਾਣਗੀਆਂ ਜਿਹੜੀ ਕਿ ਸਿਵਲ ਲਾਇਬਿਲਿਟੀਜ਼ ਜਿਹਨੂੰ ਕਹਿੰਦੇ ਤੁਸੀਂ ਇਸ ਵਜ੍ਹਾ ਤੋਂ ਨਹੀਂ ਕੰਟੈਸਟ ਕਰ ਰਹੇ
Mr. Gurumurthy?
I would agree with those statements as to the plea and as to the reason for the no contest.
Ms. Razul?
Yeah, ਉਹ ਤੁਹਾਨੂੰ ਤੁਹਾਡੇ ਵਕੀਲ ਨੇ ਤੁਹਾਡੇ ਨਾਲ ਆਲਰੇਡੀ ਜਿਹੜੀ ਸਾਰੀ ਡਿਸਕਸ ਕਰ ਲਿੱਤੀ ਗੱਲ ਉਹ ਹੀ ਕਹਿ ਰਿਹਾ ਕਿ ਮੈਂ ਉਹਨਾਂ ਨਾਲ ਸਾਰੀ ਗੱਲ ਡਿਸਕਸ ਕਰ ਲਿੱਤੀ ਹੈ
Mr. Singh, have you heard what the attorneys have said the resolution is?
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮਿਸਟਰ ਸਿੰਘ ਤੁਸੀਂ ਜਿਹੜੀ ਵੀ ਤੁਹਾਡੇ ਜਿਹੜਾ ਅਸੀਂ ਜਿਹੜਾ ਹੱਲ ਕੱਢਿਆ ਹੈ ਉਹ ਤੁਹਾਨੂੰ ਤੁਹਾਡੇ ਅਟਰਨੀ ਨੇ ਤੁਹਾਨੂੰ ਸਮਝਾਇਆ ਹੈ ਤੁਹਾਨੂੰ ਸਮਝ ਆ ਗਈ ਹੈ
And is that how you wish to resolve the matter?
ਕਹਿੰਦੇ ਨੇ ਤੁਸੀਂ ਇਸ ਤਰ੍ਹਾਂ ਇਸ ਮਸਲੇ ਨੂੰ ਹੱਲ ਕਰਨਾ ਚਾਹੁੰਦੇ ਹੋ ਉੱਚੀ ਆਵਾਜ਼ ਨਾਲ ਕਹਿ ਦਿਓ ਨਾ ਹਾਂ ਕਹੋ ਜਾਂ ਨਾ ਜੋ ਤੁਹਾਨੂੰ ਸਮਝ ਆ ਰਹੀ ਹੈ He's saying yes, he got it.
We are also here for a bond violation show cause.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਅਸੀਂ ਇੱਥੇ ਜਿਹੜੇ ਆ ਨਾ ਜਿਹੜਾ ਬੌਂਡ ਹੈ ਨਾ ਉਹਦੀ ਵੀ ਸ਼ੋ ਕਾਜ਼ ਵਾਸਤੇ ਗੱਲ ਕਰਾਂਗੇ ਕਿ ਕੀ ਬੌਂਡ ਕਿਹੜਾ ਭਰਨਾ ਪਏਗਾ
Ms. Carey, is there any resolution to that as part of the plea?
I believe that.
Hold on.
Defendant will.
Hold on.
I always forget.
Can you interpret that, please?
ਹਾਂਜੀ ਉਹ ਪੁੱਛ ਰਹੇ ਨੇ ਦੂਸਰੇ ਅਟਰਨੀ ਨੂੰ ਪੁੱਛ ਰਹੇ ਨੇ ਕਿ ਤੁਸੀਂ ਜਿਹੜਾ ਬੌਂਡ ਦੇ ਮੁਤਲਕ ਜਿਹੜੀ ਗੱਲ ਕਰਨੀ ਹੈ ਉਹ ਤੁਹਾਨੂੰ ਪਤਾ ਹੈ
It's my understanding the defendant will provide an explanation.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਤੁਹਾਨੂੰ ਐਕਸਪਲੇਨ ਜਿਹੜਾ ਨਾ ਕਰਨਗੇ ਜਿਹੜਾ ਅਟਰਨੀ ਉਹ ਐਕਸਪਲੇਨ ਕਰੇਗਾ ਇਹਦੇ ਬਾਰੇ ਚ
So we'll plead the violation with an explanation?
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਿਹੜਾ ਜੋ ਤੁਹਾਡੀ ਪਲੀ ਹੈ ਉਹਦੀ ਤੁਹਾਨੂੰ ਜਿਹੜਾ ਹੈ ਤੁਹਾਨੂੰ ਸਾਰੀ ਡਿਟੇਲ ਜਿਹੜੀਆਂ ਨੇ ਉਹ ਤੁਹਾਨੂੰ ਐਕਸਪਲੇਨ ਕਰ ਦਿੱਤੀਆਂ ਤੁਹਾਡੇ ਵਕੀਲ ਨੇ
My understanding is we'll leave it up to the court to just determine whether that explanation will lead to a violation or not.
Can you were you able to hear that?
Yeah, I'm trying. I'm sorry if somebody can say it a little bit
Why
louder.
don't counsel come up closer to the microphone?
Ms. Rasool, I said that Mr. Singh would provide an explanation and Judge Wiggins would then determine whether that explanation would suffice for him to accept that, whether it's a violation or not.
ਹਾਂਜੀ ਮਿਸਟਰ ਸਿੰਘ ਉਹ ਕਹਿ ਰਹੇ ਨੇ ਕਿ ਜਿਹੜੇ ਜੱਜ ਸਾਹਿਬ ਨੇ ਉਹ ਤੁਹਾਨੂੰ ਦੱਸਣਗੇ ਕਿ ਤੁਹਾਡੀ ਜਿਹੜਾ ਨਾ ਤੁਸੀਂ ਪਲੀ ਜਿਹੜਾ ਕਿਉਂ ਨਹੀਂ ਕਰਨਾ ਚਾਹ ਰਹੇ ਹੋ ਇਹ ਤੁਹਾਨੂੰ ਐਕਸਪਲੇਨ ਕਰਨਾ ਪਏਗਾ ਉਹ ਤੁਹਾਨੂੰ ਐਕਸਪਲੇਨ ਕਰਨਗੇ
Mr. Singh, is that your understanding of the bond violation procedure?
Yes, sir.
You interpret that, please?
Yeah, ਉਹ ਕਹਿੰਦੇ ਨੇ ਮਿਸਟਰ ਸਿੰਘ ਤੁਹਾਨੂੰ ਜਿਹੜਾ ਬੌਂਡ ਭਰਨਾ ਪਏਗਾ ਉਹਨਾਂ ਤੁਹਾਨੂੰ ਐਕਸਪਲੇਨ ਸਾਰਾ ਕੁਝ ਕਰ ਦਿੱਤਾ ਹੈ ਮਿਸਟਰ ਸਿੰਘ ਆਵਾਜ਼ ਆ ਰਹੀ ਹੈ
ਹਾਂਜੀ
Yeah, he got it.
All right. Mr. Singh, will you please raise your right hand?
Mr. Singh, ਤੁਸੀਂ ਆਪਣਾ ਹੱਥ ਖੜਾ ਕਰੋ ਸੱਜਾ।
Do you solemnly swear or affirm
ਤੁਸੀਂ ਆਪਣਾ ਜਿਹੜਾ ਨਾ ਬਿਲਕੁਲ ਸੱਚੇ ਦਿਲ ਦੇ ਨਾਲ ਕਹੋਗੇ
that the testimony you give today
ਜੋ ਤੁਸੀਂ ਅੱਜ ਗੱਲ ਕਹਿ ਰਹੇ ਹੋ
will be true and accurate
ਉਹ ਬਿਲਕੁਲ ਸੱਚ ਹੋਏਗਾ, ਸੱਚ ਦੇ ਇਲਾਵਾ ਕੁਝ ਨਹੀਂ ਹੋਏਗਾ।
and the whole truth and nothing but the truth?
ਹਾਂ, ਸਿਰਫ ਸੱਚ ਹੋਏਗਾ, ਸੱਚ ਤੋਂ ਇਲਾਵਾ ਹੋਰ ਕੋਈ ਗੱਲ ਨਹੀਂ ਹੋਏਗੀ।
I need you to speak up.
ਹਾਂ, ਉੱਚਾ ਬੋਲੋ ਤਾਂ ਉਹਨਾਂ ਨੂੰ ਸਮਝ ਆਏ।
ਜੋ ਵੀ ਮੈਂ ਬੋਲਾਂਗਾ ਸੱਚ ਬੋਲਾਂਗਾ, ਉਸ ਤੋਂ ਇਲਾਵਾ ਕੁਝ ਨਹੀਂ ਬੋਲਾਂਗਾ।
Yeah, he's saying whatever he will say, it will be truth, but only the truth.
All right, you may put your hand down.
ਹੱਥ ਥੱਲੇ ਕਰ ਲਓ।
And so I want to back up just a little bit.
ਕਹਿੰਦੇ ਨੇ ਮੈਂ ਥੋੜੀ ਜਿਹੀ ਗੱਲ ਪਿਛਲੀ ਗੱਲ ਕਰਾਂਗਾ।
Mr. Singh, have you heard what the attorneys have said the resolution in this matter is?
ਕਹਿੰਦੇ ਨੇ ਮਿਸਟਰ ਸਿੰਘ ਤੁਹਾਨੂੰ ਸਮਝ ਆਇਆ ਜਿਹੜਾ ਕਿ ਅਟਰਨੀ ਨੇ ਗੱਲ ਕੀਤੀ ਹੈ ਕਿ ਇਹਦਾ ਅਸੀਂ ਕੀ ਹੱਲ ਕਰਨਾ ਹੈ?
ਹਾਂਜੀ।
Yeah, he got it.
It's my understanding that you will plead no contest to count number 1.
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਨੂੰ ਜਿੱਦੋਂ ਤੱਕ ਮੈਨੂੰ ਸਮਝ ਆਈ ਹੈ ਕਿ ਤੁਸੀਂ ਜਿਹੜਾ ਨਾ ਇਸ ਗੱਲ ਨੂੰ ਅੱਗੇ ਨਹੀਂ ਤੁਰਾਉਣਾ ਚਾਹੁੰਦੇ, ਕੰਟੈਸਟ ਨਹੀਂ ਕਰਨਾ ਚਾਹੁੰਦੇ ਹੋ। ਇਹ ਗੱਲ ਠੀਕ ਹੈ?
ਹਾਂਜੀ।
Yes, he said yes.
Moving violation causing death.
ਕਹਿੰਦੇ ਜੋ ਤੁਹਾਡਾ ਜਿਹੜਾ ਤੁਸੀਂ ਆਪਣੀ ਜੋ ਤੁਸੀਂ ਐਕਸੀਡੈਂਟ ਹੋਇਆ ਜਿਹਦੀ ਵਜ੍ਹਾ ਤੋਂ ਕਿਸੇ ਦੀ ਜਾਨ ਗਈ ਹੈ ਉਹਦੇ ਬਾਰੇ ਚ ਗੱਲ ਕਰ ਰਹੇ ਹਾਂ।
ਹਾਂਜੀ।
He got it.
That is a 1-year misdemeanor.
ਕਹਿੰਦੇ ਨੇ 1 ਸਾਲ ਦਾ ਜਿਹੜਾ ਨਾ 1 ਸਾਲ ਦੀ ਸਜ਼ਾ ਹੈ ਇਹਦੀ।
And or a fine of $2,000.
$2,000 ਇਹਦਾ ਫਾਈਨ ਹੈ ਤੇ 1 ਸਾਲ ਦੀ ਸਜ਼ਾ ਹੈ।
Additionally, you will provide an explanation for the bond violation allegation.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਇਹ ਤਾਂ ਤੁਸੀਂ ਐਕਸਪਲੇਨ ਕਰੋਗੇ ਜਿਹੜਾ ਬੌਂਡ ਹੈ ਉਹਦੀ ਵਾਇਓਲੇਸ਼ਨ ਜਿਹੜਾ ਨਾ ਤੁਸੀਂ ਉਹ ਐਕਸਪਲੇਨ ਕਰੋਗੇ, ਤੁਹਾਡਾ ਅਟਰਨੀ ਤੁਹਾਨੂੰ ਦੱਸੇਗਾ।
The reason for the no contest plea
ਜਿਹੜਾ ਰੀਜ਼ਨ ਹੈ ਤੁਹਾਡਾ ਜਿਹੜਾ ਤੁਸੀਂ ਕੰਟੈਸਟ ਨਹੀਂ ਕਰਨਾ ਉਹਦੀ ਰੀਜ਼ਨ ਅੱਗੇ ਗੱਲ ਕਰਨਗੇ।
is to protect you from civil liability.
ਕਹਿੰਦੇ ਨੇ ਉਹ ਜਿਹੜੀ ਇਹਦੀ ਰੀਜ਼ਨ ਜਿਹੜੀ ਹੈ ਉਹ ਹੈ ਕਿ ਤੁਹਾਨੂੰ ਜਿਹੜਾ ਨਾ ਅੱਗੇ ਜਿਹੜਾ ਸਿਵਲ ਜਿਹੜਾ ਨਾ ਤੁਹਾਡੀ ਜਿਹੜੀ ਹੋਰ ਤੁਹਾਡੇ ਤੇ ਜ਼ਿੰਮੇਵਾਰੀ ਪੈਣੀ ਸੀ ਉਹਦੇ ਤੋਂ ਤੁਹਾਨੂੰ ਬਚਾਉਂਦੇ ਪਏ ਨੇ ਇਹ ਕਰਨ ਦੇ ਬਜਾਏ ਕਿ ਤੁਸੀਂ ਇਹਨੂੰ ਅੱਗੇ ਨਾ ਘਸੀਟੋ ਮਸਲੇ ਨੂੰ।
In case you were sued separately for this event.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਇਸ ਵਜ੍ਹਾ ਤੋਂ ਤੁਹਾਨੂੰ ਅਲੱਗਾ ਤੋਂ ਜਿਹੜਾ ਹੈ ਤੁਹਾਡੇ ਤੇ ਜਿਹੜਾ ਨਾ ਕੇਸ ਨਾ ਹੋਰ ਬਣ ਜਾਵੇ, ਕੋਈ ਤੁਹਾਨੂੰ ਸੂ ਨਾ ਕਰ ਲਵੇ ਹੋਰ ਕਿਸੇ ਮਸਲੇ 'ਚ।
By pleading no contest,
ਕਹਿੰਦੇ ਨੇ ਜਿਹੜਾ ਨਾ ਨੋ ਕੰਟੈਸਟ ਕਰਨ ਦੀ ਵਜ੍ਹਾ ਤੋਂ
I will be able to read documents such as a police report or an autopsy report.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਜਿਹੜਾ ਨਾ ਇਸ ਵਜ੍ਹਾ ਤੋਂ ਮੈਂ ਜਿਹੜਾ ਨਾ ਮੈਨੂੰ ਦੁਬਾਰਾ ਤੋਂ ਜਿਹੜਾ ਡਾਕੂਮੈਂਟ ਜਿਹੜਾ ਨਾ ਕਰਨਾ ਪਏਗਾ ਪੁਲਿਸ ਰਿਪੋਰਟ ਦਾ ਤੇ ਜਿਹੜਾ ਆਟੋਪਸੀ ਜਿਹੜੀ ਹੈ ਉਹਦੀ ਰਿਪੋਰਟ ਜਿਹੜੀ ਹੈ ਮੈਨੂੰ ਦੁਬਾਰਾ ਤੋਂ ਕਰਨੀ ਪਏਗੀ, ਵੇਖਣੀ ਪਏਗੀ।
To allow me to determine if a factual basis exists to accept the plea.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਨੂੰ ਉਹਨੂੰ ਦੁਬਾਰਾ ਇਹਨੂੰ ਵੇਖਣਾ ਪਏਗਾ ਕਿ ਜਿਹੜੀ ਜਿਹੜਾ ਨਾ ਤੁਹਾਨੂੰ ਜਿਹੜਾ ਤੁਹਾਡੀ ਪਲੀ ਨੂੰ ਐਕਸੈਪਟ ਕਰਨ ਵਾਸਤੇ ਮੈਨੂੰ ਉਹਦੇ ਜਿਹੜੇ ਜੋ ਹਕੀਕਤ ਵਿੱਚ ਹੋਇਆ ਮੈਨੂੰ ਦੁਬਾਰਾ ਉਹਨੂੰ ਦੁਬਾਰਾ ਰੀਕਨਸੀਡਰ ਮੈਨੂੰ ਵੇਖਣਾ ਪਵੇਗਾ ਦੁਬਾਰਾ।
And for sentencing purposes.
ਹਾਂ ਤੇ ਕਹਿੰਦੇ ਨੇ ਫਿਰ ਜਿਹੜਾ ਸੈਂਟੈਂਸ ਚ ਹੈ ਨਾ ਉਹਦੇ ਮੁਤਾਬਕ ਅਸੀਂ ਕਰਾਂਗੇ।
By accepting a no contest plea,
ਕਹਿੰਦੇ ਨੇ ਕਿ ਇਹ ਜਿਹੜੀ ਅਗਰ ਤੁਸੀਂ ਇਹ ਸਜ਼ਾ ਕਬੂਲ ਕਰ ਲੈਂਦੇ ਹੋ ਕਿ ਤੁਸੀਂ ਨਹੀਂ ਅੱਗੇ ਉਹਨੂੰ ਕੇਸ ਨੂੰ ਅੱਗੇ ਲੈ ਕੇ ਜਾਣਾ,
you are essentially
ਤੁਸੀਂ ਡੈਫੀਨਿਟਲੀ ਇਹ ਗੱਲ ਨੂੰ ਅਗਰ ਤੁਸੀਂ ਐਕਸੈਪਟ ਕਰ ਲੈਂਦੇ ਹੋ ਤੇ ਫਿਰ ਤੁਹਾਨੂੰ ਜਿਹੜਾ ਨਾ ਜ਼ਰੂਰੀ ਹੈ ਕਿ ਤੁਸੀਂ
accepting the consequences without saying you are guilty.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹਦਾ ਜਿਹੜਾ ਨਾ ਤੁਸੀਂ ਫਿਰ ਜਿਹੜੀ ਨੇ ਤੁਹਾਡੇ ਤੇ ਤੁਸੀਂ ਉਹਦੇ ਸਾਰੇ ਜਿਹੜੇ ਨਤੀਜੇ ਨੇ ਨਾ ਉਹ ਤੁਸੀਂ ਜੋ ਵੀ ਹੋਏਗਾ ਉਹ ਤੁਹਾਨੂੰ ਫਿਰ ਬਰਦਾਸ਼ਤ ਕਰਨਾ ਪਏਗਾ ਕਿ ਪਲੀਡ ਨਾ ਗਿਲਟੀ ਕਰਨ ਦੀ ਵਜ੍ਹਾ ਤੋਂ ਜੋ ਵੀ ਔਰ ਆਪ ਹੋਣਗੇ ਉਹ ਤੁਹਾਨੂੰ ਐਕਸੈਪਟ ਕਰਨੇ ਪੈਣਗੇ ਇਸ ਵਜ੍ਹਾ ਤੋਂ।
Do you understand that? And is that how you still wish to proceed?
ਕਹਿੰਦੇ ਨੇ ਤੁਸੀਂ ਫੇਰ ਵੀ ਇਹ ਸਾਰਾ ਕੁਝ ਸੁਣਨ ਤੋਂ ਬਾਅਦ ਤੁਸੀਂ ਫੇਰ ਵੀ ਇਸ ਤਰ੍ਹਾਂ ਹੀ ਐਸੀ ਕਰਨਾ ਚਾਹੁੰਦੇ ਹੋ, ਨੋ ਕੰਟੈਸਟ ਕਰਨਾ ਚਾਹੁੰਦੇ ਹੋ? Yes, he said yes, he wants to go with that.
At the time of this offense, you speak up. So
I said no.
No, he's saying no.
Were you on bond in any other file?
ਕਹਿੰਦੇ ਕਿਸੇ ਹੋਰ ਚੀਜ਼ ਦਾ ਬੌਂਡ ਤੇ ਨਹੀਂ ਤੁਸੀਂ ਭਰਿਆ ਹੋਇਆ ਸੀ ਕਿਸੇ ਹੋਰ ਫਾਈਲ ਤੇ?
No.
No.
Did you read and sign this advice of rights form? It talked about your rights to an attorney in trial.
ਕਹਿੰਦੇ ਤੁਸੀਂ ਆਪਣੇ ਸਾਰੇ ਰਾਈਟਸ ਜਿਹੜੇ ਨੇ ਤੁਹਾਡੇ ਅਟਰਨੀ ਨੇ ਸਾਰੇ ਸਮਝਾ ਦਿੱਤੇ ਨੇ, ਤੁਸੀਂ ਸਾਈਨ ਕਰ ਦਿੱਤਾ ਉਹਦੇ ਤੇ?
Yes.
Yes, he did.
Did you understand those rights?
ਤੁਹਾਨੂੰ ਸਾਰੇ ਰਾਈਟ ਤੁਹਾਨੂੰ ਸਮਝਾ ਦਿੱਤੇ ਸਨ ਤੁਹਾਡੇ ਅਟਰਨੀ ਨੇ, ਤੁਹਾਡੇ ਕੀ ਨੇ?
Yes.
Yes.
Most importantly, do you understand that by entering a no contest plea today,
ਕਹਿੰਦੇ ਨੇ ਕਿ ਅਗਰ ਤੁਹਾਨੂੰ ਇਹ ਚੀਜ਼ ਦਾ ਸਭ ਤੋਂ ਜ਼ਰੂਰੀ ਗੱਲ ਹੈ ਇਹ ਕਿ ਤੁਹਾਨੂੰ ਪਤਾ ਹੋਣਾ ਚਾਹੀਦਾ ਹੈ ਕਿ ਤੁਸੀਂ ਅਗਰ ਕੇਸ ਨੂੰ ਅੱਗੇ ਨਹੀਂ ਲੈ ਕੇ ਜਾਣਾ ਚਾਹੁੰਦੇ,
you will be giving up those rights and you won't have a trial of any kind.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਅਗਰ ਤੁਸੀਂ ਅੱਜ ਇਸ ਚੀਜ਼ ਨੂੰ ਅੱਗੇ ਲੈ ਕੇ ਜਾਂਦੇ ਹੋ ਤੇ ਫਿਰ ਤੁਸੀਂ ਅੱਗੇ ਜਿਹੜਾ ਨਾ ਕੇਸ ਨੂੰ ਦੁਬਾਰਾ ਟ੍ਰਾਇਲ ਵਿੱਚ ਨਹੀਂ ਲੈ ਕੇ ਜਾ ਸਕਦੇ, ਤੇ ਤੁਸੀਂ ਆਪਣੇ ਸਾਰੇ ਜਿਹੜੇ ਬਾਕੀ ਰਾਈਟਸ ਤੁਹਾਨੂੰ ਦੱਸੇ ਸਨ ਉਹ ਸਾਰੇ ਤੁਹਾਡੇ ਖਤਮ ਹੋ ਜਾਣਗੇ ਅੱਜ ਅਗਰ ਤੁਸੀਂ ਸਾਈਨ ਕਰ ਦਿੰਦੇ ਹੋ ਤੇ। ਤੁਹਾਨੂੰ ਸਮਝ ਆ ਗਈ ਨਾ? Yeah, he got it.
Sir, has anybody promised you anything to get you to plea today that has not been made part of the record?
ਕਹਿੰਦੇ ਨੇ ਤੁਹਾਨੂੰ ਕਿਸੇ ਨੇ ਪ੍ਰੋਮਿਸ ਤੇ ਨਹੀਂ, ਤੁਹਾਡੇ ਨਾਲ ਕਿਸੇ ਨੇ ਵਾਅਦਾ ਤੇ ਨਹੀਂ ਕੀਤਾ ਕਿ ਤੁਸੀਂ ਇਹ ਕਰੋਗੇ ਤੇ ਤੁਹਾਡੇ ਨਾਲ ਕੀ ਕਰਨਗੇ, ਜਾਂ ਤੁਸੀਂ ਆਪਣੀ ਮਰਜ਼ੀ ਨਾਲ ਕਰ ਰਹੇ ਹੋ?
ਮੈਂ ਆਪਣੀ ਮਰਜ਼ੀ ਨਾਲ ਕਰ।
He is saying that he is doing by his own will.
But there's been no promises that the court is not aware of. Is that correct?
ਹਾਂ, ਕਹਿੰਦੇ ਨੇ ਕੋਈ ਕਿਸੇ ਨੇ ਤੁਹਾਡੇ ਨਾਲ ਕੋਈ ਵਾਅਦੇ ਤੇ ਨਹੀਂ ਕੀਤੇ ਜੋ ਕੋਰਟ ਨੂੰ ਨਾ ਪਤਾ ਹੋਏ? ਕਿਸੇ ਚੀਜ਼ ਦਾ ਤੁਹਾਡੇ ਨਾਲ ਕਿਸੇ ਨੇ ਪ੍ਰੋਮਿਸ ਤੇ ਨਹੀਂ ਕੀਤਾ ਕਿਸੇ ਗੱਲ ਦਾ?
ਨਹੀਂ।
No, he said no.
Has anybody threatened you in order to get you to plea?
ਕਹਿੰਦੇ ਨੇ ਕਿਸੇ ਨੇ ਤੁਹਾਨੂੰ ਧਮਕਾਇਆ ਤੇ ਨਹੀਂ ਕਿ ਤੁਹਾਨੂੰ ਇਹ ਕਰਨਾ ਪਵੇਗਾ?
ਨਹੀਂ।
No.
And is it your own free choice to plead today?
ਕਹਿੰਦੇ ਤੁਸੀਂ ਆਪਣੀ ਜ਼ਾਤੀ ਮਰਜ਼ੀ ਦੇ ਨਾਲ ਇਹ ਕਰ ਰਹੇ ਹੋ, ਪਲੀਡ ਕਰ ਰਹੇ ਹੋ?
ਹਾਂਜੀ।
Yes, he's saying.
Are counsel aware of any other promises, threats, or inducements that have not been made part of the record?
I'm not.
ਹਾਂ, ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਪੁੱਛਦੇ ਪਏ ਨੇ ਕਿ ਕਿਸੇ ਨੇ ਵੀ ਕਿਸੇ ਕਾਉਂਸਲਰ ਨੇ ਕਿਸੇ ਨੇ ਤੁਹਾਨੂੰ ਕੋਈ ਧਮਕਾਇਆ ਜਾਂ ਕੋਈ ਵਾਅਦੇ ਕੀਤੇ ਨੇ ਤੇ ਉਹ ਪਤਾ ਹੋਣੇ ਚਾਹੀਦੇ ਨੇ ਕੋਰਟ ਨੂੰ।
Ms. Carey?
I am not.
Ms. Carey? Go ahead. Can you translate that, please?
ਉਹ ਪੁੱਛ ਰਹੇ ਨੇ ਕਿ ਉਹਨੂੰ ਪੁੱਛ ਰਹੇ ਨੇ, ਉਹ ਕਹਿੰਦੇ ਨਹੀਂ ਮੈਨੂੰ ਨਹੀਂ ਪਤਾ ਇਸ ਗੱਲ ਦਾ, ਅਸੀਂ ਨਹੀਂ ਕੀਤਾ।
I'm not.
ਉਹ ਕਹਿੰਦੀ ਹੈ ਕਿ ਮੈਨੂੰ ਇਸ ਚੀਜ਼ ਤੇ ਯਕੀਨ ਹੈ ਕਿ ਇਹੋ ਜਿਹਾ ਨਹੀਂ ਹੋਇਆ ਕੁਛ ਗੱਲ।
Mr. Gurmurthy? Promises, threats, or inducements?
No.
ਹਾਂ, ਉਹਨਾਂ ਨੇ ਤੁਹਾਡੇ ਵਕੀਲ ਕੋਲੋਂ ਵੀ ਪੁੱਛਿਆ ਕਿ ਕੋਈ ਪ੍ਰੋਮਿਸ ਜਾਂ ਕੋਈ ਥ੍ਰੈਟਸ ਤੇ ਨਹੀਂ ਹੋਏ, ਤੇ ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਨਹੀਂ ਹੋਏ।
I have received People's Exhibit number 1.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਰਿਸੀਵ ਕੀਤਾ, ਮੈਨੂੰ ਮਿਲਿਆ ਹੈ ਜਿਹੜਾ ਪੇਪਰ ਜਿਹਨੂੰ ਐਗਜ਼ਿਬਿਟ 1 ਕਹਿੰਦੇ ਨੇ, ਉਹ ਮੈਨੂੰ ਮਿਲਿਆ ਹੈ।
And Defendant's Exhibit A.
ਜਿਨ੍ਹਾਂ ਦੇ ਖਿਲਾਫ ਗੱਲ ਹੋ ਰਹੀ ਹੈ ਉਹਨਾਂ ਨੇ ਕੀਤਾ ਜਿਹਨਾਂ ਦਾ ਏ ਵੇ।
People's Exhibit number 1 is
ਜਿਹੜਾ ਐਗਜ਼ਿਬਿਟ 1 ਦੇ ਹੈਗੇ ਨੇ,
a report from the Wexford County Sheriff's Office.
ਕਹਿੰਦੇ ਨੇ ਜਿਹੜੇ ਸ਼ੈਰਿਫ ਦੇ ਆਫਿਸ ਤੋਂ, ਵੈਕਸਫੋਰਡ ਕਾਉਂਟੀ ਦਾ ਜਿਹੜਾ ਸ਼ੈਰਿਫ ਹੈ ਉਹਦੇ ਤੋਂ ਜਿਹੜਾ ਮੈਨੂੰ ਮਿਲਿਆ ਪੇਪਰ।
Case number
ਕੇਸ ਨੰਬਰ ਦੱਸ ਰਹੇ ਨੇ
83- 23-2500
2500
494.
495
Defendants Exhibit A
ਜਿਹੜਾ ਡਿਫੈਂਡਡ ਹੈ ਜਿਹਦਾ ਨਾਂ A ਵੇ
is a stipulated order regarding medical examiner report records
ਕਹਿੰਦੇ ਕੋਰਟ ਦੀ ਰੈਕਟ ਤੇ ਜੇ ਮੈਡੀਕਲ ਐਗਜ਼ਾਮ ਹੋਇਆ ਹੈ ਉਹ ਰਿਕਾਰਡ ਆਇਆ ਹੈ
and attached to that
ਜੋ ਉਹਦੇ ਨਾਲ ਅਟੈਚ ਹੋਇਆ ਹੈ ਮੈਡੀਕਲ ਰਿਪੋਰਟ ਦੇ ਨਾਲ
is case report number
ਜਿਹੜਾ ਕੇਸ ਦਾ ਰਿਕਾਰਡ ਨੰਬਰ ਹੈ
83-0318
-0318 ਜਿਹੜਾ ਹੈ 18
-B as in boy W
-B boy W
-2025
-2025 225
from the Mid-Michigan ME group
Mid Michigan ME group ਹੈਗਾ
pathologist
ਐਂਥੋਲੋਜਿਸਟ ਹੈਗੇ ਨੇ ਉਹ
Christopher
ਉਹਦਾ ਨਾਮ ਕ੍ਰਿਸਟੋਫਰ ਹੈ
HAUCH MD
ਉਹਦਾ ਨਾਲ ਮੇਰਾ ਲਾਸਟ ਨੇਮ ਹੈ ਸ਼ਾਇਦ
do council move for their admission
ਜਿਹੜੀ ਕੌਂਸਲ ਹੈ ਉਹਨੇ ਆਪਣਾ ਜੋ ਐਡਮਿਸ਼ਨ ਦਿੱਤਾ ਹੈ ਰਿਚ ਦੱਸਿਆ ਉਹਨਾਂ ਨੇ
I do.
ਉਹ ਕਹਿੰਦੇ ਮੈਂ ਕਰਨੀ ਹੈ ਉਹ ਆਪਣਾ ਨਾਮ ਦੱਸ ਰਹੇ ਨੇ
And I do too.
Lowry, Mr. Grimmerly.
I do as well, Judge.
ਹਾਂ ਉਹ ਤੁਹਾਡਾ ਵਕੀਲ ਵੀ ਕਹਿ ਰਿਹਾ ਕਿ ਉਹ ਵੀ ਕਹਿ ਰਿਹਾ ਕਿ ਮੈਂ ਵੀ ਉਸ ਗੱਲ ਤੋਂ ਮੰਨਣਾ
Peoples 1 and defendants A are received by the court.
ਕਹਿੰਦੇ ਜੇ ਡਿਫੈਂਡੈਂਟ A ਜਿਹੜਾ ਜੋ ਰਿਸੀਵ ਹੋਇਆ ਸਾਨੂੰ ਕੋਰਟ ਦੇ ਥਰੂ
I was apprised of the no contest plea prior to calling the case.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਜੋ no contest ਜਿਹੜੀ ਪਲੀ ਕਰਨੀ ਹੈ ਕੇਸ ਤੋਂ ਪਹਿਲੇ ਜਿਹੜੀ ਗੱਲ ਹੋਈ ਸੀ
In particular, in People's Exhibit 1,
ਹਾਂ ਜਿਹੜੇ ਕਹਿੰਦੇ ਜਿਹੜਾ ਐਗਜ਼ਿਬਿਟ 1 ਜਿਹੜਾ ਹੁਣੇ ਜੋ ਦੱਸ ਰਹੇ ਨੇ ਉਹਦੇ ਮੁਤਾਬਿਕ
my attention was drawn to a report by Cameron Johnson
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੇਰੀ ਤੋਜੋ ਗਈ ਹੈ ਉਸ ਗੱਲ ਤੇ ਜਿਹੜਾ ਕੈਮਰਨ ਜੌਨਸਨ ਨੇ ਰਿਪੋਰਟ ਭੇਜੀ ਹੈ ਉਹਦੇ ਮੁਤਲਕ
pages 1 through 4 of 7.
ਕਹਿੰਦੇ ਨੇ ਜੋ ਪੇਜ ਜਿਹੜਾ ਹੈ 1 to 7 ਜਿਹੜਾ ਪੇਜ ਨੰਬਰ ਹੈ ਉਹਦੇ ਤੇ ਤੋਜੋ ਉਹਨਾਂ ਦੀ ਗਈ ਹੈ ਉਹਨਾਂ ਨੇ ਵੇਖਿਆ ਕਿ ਇਹ ਕੀ ਹੈ ਧਿਆਨ ਗਿਆ ਉਹਨਾਂ ਦਾ ਉਸ ਪਾਸੇ
Based on these exhibits, do council believe that they provide a factual basis in which to accept the plea?
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਸਾਰੀ ਗੱਲ ਨੂੰ ਵੇਖਦੇ ਹੋਏ ਮੈਂ ਉਹ ਚੀਜ਼ਾਂ ਨੂੰ ਵੇਖਣਾ ਕਿ ਉਹਨਾਂ ਦਾ ਕੀ ਹਕੀਕਤ ਹੈ ਕਿ ਮੈਂ ਇਹ ਪਲੀ ਨੂੰ ਐਕਸੈਪਟ ਕਰ ਲਵਾਂ
I do. I do.
ਉਹ ਕਹਿੰਦੀ ਮੈਂ ਮੰਨਨੀ ਇਸ ਗੱਲ ਨੂੰ
And I do too, Judge.
ਉਹ ਵੀ ਕਹਿੰਦੇ ਨੇ ਮੈਂ ਮੰਨਣਾ ਇਸ ਗੱਲ ਨੂੰ
Do council believe the court rules have been complied with?
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਕੌਂਸਲ ਨੂੰ ਪੁੱਛਣਾ ਕਿ ਜੋ ਵੀ ਮੈਂ ਰੂਲ ਜਿਹੜੇ ਨੇ ਲਾ ਦੇ ਮੁਤਾਬਿਕ ਨੇ ਉਹਨਾਂ ਨਾਲ ਉਹ ਉਸ ਗੱਲ ਨੂੰ ਮੰਨਦੇ ਨੇ
Yes.
ਉਹ ਕਹਿੰਦੀ ਹੈ ਹਾਂ ਮੈਂ ਮੰਨਨੀ ਹੈ
Yes, Judge.
ਉਹ ਵੀ ਕਹਿ ਰਹੇ ਨੇ ਮੈਂ ਮੰਨਣਾ
As does the court.
ਕਹਿੰਦੇ ਜਿਸ ਤਰ੍ਹਾਂ ਕੋਰਟ ਕਹਿ ਰਿਹਾ ਹੈ
I find the plea is knowing, voluntary, and accurate.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਸਮਝ ਰਿਹਾ ਕਿ ਜੋ ਵੀ ਪਲੀ ਕੀਤੀ ਗਈ ਹੈ ਉਹ ਆਪਣੇ ਤੌਰ ਤੇ ਕੀਤੀ ਗਈ ਹੈ ਤੇ ਬਿਲਕੁਲ ਸਹੀ ਹੈ
In particular, the page numbers referenced in People's Exhibit number 1
ਕਹਿੰਦੇ ਜਿਹੜਾ ਪੇਜ ਨੰਬਰ 1 ਹੈ ਉਹਦੇ ਮੁਤਾਬਿਕ
indicate that on March 18th,
ਉਹਦੇ ਮੁਤਾਬਿਕ ਜੋ ਮਾਰਚ 18 ਨੂੰ
counsel, we never took the plea.
I was just gonna say, you never asked.
Hold on. Can you translate that?
ਕਹਿੰਦੇ ਨੇ ਕਿ ਸਾਨੂੰ ਉਸ ਵਕਤ ਪਲੀ ਨਹੀਂ ਮਿਲੀ ਸੀ।
Mr. Singh, to the
Mr.
offense that on March 18th, 2025,
ਕਹਿੰਦੇ ਨੇ ਮਾਰਚ 18 2025 ਪੰਜੀ ਨੂੰ
in Liberty Township
ਲਿਬਰਟੀ ਟਾਊਨਸ਼ਿਪ ਵਿੱਚ
of Wexford County,
ਵੈਕਸਫੋਰਡ ਕਾਉਂਟੀ ਹੈਗੀ ਸੀ।
how do you plead?
ਕਹਿੰਦੇ ਨੇ ਤੁਸੀਂ ਕਿਸ ਤਰ੍ਹਾਂ ਜਿਹੜਾ ਪਲੀ ਕੀਤਾ ਸੀ, ਕਿਸ ਤਰ੍ਹਾਂ ਤੁਸੀਂ ਕਿਹਾ ਸੀ ਕਿ ਮੇਰੇ ਕੋਲ ਹੋਇਆ ਜੋ ਵੀ, ਕਿਸ ਤਰ੍ਹਾਂ ਹੋਇਆ ਸੀ?
To count number 1, moving violation causing death.
ਕਹਿੰਦੇ ਕਿ ਤੁਹਾਡੇ ਉਹ ਜੋ ਤੁਸੀਂ ਚਲਾ ਰਹੇ ਸੋ ਉਹਦੀ ਵਜ੍ਹਾ ਤੋਂ ਕਿਸੇ ਦੀ ਜਾਨ ਗਈ ਹੈ।
I anticipate a no contest plea.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਇਸ ਸਮਝ ਰਿਹਾ ਕਿ ਤੁਸੀਂ ਜਿਹੜਾ ਆਪਣਾ ਨੋ ਕੰਟੈਸਟ ਜਿਹੜਾ ਨਾ ਉਹ ਰਿਪਲੀ ਕਰਨਾ ਚਾਹ ਰਹੇ ਹੋ, ਕਿ ਤੁਸੀਂ ਅੱਗੇ ਕੇਸ ਨੂੰ ਖਿੱਚਣਾ ਨਹੀਂ ਚਾਹੁੰਦੇ।
How do you plead?
ਕਹਿੰਦੇ ਨੇ ਕਿ ਤੁਸੀਂ ਪਲੀ ਕਰਨਾ ਚਾਹੁੰਦੇ ਹੋ, ਜਿਹੜਾ ਤੁਸੀਂ ਦੱਸਿਆ ਤੁਹਾਨੂੰ ਲਾਇਰ ਨੇ ਕਿ ਨੋ ਕੰਟੈਸਟ ਕਰਨਾ ਹੈ।
Yes, no, but.
Yeah, he said yes. No contest.
No contest.
Yeah.
Now do counsel believe that the court rules have been complied with?
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਕੌਂਸਲ ਨੂੰ ਪੁੱਛਣਾ ਕਿ ਉਹ ਜਿਹੜਾ ਕੋਰਟ ਦਾ ਜਿਹੜਾ ਜੋ ਕੋਰਟ ਫੈਸਲਾ ਦੇ ਰਿਹਾ ਉਹ ਉਹਨਾਂ ਨੂੰ ਮੰਨਦੇ ਨੇ?
Yes.
ਉਹ ਕਹਿ ਰਹੀ ਹੈ yes.
I agree to, Judge.
ਤੁਹਾਡਾ ਵਕੀਲ ਵੀ ਕਹਿੰਦਾ ਉਹ ਮੈਂ ਮੰਨਣਾ।
I now find the plea is knowing, voluntary, and accurate.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਨੂੰ ਪਤਾ ਹੈ ਕਿ ਜਿਹੜੀ ਪਲੀ ਹੋਈ ਹੈ ਉਹ ਤੁਸੀਂ ਆਪਣੇ ਤਰਫੋਂ ਹੀ ਕਰ ਰਹੇ ਹੋ।
In particular, People's Exhibit number 1,
ਕਹਿੰਦੇ ਨੇ ਜੋ ਐਗਜ਼ਿਬਿਟ ਨੰਬਰ 1 ਤੇ ਜੋ ਲਿਖਿਆ ਹੈ
reports that on March 18th, 2025,
ਜਿੱਥੇ ਲਿਖਿਆ ਹੈ ਕਿ ਜੋ ਰਿਪੋਰਟ ਕਰਦਾ ਹੈ ਕਿ 18 ਮਾਰਚ 2025 ਨੂੰ
in Liberty Township,
ਲਿਬਰਟੀ ਟਾਊਨਸ਼ਿਪ ਵਿੱਚ
the defendant was operating a semi
ਕਹਿੰਦੇ ਕਿ ਤੁਸੀਂ ਸੈਮੀ ਟਰੱਕ ਚਲਾ ਰਹੇ ਸੋ
and while in the southbound lane,
ਸਾਊਥਬਾਊਂਡ ਲੇਨ ਹੈਗੀ ਸੀ, ਉਹ ਹੈਗਾ ਸੀ ਡਿਫੈਂਡੈਂਟ
struck another vehicle head on.
ਕਹਿੰਦੇ ਦੂਸਰੀ ਗੱਡੀ ਜਿਹੜੀ ਸੀ ਔਰ ਤੁਸੀਂ ਜਾ ਕੇ ਸਿੱਧੀ ਗੱਡੀ ਉਹਦੇ ਚ ਮਾਰੀ ਹੈ।
Witnesses reported
ਕਹਿੰਦੇ ਜਦੋਂ ਇਹਦੀ ਰਿਪੋਰਟ ਹੋਈ
the defendant trying to pass other vehicles
ਕਹਿੰਦੇ ਨੇ ਜਿਹੜਾ ਡਿਫੈਂਡੈਂਟ ਹੈ ਉਹ ਗੱਡੀ ਜਿਹੜੀ ਸੀ ਉਹਨੂੰ ਪਾਸ ਕਰਨਾ ਚਾਹੁੰਦਾ ਸੀ, ਉਹਨੂੰ ਅੱਗੇ ਜਾਣਾ ਚਾਹੁੰਦਾ ਸੀ
and crossing the center line to do so.
ਕਹਿੰਦੇ ਉਹ ਜਿਹੜੀ ਦਰਮਿਆਨ ਵਾਲੀ ਲੇਨ ਸੀ ਉਹ ਰਹੀ ਜਾਣਾ ਚਾਹ ਰਿਹਾ ਸੀ।
The driver of the pickup that was struck head on
ਜਿਹੜੀ ਪਿਕਅਪ ਗੱਡੀ ਦਾ ਜਿਹੜਾ ਡਰਾਈਵਰ ਸੀ ਜਿਹੜਾ ਜਿਹਦਾ ਐਕਸੀਡੈਂਟ ਹੋਇਆ, ਜਿਹਨੂੰ ਜਾ ਕੇ ਵੱਜਿਆ ਟਰੱਕ,
and was pronounced deceased at the scene.
ਕਹਿੰਦੇ ਉਹਦੀ ਉੱਥੇ ਹੀ ਜਿਹੜਾ ਸੀ ਉਹਦੀ ਮੌਤ ਹੋ ਗਈ ਸੀ ਮੌਕੇ ਤੇ ਹੀ।
Weather conditions were reported at
ਕਹਿੰਦੇ ਉਸ ਵਕਤ ਜਿਹੜੀ ਵੈਦਰ ਦੀ ਜਿਹੜੀ ਕੰਡੀਸ਼ਨ ਹੈ ਉਹ ਰਿਪੋਰਟ ਹੋਈ ਸੀ
36 degrees
ਕਹਿੰਦੇ 36 ਡਿਗਰੀ ਵੈਦਰ ਸੀ
with visibility of 10 miles.
ਕਹਿੰਦੇ ਕਿ ਬਿਲਕੁਲ 10 ਮੀਲ ਤੱਕ ਜਿਹੜਾ ਨਜ਼ਰ ਆਂਦਾ ਸੀ।
And road conditions were reported clean and dry, or clear and
ਕਹਿੰਦੇ
dry.
ਕਿ ਜਿਹੜੀ ਸੜਕਾਂ ਦੀ ਜਿਹੜੀ ਹਾਲਤ ਸੀ ਉਹ ਬਿਲਕੁਲ ਸਾਫ਼ ਸਨ ਤੇ ਖੁਸ਼ਕ ਸਨ।
Exhibit number or letter D, I'm sorry, A, exhibit A,
ਹਾਂ ਕਹਿੰਦੇ ਜਿਹੜਾ ਐਗਜ਼ਿਬਿਟ A ਹੈ ਉਹਦੇ ਮੁਤਾਬਕ
determine the cause of death of Mr. William Bolin
ਕਹਿੰਦੇ ਜੋ ਉਹਨਾਂ ਦੀ ਵਿਲੀਅਮ ਬੋਲਿੰਗ ਦੀ ਜਿਹੜੀ ਮੌਤ ਦਾ ਕਾਰਨ ਸੀ
to be the result of
ਉਹਦੀ ਵਜ੍ਹਾ ਜੋ ਬਣੀ ਹੈ
a motor vehicle accident
ਗੱਡੀ ਦਾ ਜਿਹੜਾ ਐਕਸੀਡੈਂਟ ਹੈ
with multiple trauma.
ਹਾਂ ਕਹਿੰਦੇ ਜੋ ਉਹਨੂੰ ਬਹੁਤ ਜ਼ਿਆਦਾ ਜਿਹੜਾ ਹੈ ਨੁਕਸਾਨ ਪਹੁੰਚਿਆ ਉਹਨੂੰ ਬਹੁਤ ਤਰ੍ਹਾਂ ਦਾ ਡਿਫਰੈਂਟ ਤਰੀਕੇ ਦਾ ਉਹਨੂੰ ਟਰਾਮਾ ਹੋਇਆ ਉਹਨੂੰ ਬਹੁਤ ਤਕਲੀਫ ਆਈ ਹੈ
As such, I find the defendant guilty
ਕਹਿੰਦੇ ਨੇ ਮੈਨੂੰ ਇਸ ਗੱਲ ਤੋਂ ਇਹੀ ਹੈ ਕਿ ਜਿਹੜਾ ਡਿਫੈਂਡੈਂਟ ਹੈ ਉਹਦੀ ਗਲਤੀ ਹੈ
of moving violation causing death.
ਜਿਹੜਾ ਜੋ ਤੁਸੀਂ ਗੱਡੀ ਚਲਾਈ ਹੈ ਉਹਦੀ ਵਜ੍ਹਾ ਤੋਂ ਜਿਹਦੀ ਜਾਨ ਗਈ ਹੈ
I also find the interests of justice
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਨੂੰ ਜਿਹੜਾ ਕਾਨੂੰਨ ਦਾ ਵੀ ਖਿਆਲ ਰੱਖਣਾ ਹੈ ਕਿ ਇਨਸਾਫ ਹੋਣਾ ਚਾਹੀਦਾ ਹੈ
are well preserved
ਕਹਿੰਦੇ ਉਹਦਾ ਵੀ ਮੈਂ ਖਿਆਲ ਰੱਖਾਂਗਾ ਪੂਰੀ ਤਰ੍ਹਾਂ
in allowing the defendant a no contest plea
ਕਹਿੰਦੇ ਕਿ ਮੈਂ ਅਲਾਉ ਕਰਨਾ ਜਿਹੜਾ ਤੁਹਾਨੂੰ ਕਿ ਤੁਸੀਂ ਨੋ ਕੰਟੈਸਟ ਜਿਹੜਾ ਨਾ ਤੁਸੀਂ ਪਲੀ ਕਰ ਸਕਦੇ ਹੋ
and not plead guilty
ਹਾਂ ਕਹਿੰਦੇ ਕਿ ਤੁਸੀਂ not plead guilty ਵੀ ਜਿਹੜਾ ਹੈ ਮੈਂ ਸਮਝ ਰਿਹਾ ਤੁਹਾਡੀ ਗੱਲ ਨੂੰ
by articulating a factual basis
ਹਾਂ ਸਾਰੀ ਜਿਹੜੇ ਜੋ ਵੀ ਹੋਇਆ ਹੈ ਉਹਦੀ ਰਿਜ਼ਲਟ ਤੋਂ ਸਾਰੇ ਚੀਜ਼ਾਂ ਨੂੰ ਵੇਖਦੇ ਹਕੀਕਤ ਨੂੰ ਵੇਖਦੇ ਹੋਏ
in order to protect
ਉਹਦੀ ਹਿਫਾਜ਼ਤ ਕਰਦੇ ਹੋਏ
against civil liability
ਜਿਹੜੀ ਤੁਹਾਨੂੰ ਸਿਵਲ ਲਾਇਬਿਲਿਟੀ ਤਹਿਤ ਜਿਹੜੀ ਹੋਰ ਜ਼ਿੰਮੇਵਾਰੀਆਂ ਪੈਣੀਆਂ ਸਨ ਉਹਨੂੰ ਤੁਹਾਨੂੰ ਬਚਾਉਂਦੇ ਤੁਹਾਨੂੰ ਜਿਹੜਾ ਹੈ ਇਹ ਇਜਾਜ਼ਤ ਦਿੰਦੇ ਆ
Ms. Carey, are we able to sentence today?
Yes, we have a,
ਮਿਸ ਕੈਰੀ ਨੂੰ ਪੁੱਛ ਰਹੇ ਨੇ ਕਿ ਅੱਜ ਅਸੀਂ ਸੈਂਟੈਂਸ ਤੁਹਾਨੂੰ ਸਜ਼ਾ ਸੁਣਾ ਸਕਦੇ ਹਾਂ
yes, and we have two victim statements.
ਉਹ ਕਹਿੰਦੇ ਕਿ ਹਾਂ ਅਸੀਂ ਕਰ ਸਕਦੇ ਹਾਂ
Are those victims present or is it something to be read into the record?
ਉਹ ਪੁੱਛ ਰਹੇ ਨੇ ਕਿ ਉਹ ਜਿਹੜੇ ਵਿਕਟਮ ਨੇ ਉਹ ਪ੍ਰੈਜ਼ੈਂਟ ਨੇ ਜਾਂ ਨਹੀਂ ਨੇ
One is present.
ਕਹਿੰਦੇ ਇੱਕ ਹੈਗਾ ਵਿੱਚੋਂ
Be read.
Can you repeat that louder?
And one is to be read.
ਉਹ ਕਹਿੰਦੇ ਨੇ ਇੱਕ ਜਿਹੜਾ ਨਾ ਪ੍ਰੈਜ਼ੈਂਟ ਨਹੀਂ ਹੈਗਾ ਦੂਸਰਾ what did you say one was present and the other one
To be read.
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਹਾਂ ਉਹਨੂੰ ਉਹਦਾ ਪੜਿਆ ਜਾਏਗਾ ਉਹਦੇ ਮੁਤਲਕ
Let's start with those that are present.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹਦੇ ਨਾਲ ਗੱਲ ਕਰਨਾ ਹੈ ਜੋ ਪ੍ਰੈਜ਼ੈਂਟ ਹੈਗਾ ਜੋ ਮੌਜੂਦ ਹੈ ਇਸ ਵਕਤ
Ma'am, could you please state your name for the record?
ਤੁਸੀਂ ਆਪਣਾ ਨਾਮ ਦੱਸੋ ਕਹਿ ਰਹੇ ਨੇ
Anita Rositas, Anita Rositas.
ਉਹ ਆਪਣਾ ਨਾਮ ਦੱਸ ਰਹੇ ਨੇ ਅਨੀਤਾ ਰੈਸਸ ਹੈ ਨਾ ਉਹਨਾਂ ਦਾ ਨਾਮ
Ma'am, I'm going to ask that, as you've seen, we need to speak slowly so things can be interpreted.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਤੁਸੀਂ ਆਰਾਮ ਨਾਲ ਥੋੜਾ ਗੱਲ ਕਰੋ ਤਾਂ ਕਿ ਮੈਂ ਸਮਝ ਸਕਾਂ ਤੇ ਮੈਂ ਅੱਗੇ ਤੁਹਾਨੂੰ ਦੱਸ ਸਕਾਂ ਕੀ ਕਹਿ ਰਹੇ ਨੇ
What would you like the court to know?
Thank you, Your Honor.
ਕਹਿੰਦੇ ਨੇ ਕੋਰਟ ਨੂੰ ਕਹਿੰਦੇ ਨੇ ਕਿ ਤੁਸੀਂ ਕੀ ਦੱਸਣਾ ਚਾਹੁੰਦੇ ਹੋ
Thank you, Your Honor, for letting me speak today.
ਉਹ ਥੈਂਕ ਯੂ ਕਹਿ ਰਹੀ ਹੈ ਕਿ ਤੁਸੀਂ ਮੈਨੂੰ ਇਜਾਜ਼ਤ ਦਿੱਤੀ ਹੈ ਬੋਲਣ ਦੀ
First, I would like to extend my heartfelt condolences to the William Bolin family.
ਕਹਿੰਦੀ ਮੈਂ ਸਭ ਤੋਂ ਪਹਿਲੇ ਜਿਹੜੀ ਫੈਮਿਲੀ ਹੈ ਵਿਲੀਅਮ ਬੋਲਿੰਗ ਦੀ ਉਹਨਾਂ ਵਾਸਤੇ ਮੈਂ ਅਫਸੋਸ ਦਾ ਇਜ਼ਹਾਰ ਕਰਨੀ ਹੈ ਉਹਨਾਂ ਵਾਸਤੇ ਦਿਲ ਤੋਂ
Mr. Excuse me. You changed my life on March 18th, 2025, at 8:50 a.m.
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਤੁਸੀਂ ਮਿਸਟਰ ਸਿੰਘ ਤੁਸੀਂ ਮੇਰੀ ਜ਼ਿੰਦਗੀ ਜਿਹੜੀ ਹੈ ਨਾ ਚੇਂਜ ਕਰ ਦਿੱਤੀ ਹੈ 18 ਜਿਹੜੀ ਮਾਰਚ ਦੀ ਜਿਹੜੀ ਗੱਲ ਕਰ ਰਹੇ ਨੇ 8 am
As the court stated, it was a beautiful day. The road was dry. And it was,
ਕਹਿੰਦੇ ਨੇ ਕਿ ਕੋਰਟ ਦੱਸ ਰਿਹਾ ਕਿ ਉਸ ਦਿਨ ਬੜਾ ਸੋਹਣਾ ਦਿਨ ਸੀ ਤੇ ਸਾਰਾ ਕੁਝ ਬਹੁਤ ਅੱਛਾ ਸੀ, ਵੈਦਰ ਵੀ ਅੱਛਾ ਸੀ, ਸਭ ਕੁਝ ਠੀਕ ਸੀ।
I was driving directly behind the white pickup that was going southbound.
ਕਹਿੰਦੇ ਕਿ ਮੈਂ ਜਿਹੜੀ ਵਾਈਟ ਪਿਕਅਪ ਹੈ ਉਹਦੇ ਪਿੱਛੇ ਮੈਂ ਗੱਡੀ ਚਲਾ ਰਹੀ ਸੀ ਸਾਊਥ ਬਾਉਂਡ ਤੇ।
In an instant, you were attempting to pass another northbound semi.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਤੁਸੀਂ ਨਾਰਥ ਬਾਉਂਡ ਤੋਂ ਪਾਸ ਕਰ ਰਹੇ ਸੋ ਸਮੇਂ ਟਰੱਕ ਵਿੱਚ।
I don't know your speed, but to pass another vehicle on a 2-lane road that was 55 miles an hour.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਨੂੰ ਤੁਹਾਡੀ ਸਪੀਡ ਦਾ ਨਹੀਂ ਪਤਾ, ਲੇਕਿਨ ਉੱਥੇ 55 ਜਿਹੜੀ ਸੀ 55 ਸਪੀਡ ਹੈਗੀ ਸੀ ਪਰ ਮਾਈਲ ਦੇ ਹਿਸਾਬ ਨਾਲ।
In that second, you smashed into us.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਇੱਕ ਸੈਕਿੰਡ ਹੀ ਤੁਸੀਂ ਆ ਕੇ ਸਾਡੇ ਵਿੱਚ ਜਾ ਕੇ ਗੱਡੀ ਮਾਰ ਦਿੱਤੀ ਉੱਥੇ।
I say us because I swerved into the northbound lane between you and the first northbound semi.
ਕਹਿੰਦੀ ਹੈ ਕਿ ਮੈਂ ਇਸ ਵਾਸਤੇ ਕਹਿ ਰਹੀ ਹਾਂ ਕਿ ਮੈਂ ਵੀ ਉੱਥੇ ਸਾਂ ਕਿ ਜਿਹੜਾ ਨਾ ਮੈਨੂੰ ਵੀ ਨਾਰਥ ਬਾਉਂਡ ਤੋਂ ਜਿਹੜਾ ਨਾ ਮੈਨੂੰ ਵੀ ਉੱਥੋਂ ਹੋਣਾ ਪਿਆ, ਬਿਕੋਜ਼ ਮੇਰੇ ਤੋਂ ਪਹਿਲੀ ਜਿਹੜੀ ਗੱਡੀ ਸੀ ਉਹਦੇ ਜਾ ਕੇ ਗੱਡੀ ਵੱਜ ਗਈ।
I screamed out, "Oh God, not today!"
ਉਹ ਕਹਿੰਦੀ ਕਿ ਮੈਂ ਸ਼ੋਰ ਕੀਤਾ ਕਿ ਮੈਂ ਅੱਜ ਨਾ ਹੋਵੇ ਇਹੋ ਜਿਹਾ, ਅੱਲਾ ਕੀ ਹੋ ਗਿਆ ਮੇਰੇ ਨਾਲ।
You hit that pickup so hard, pushing it past me.
ਉਹ ਕਹਿੰਦੀ ਉਹ ਜਿਹੜੀ ਪਿਕਅਪ ਇੰਨੀ ਜ਼ੋਰ ਨਾਲ ਜਾ ਕੇ ਲੱਗਿਆ ਕਿ ਉਹਨੇ ਮੈਨੂੰ ਵੀ ਪਿੱਛੇ ਧਕੇਲ ਦਿੱਤਾ।
Hearing and seeing the crash, watching the metal fly off the vehicles and debris hitting my car.
ਕਹਿੰਦੀ ਹੈ ਕਿ ਮੈਂ ਵੇਖਿਆ ਕਿ ਜਿਹੜਾ ਨਾ ਇੰਨੀ ਜ਼ੋਰ ਦਾ ਆ ਕੇ ਲੱਗੀ ਗੱਡੀ ਕਿ ਉਹ ਜਿਹੜੀਆਂ ਉਹਦੀਆਂ ਜਿੰਨਾ ਵੀ ਮੈਟਲ ਸੀ ਉਹ ਟੁੱਟ ਕੇ ਆ ਕੇ ਤੇ ਜਿਹੜਾ ਨਾ ਸਾਰਾ ਜਿਹੜਾ ਉਹ ਜੋ ਵੀ ਹੈਗਾ ਸੀ ਅੱਗੇ ਪਿੱਛੇ ਟੁੱਟਿਆ ਹੋਇਆ ਸਾਰਾ ਮੇਰੀ ਵੀ ਗੱਡੀ ਤੇ ਆ ਕੇ ਵੱਜਿਆ।
Your semi was pushing that truck next to me on the side of the road, and I knew the outcome.
ਕਹਿੰਦੀ ਕਿ ਤੁਹਾਡਾ ਜਿਹੜਾ ਸੈਮੀ ਟਰੱਕ ਹੈ ਉਹਨੇ ਉਹ ਗੱਡੀ ਨੂੰ ਪੁਸ਼ ਕੀਤਾ ਤੇ ਮੇਰੀ ਗੱਡੀ ਵੀ ਜਿਹੜੀ ਹੈ ਉਹਦੇ ਨਾਲ ਜਿਹੜਾ ਨਾ ਪਿੱਛੇ ਧਕੇਲੀ ਗਈ।
No one would survive in that pickup.
ਕਹਿੰਦੇ ਕੋਈ ਵੀ ਉਸ ਗੱਡੀ 'ਚ ਬਚ ਨਹੀਂ ਸਕਿਆ।
My seat belt left me with bruises on my neck and a rash.
ਕਹਿੰਦੇ ਉਹਦੀ ਵਜ੍ਹਾ ਤੋਂ ਜਿਹੜਾ ਨਾ ਮੇਰੀ ਜਿਹੜੀ ਸੀਟ ਬੈਲਟ ਦੀ ਵਜ੍ਹਾ ਤੋਂ ਮੈਨੂੰ ਰੈਸ਼ ਹੋਇਆ ਤੇ ਮੇਰੀ ਜਿਹੜੀ ਨਾ ਮੇਰੀ ਗਰਦਨ ਤੇ ਵੀ ਜਿਹੜਾ ਨਾ ਖਿੱਚ ਪਈ।
My doctor had to prescribe me with medication for anxiety, depression, and nightmares.
ਕਹਿੰਦੇ ਮੇਰੇ ਡਾਕਟਰ ਨੂੰ ਮੈਨੂੰ ਜਿਹੜੀ ਇਹ ਦਵਾਈ ਦੇਣੀ ਪਈ ਕਿ ਮੈਂ ਡਿਪਰੈਸ਼ਨ ਵਿੱਚ ਚਲੀ ਗਈ ਤੇ ਮੈਨੂੰ ਬਹੁਤ ਮੇਰਾ ਪਰੇਸ਼ਾਨੀ ਹੋਈ ਤੇ ਮੈਨੂੰ ਰਾਤੀ ਜਿਹੜੇ ਨਾ ਮੈਨੂੰ ਸੋਣਾ ਵੀ ਮੇਰੇ ਵਾਸਤੇ ਮੁਸ਼ਕਲ ਹੋ ਗਿਆ।
I have a $500 insurance deductible for my car for damages.
ਕਹਿੰਦੀ $500 ਦਾ ਮੇਰੀ ਗੱਡੀ ਨੂੰ ਜਿਹੜਾ ਡੈਮੇਜ ਹੋਇਆ ਇੰਸ਼ੋਰੈਂਸ ਵੱਲੋਂ।
And $500 for medical.
ਅਗਰ $500 ਮੇਰਾ ਗੱਡੀ ਤੇ ਲੱਗ ਗਿਆ ਤੇ $500 ਮੇਰਾ ਦਵਾਈਆਂ ਤੇ ਲੱਗ ਗਿਆ ਡਾਕਟਰਾਂ ਤੇ।
But as a retiree, I don't have that extra $1,000.
ਕਹਿੰਦੀ ਮੈਂ ਰਿਟਾਇਰਡ ਹਾਂ ਤੇ ਮੇਰੇ ਕੋਲ ਐਕਸਟਰਾ ਜਿਹੜਾ ਨਾ $1000 ਨਹੀਂ ਹੈਗਾ।
I didn't ask for restitution.
ਕਹਿੰਦੀ ਮੈਂ ਕਦੀ ਇਸ ਪੈਸੇ ਨੂੰ ਮੰਗਣ ਵਾਸਤੇ ਨਹੀਂ ਗੱਲ ਕਰਦੀ ਪਈ।
However, I would recommend that you have to pay for the funeral expenses to the Bolin family, including the headstone and grief counseling and his truck.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਜਿਹੜਾ ਉਹਦੀ ਵਜ੍ਹਾ ਤੋਂ ਮੈਂ ਇਹ ਕਹਿੰਦੀ ਹਾਂ ਕਿ ਤੁਸੀਂ ਜਿਹੜੀ ਬੋਲਿੰਗ ਫੈਮਿਲੀ ਹੈ ਉਹਨਾਂ ਨੂੰ ਜਿਹੜਾ ਉਹਨਾਂ ਦਾ ਨੁਕਸਾਨ ਹੋਇਆ ਹੈ ਉਹਨਾਂ ਦੀ ਫੈਮਿਲੀ ਨੂੰ ਜਿਹੜਾ ਦਾ ਉੱਥੇ ਲੱਗਣਾ ਸਟੋਨ ਲੱਗਣਾ ਹੈ ਉਹਨਾਂ ਦੀ ਕਬਰ ਤੇ ਜਾਂ ਜੋ ਵੀ ਉਹਨਾਂ ਨੇ ਕਰਨਾ ਹੈ ਉਹ ਸਾਰਾ ਖਰਚਾ ਤੁਸੀਂ ਦੇਵੋ ਤੇ ਉਹਨਾਂ ਦੇ ਨਾਲ ਤੁਸੀਂ ਮਾਜ਼ਰਤ ਵੀ ਕਰੋ।
Should the court order probation, community service, I hope that the court would mandate you to speak to a semi-truck's driver's school of education or driver's education for young children.
हाँ कहते ने कि मैं जड़ा ना चाहांगी कि कम्युनिटी वास्ते कि जड़ा ना ਉਹ ਡਰਾਈਵਰਸ ਨੂੰ ਜਿਹੜਾ ਨਾ ਜ਼ਿਆਦਾ ਐਜੂਕੇਸ਼ਨ ਦੇਣ ਤਾਂ ਕਿ ਜਿਹੜਾ ਨਾ ਉਹਨਾਂ ਨੂੰ ਛੋਟਿਆਂ ਬੱਚਿਆਂ ਵਾਸਤੇ ਤੇ ਉਹਨਾਂ ਨੂੰ ਸਾਰੀ ਚੀਜ਼ ਦੀ ਸਮਝ ਹੋਣੀ ਚਾਹੀਦੀ ਹੈ
I retired from 35 years working with victims and families.
ਕਹਿੰਦੀ ਮੈਂ 35 ਸਾਲ ਤੋਂ ਜਿਹੜਾ ਨਾ ਰਿਟਾਇਰ ਹੋਈ ਆ ਮੈਂ ਫੈਮਿਲੀਜ਼ ਦੇ ਨਾਲ ਜਿਹੜਾ ਨਾ ਕੰਮ ਕਰਦੀ ਸਾਂ
Working through tragic events like this.
ਕਹਿੰਦੀ ਇਹੋ ਜਿਹੇ ਜਿਹੜੇ ਦੁੱਖ ਭਰੀਆਂ ਜਿਹੜੇ ਲੋਕਾਂ ਦੇ ਨਾਲ ਹਾਦਸੇ ਹੁੰਦੇ ਨੇ ਉਹਨਾਂ ਦੇ ਵਾਸਤੇ ਮੈਂ ਉਹਨਾਂ ਨੂੰ ਹੈਲਪ ਕਰਦੀ ਸਾਂ
It grinds me when I hear someone say, get over it, just deal with it, move on.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਨੂੰ ਇਸ ਗੱਲ ਤੋਂ ਹੁੰਦਾ ਹੈ ਬਹੁਤ ਦੁੱਖ ਹੁੰਦਾ ਹੈ ਕਿ ਲੋਕੀ ਕਹਿੰਦੇ ਨੇ ਕਿ ਭੁੱਲ ਜਾਓ ਇਸ ਗੱਲ ਨੂੰ ਤੇ ਅੱਗੇ ਜ਼ਿੰਦਗੀ ਸਟਾਰਟ ਕਰ ਲਓ ਇਹ ਬੜੀ ਮੈਨੂੰ ਪਰੇਸ਼ਾਨੀ ਦੀ ਗੱਲ ਲੱਗਦੀ ਹੈ
But in reality, you don't get over it.
ਕਹਿੰਦੀ ਕਿ ਹਕੀਕਤ ਹਾਂ ਕਹਿੰਦੀ ਹਕੀਕਤ ਵਿੱਚ ਜਿਹੜਾ ਨਾ ਤੁਸੀਂ ਇਹਨੂੰ ਇੰਨੀ ਆਸਾਨੀ ਨਾਲ ਭੁੱਲ ਨਹੀਂ ਸਕਦੇ ਇਸ ਤਕਲੀਫ ਨੂੰ
It may lessen a little, but you take one day at a time.
ਕਹਿੰਦੀ ਹੈ ਕਾਫੀ ਦੇਰ ਤੱਕ ਇਹ ਰਹਿੰਦੀ ਹੈ ਗੱਲ ਲੇਕਿਨ ਇਹ ਕਿ ਤੁਹਾਨੂੰ ਜ਼ਿੰਦਗੀ ਦੇ ਨਾਲ ਫਿਰ ਚੱਲਣਾ ਪੈਂਦਾ ਹਰ ਚੀਜ਼ ਜੋ ਹੈ ਨਾ ਤੁਸੀਂ ਡੇਲੀ ਬੇਸਿਸ ਤੇ ਵੇਖਦੇ ਹੋ ਉਹਨੂੰ ਫਿਰ
The Bolin family won't get that day back. They can't start over. Husband, father.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਿਹੜੀ ਫੈਮਿਲੀ ਹੈ ਬੋਲਿੰਗ ਫੈਮਿਲੀ ਜਿਹੜੀ ਹੈ ਉਹਨਾਂ ਵਾਸਤੇ ਬੜਾ ਮੁਸ਼ਕਿਲ ਦੀ ਘੜੀ ਹੈ ਉਹ ਉਹਨਾਂ ਦਾ ਬਾਪ ਵੀ ਗਿਆ ਉਹਨਾਂ ਦਾ ਫਾਦਰ ਵੀ ਉਹਨਾਂ ਦੀ ਜੋ ਵੀ ਉਹਨਾਂ ਦੀ ਫੈਮਿਲੀ ਨੂੰ ਨੁਕਸਾਨ ਪਹੁੰਚਿਆ ਹੈ ਹਸਬੈਂਡ ਤੇ ਫਾਦਰ ਹੋਣ ਦੀ ਵਜ੍ਹਾ ਤੋਂ
He's gone due to your actions on March 18.
ਹਾਂ ਕਹਿੰਦੇ ਉਹ ਤੁਹਾਡੀ ਵਜ੍ਹਾ ਤੋਂ 18 ਮਾਰਚ ਨੂੰ ਦੁਨੀਆ ਤੋਂ ਟੁਰ ਗਿਆ
I was always taught to say a prayer when I get in the car, and I do every day.
ਕਹਿੰਦੀ ਮੈਂ ਹਰ ਰੋਜ਼ ਜਿਹੜਾ ਗੱਡੀ ਜਿਹੜਾ ਬਹਿਣੀ ਆ ਤੇ ਮੈਂ ਦੁਆ ਕਰਨੀ ਆ ਪ੍ਰਾਰਥਨਾ ਕਰਨੀ ਆ
I just ask God to keep me safe in my travels.
ਕਹਿੰਦੀ ਮੈਂ ਦੁਆ ਕਰਨੀ ਆ ਕਿ ਮੈਂ ਜਿੱਥੇ ਵੀ ਜਾ ਰਹੀ ਆ ਮੈਂ ਸਫ਼ਰ ਵਿੱਚ ਖੈਰੀਅਤ ਨਾਲ ਹੋਵਾਂ
And now, when I am faced with a semi coming at me, I just cringe.
ਹਾਂ ਕਹਿੰਦੀ ਕਿ ਜਦੋਂ ਵੀ ਹੁਣ ਮੈਨੂੰ ਕੋਈ ਟਰੱਕ ਨਜ਼ਰ ਆਉਂਦਾ ਸਮਾਂ ਟਰੱਕ ਨਜ਼ਰ ਆਉਂਦਾ ਤੇ ਮੈਨੂੰ ਨਾ ਮੈਂ ਡਰ ਜਾਂਦੀ ਆ ਤੇ ਮੈਂ ਆਪਣੀਆਂ ਮੁੱਠੀਆਂ ਕੱਸ ਲੈਂਦੀ ਆ ਮੈਨੂੰ ਡਰ ਲੱਗਦਾ
Mr. Bolin didn't have to die that day, and I shouldn't feel this way. You caused the death.
ਕਹਿੰਦੇ ਮਿਸਟਰ ਬੋਲਨ ਨੂੰ ਨਹੀਂ ਮਰਨਾ ਚਾਹੀਦਾ ਸੀ ਤੇ ਨਾ ਹੀ ਮੈਨੂੰ ਡਰਨਾ ਚਾਹੀਦਾ ਸੀ ਜੋ ਹੋਇਆ ਉਸ ਦਿਨ
Thank you, Your Honor.
ਥੈਂਕ ਯੂ ਬੋਲ ਰਹੀ ਕੋਰਟ ਨੂੰ
Ms. Carey.
This is a letter from the victim's son, Niall Allen Bolin, on behalf of the Bolin family.
ਕਹਿੰਦੇ ਨੇ ਮਿਸਟਰ ਬੋਲਨ ਦਾ ਜਿਹੜਾ ਬੇਟਾ ਹੈ ਉਹ ਇੱਥੇ ਨਹੀਂ ਹੈਗਾ ਉਹਨੇ ਲੈਟਰ ਲਿਖਿਆ ਕੋਰਟ ਨੂੰ
It was emailed from Mr. Bolin's wife.
ਮਿਸਟਰ ਬੋਲਨ ਦੀ ਵਾਈਫ ਦੇ ਥਰੂ ਈਮੇਲ ਆਈ ਹੈ
It says, please read from here all the way through my son's name. He needs to hear it.
ਹਾਂ ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹਨਾਂ ਕਿਹਾ ਕਿ ਸਾਰਾ ਉੱਤੋਂ ਤੋਂ ਲੈ ਕੇ ਥੱਲੇ ਮੇਰੇ ਪੁੱਤਰ ਦੇ ਨਾਂ ਤੱਕ ਪੜੋ ਉਹਨਾਂ ਨੇ ਕਿਹਾ
We choose not to be in person.
ਕਹਿੰਦੇ ਅਸੀਂ ਇਨ ਪਰਸਨ ਅਸੀਂ ਸਾਹਮਣੇ ਨਹੀਂ ਆਣਾ ਚਾਹੁੰਦੇ ਇਸ ਵਾਸਤੇ ਅਸੀਂ ਭੇਜਿਆ ਲੈਟਰ ਭੇਜਿਆ
We do not need images of the accident.
ਹਾਂ ਕਹਿੰਦੇ ਸਾਨੂੰ ਐਕਸੀਡੈਂਟ ਦੇ ਜਿਹੜੇ ਨਾ ਸਾਨੂੰ ਫੋਟੋਆਂ ਨਹੀਂ ਵੇਖਣੀਆਂ
Or Colwarren Singh's face haunting us.
ਹਾਂ ਕਹਿੰਦੇ ਨਾ ਹੀ ਅਸੀਂ ਫੇਸ ਕਰਨਾ ਚਾਹੁੰਦੇ ਆ ਨਾ ਵੇਖਣਾ ਚਾਹੁੰਦੇ ਆ
Thank you for being our voice.
ਕਹਿੰਦੇ ਨੇ ਤੁਹਾਡਾ ਬਹੁਤ ਸ਼ੁਕਰੀਆ ਕਿ ਤੁਸੀਂ ਸਾਡੀ ਗੱਲ ਨੂੰ ਸਾਡੀ ਤਕਲੀਫ ਨੂੰ ਸਮਝ ਰਹੇ ਹੋ ਸਾਡੀ ਆਵਾਜ਼ ਬਣ ਰਹੇ ਹੋ
My son has put into words what we are all feeling.
ਕਹਿੰਦੇ ਮੇਰੇ ਪੁੱਤਰ ਨੇ ਜੋ ਅਸੀਂ ਮਹਿਸੂਸ ਕਰ ਰਹੇ ਹਾਂ ਉਹਨੇ ਲਿਖ ਦਿੱਤਾ ਹੈ ਇਹਦੇ ਵਿੱਚ
Here is what he wrote.
ਕਹਿੰਦੇ ਇਹ ਉਹਨੇ ਲਿਖਿਆ
There are no words that can truly explain what my family and I have lost.
ਕਹਿੰਦੇ ਕਿ ਮੈਂ ਅਲਫਾਜ਼ ਨਹੀਂ ਦੁਹਰਾ ਸਕਦਾ ਕਿ ਮੇਰੀ ਫੈਮਿਲੀ ਦਾ ਨੇ ਕਿੰਨਾ ਨੁਕਸਾਨ ਹੋਇਆ
My father was more than just a name on a report.
कहना कि मेरा बाप जो सी मेरे वास्ते बहुत बड़ी सपोर्ट सी.
He was the person that constantly loved and reached out to me
कहने वो इस तरह का बंदा सी कि जो हर वक्त मैनू बहुत मतलब प्यार करदा सी ते हर वक्त मेरा ख्याल करदा सी.
to ensure I was in good headspace
कहना कि वो हमेशा समझदा सी कि मैं जड़ा है सही रस्ते ते चलना ते मेरा ख्याल करदा सी.
the steady presence at every family gathering
कहने कि मेरी पढ़ाई दा ते हर फैमिली जड़ी साडी गेट टुगेदर होंदी सी ओरे विच.
the person who made our lives feel grounded
कहते साडी उन्हें फैमिली नू इस तरह जोड़ के रखया सी आपस विच.
since the day of the crash
कहते जिस दिन दा एक्सीडेंट होया है.
I'm sorry, I missed a sentence.
वो कहंदी मैं भूल गई हां विचों की कहना चाह रही.
He was loving, honest and devoted.
क्या बहुत प्यार करने वाला ते बहुत ही सच्चा ते ईमानदार ते मोहब्बत करने वाला बंदा सी.
Since the day of the crash
जदों ये हादसा होया है
there has been an unbearable silence in our lives.
कहने साडी जिंदगी च बहुत ही खामोशी ते उदासी छा गई है.
A sense that something essential has been ripped away from us.
कहने इस तरह लगदा है कि साडे कोलों साडी बहुत कीमती शायद साडे कोलों चली गई है.
His death was not an accident in the purest sense of the word.
हाँ कहने सिर्फ एरी जो मौत सी वो सिर्फ एक्सीडेंट नहीं सी. सानू इस तरह लगदा है कि साडे कोलों को बहुत ही साडी प्यारी चीज चली गई है साडी जिंदगी चों.
It was a preventable tragedy.
कहने ये जड़ा हादसा सी ये बच सकदा सी.
The choices made that day behind the wheel were
कहने
not
जो
just your judgment.
हाँ कहने ने कि वो जड़ियां जो भी वाकया होया है वो बच सकदा सी लेकिन वो जड़ा ना सही जजमेंट नहीं हुई. जो चलान वाले दी गलती सी उन्हें सही समझिया नहीं गल नूं मौके नूं नहीं समझिया.
They had consequences.
हाँ ओदी वजह तो फिर ओरे नतीजे निकलते ने एहो जी गल दे.
Permanent ones.
और हमेशा वास्ते और फिर नतीजे रह जांदे ने.
Because of those actions, my father is gone forever.
कहने ओरी वजह तो मेरा बाप जड़ा हमेशा वास्ते चला गया.
We didn't get to say goodbye.
कहने सानू मौका नहीं मिलिया कि ਅਸੀਂ ਉਹਨੂੰ ਖੁਦਾ ਹਾਫਿਜ਼ ਵੀ ਕਹਿ ਸਕਦੇ.
We didn't get another hug, another laugh, another moment.
कहने ना ਅਸੀਂ ਆਪਣੇ ਬਾਪ ਨੂੰ ਜੱਫੀ ਪਾ ਸਕੇ ਨਾ ਪਿਆਰ ਕਰ ਸਕੇ ਨਾ ਖੁਦਾ ਹਾਫਿਜ਼ ਕਹਿ ਸਕੇ.
To the driver, I don't know what you were thinking that day.
ਹਾਂ ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਡਰਾਈਵਰ ਨੂੰ ਕਹਿ ਰਿਹਾ ਤੁਹਾਨੂੰ ਕਹਿ ਰਿਹਾ ਕਿ ਤੁਸੀਂ ਪਤਾ ਨਹੀਂ ਕੀ ਸੋਚ ਰਹੇ ਸੋ ਉਸ ਦਿਨ ਜਦੋਂ ਤੁਸੀਂ ਇਹ ਕੀਤਾ.
But I do know that your decisions ended the life of a good man who didn't deserve to die that way.
कहने कि ताड़ी ਮੈਨੂੰ ਸਮਝ ਆਈ ਕਿ ਤਾੜੀ ਵਜ੍ਹਾ ਤੋਂ ਇੱਕ ਇੰਨਾ ਅੱਛਾ ਬੰਦਾ ਦੁਨੀਆ ਤੋਂ ਚਲਾ ਗਿਆ ਜੋ ਕਿ ਉਹ ਡਿਜ਼ਰਵ ਨਹੀਂ ਕਰਦਾ ਸੀ.
You took something from us that can never be replaced.
ਤੁਸੀਂ ਸਾਡੇ ਕੋਲੋਂ ਉਹ ਸ਼ਾਇਦ ਖਿੱਚ ਲਿੱਤੀ ਹੈ ਜਿਹੜੀ ਸਾਨੂੰ ਕਦੀ ਦੁਬਾਰਾ ਮਿਲ ਨਹੀਂ ਸਕਦੀ.
The weight of that pain is something we carry every single day.
कहने जो ਸਾਨੂੰ ਤਕਲੀਫ ਹੈ ਉਹ ਸਾਨੂੰ ਹਰ ਰੋਜ਼ ਸਾਨੂੰ ਝੇਲਣੀ ਪਏਗੀ.
I'm not trying to tell you how to feel or what you should take from this.
कहने मैं नहीं चाहता कि ਤੁਸੀਂ ਜੋ ਵੀ ਮੈਂ ਕਹਿ ਰਿਹਾ ਤੁਸੀਂ ਉਹਨੂੰ ਮਹਿਸੂਸ ਕਰੋ ਜਾਂ ਕਿਸ ਤਰ੍ਹਾਂ ਮਹਿਸੂਸ ਕਰੋਗੇ ਮੈਨੂੰ ਨਹੀਂ ਪਤਾ.
But I hope you understand the damage you've done.
लेकिन कहते मैं सिर्फ चाहना कि ਤੁਸੀਂ ਇਹ ਸਮਝੋ ਕਿ ਤੁਸੀਂ ਜੋ ਨੁਕਸਾਨ ਸਾਨੂੰ ਪਹੁੰਚਾਇਆ ਹੈ
Not just to my father, but to every person who loved him.
कहने ना सिर्फ ना मेरे बाप ਨੂੰ ਨੁਕਸਾਨ ਪਹੁੰਚਾਇਆ ਬਲਕਿ ਹਰ ਉਸ ਸ਼ਖਸ ਨੂੰ ਪਹੁੰਚਿਆ ਜੋ ਮੇਰੇ ਬਾਪ ਨੂੰ ਪਿਆਰ ਕਰਦਾ ਸੀ.
We are serving a life sentence of grief.
कहने ਸਾਨੂੰ ਸਾਰੀ ਜ਼ਿੰਦਗੀ ਵਾਸਤੇ ਜਿਹੜਾ ਨਾ ਸਜ਼ਾ ਮਿਲ ਗਈ ਹੈ ਦੁੱਖ ਦੀ.
And I hope you never forget the name William Troy Bolin or the impact of your actions.
कहने कि ਤੁਸੀਂ ਮੈਂ ਉਮੀਦ ਕਰਨਾ ਕਿ ਤੁਸੀਂ ਮੇਰੇ ਬਾਪ ਦਾ ਨਾਂ ਕਦੀ ਸਾਰੀ ਜ਼ਿੰਦਗੀ ਨਹੀਂ ਭੁੱਲੋਗੇ.
Thank you, Niall Allen Bolin.
ਆਪਣਾ ਸ਼ੁਕਰੀਆ ਅਦਾ ਕਰ ਰਿਹਾ ਤੇ ਨਾ ਆਪਣਾ ਨਾਂ ਦੱਸ ਰਿਹਾ ਨਾਇਲ ਬੋਲਨ.
Is that it, Ms. Carey?
ਪੁੱਛ ਰਹੇ ਨੇ ਕੁਝ ਹੋਰ ਕਹਿਣਾ ਹੈ?
Yes.
ਕਹਿੰਦੀ ਹਾਂ।
Allocution, Mr. Gurmurthy. Allocution, Mr. Gurmurthy. Mr. Gurmurthy, is there anything you would like to say?
ਮਿਸਟਰ ਗਰੋਮਿਨੀ ਨੂੰ ਪੁੱਛਣਾ ਹੈ, ਤੁਸੀਂ ਕੁਝ ਕਹਿਣਾ ਚਾਹੁੰਦੇ ਹੋ?
Just briefly, Judge, Mr. Singh is 29 years of age. He will be 30 in a month.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਦੱਸ ਰਹੇ ਨੇ ਕਿ ਮਿਸਟਰ ਸਿੰਘ ਜਿਹੜੇ 29 ਸਾਲ ਦੇ ਨੇ, 30 ਸਾਲ ਦੇ ਹੋਣ ਵਾਲੇ ਨੇ।
His to-be wife is here in the court, who's in the back of the courtroom as his support.
ਕਹਿੰਦੇ ਨੇ ਉਹਨਾਂ ਦੀ ਜਿਹੜੀ ਹੋਣ ਵਾਲੀ ਬੀਵੀ ਹੈ ਉਹ ਕੋਰਟ ਰੂਮ ਵਿੱਚ ਬੈਠੀ ਹੈ ਸਪੋਰਟ ਵਾਸਤੇ।
Mr. Singh, from the very beginning of this case, has expressed his remorse and
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਮਿਸਟਰ ਸਿੰਘ ਜਦੋਂ ਦਾ ਕੇਸ ਸਟਾਰਟ ਹੋਇਆ ਉਹਨਾਂ ਨੂੰ ਇਸ ਗੱਲ ਦਾ ਬੜਾ ਅਫਸੋਸ ਹੈ।
and his apology for how this tragic accident occurred.
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਇਸ ਗੱਲ ਤੋਂ ਮਾਫੀ ਮੰਗਦੇ ਨੇ ਕਿ ਉਹ ਗੱਲ ਤੋਂ ਉਹਨਾਂ ਨੂੰ ਬੜਾ ਅਫਸੋਸ ਹੈ ਤੇ ਉਸ ਗੱਲ ਤੋਂ ਮਾਫੀ ਮੰਗਦੇ ਨੇ ਕਿ ਉਹਨਾਂ ਕੋਲੋਂ ਗਲਤੀ ਹੋਈ ਹੈ।
Mr. Singh does not have any prior criminal record.
ਮਿਸਟਰ ਸਿੰਘ ਦਾ ਇਸ ਤੋਂ ਪਹਿਲੇ ਉਹਨਾਂ ਨੇ ਕੋਈ ਵੀ ਗੈਰ ਕਾਨੂੰਨੀ ਕੰਮ ਨਹੀਂ ਕੀਤਾ।
Mr. Singh indicates to me that in his adult life and in his teenage life, he's never consumed alcohol or any drugs.
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਮਿਸਟਰ ਸਿੰਘ ਨੇ ਆਪਣੀ ਕਦੀ ਵੀ ਜਵਾਨੀ ਚ ਜਾਂ ਇਸ ਉਮਰ ਚ ਵੀ ਅੱਜ ਤੱਕ ਕੋਈ ਡਰਗ ਨਹੀਂ ਕੀਤਾ ਤੇ ਨਾ ਕੁਝ ਪੀਤਾ ਹੈ।
That is evident from the lab results in this matter that Mr. Singh's blood screens were clean. There were no drugs or alcohol.
ਉਹਨਾਂ ਦੀ ਬਲੱਡ ਰਿਪੋਰਟ ਵਿੱਚ ਵੀ ਇਹ ਆਇਆ ਕਿ ਉਹਨਾਂ ਦਾ ਬਿਲਕੁਲ ਕਲੀਨ ਹੈ, ਸਾਰਾ ਕੁਝ ਸਾਫ਼ ਹੈ, ਕੁਝ ਨਹੀਂ ਇਹਨਾਂ ਕੀਤਾ।
Mr. Singh understood the pros and cons of the nature of the offenses and took advantage of the offer that was tendered.
ਕਹਿੰਦੇ ਮਿਸਟਰ ਸਿੰਘ ਨੂੰ ਜੋ ਆਫਰ ਕਰ ਰਹੇ ਨੇ ਉਹਨਾਂ ਦੇ ਨੁਕਸਾਨ ਤੇ ਉਹਨਾਂ ਫਾਇਦੇ ਦਾ ਸਭ ਦਾ ਪਤਾ ਹੈ।
Mr. Singh indicates he's a very religious individual.
ਮਿਸਟਰ ਸਿੰਘ ਨੇ ਦੱਸਿਆ ਕਿ ਉਹ ਬਹੁਤ ਹੀ ਮਜ਼ਹਬੀ ਬੰਦੇ ਨੇ।
He goes to the Sikh temple, which is known as a Gurdwara, every Sunday.
ਉਹ ਹਰ ਇਤਵਾਰ ਨੂੰ ਆਪਣਾ ਗੁਰਦੁਆਰੇ ਜਾਂਦੇ ਨੇ।
He volunteers there.
ਉਹ ਜਾ ਕੇ ਉੱਥੇ ਵਾਲੰਟੀਅਰ ਵੀ ਕਰਦੇ ਨੇ।
Helps individuals at a Sikh temple.
ਹਾਂ, ਸਿੱਖ ਟੈਂਪਲ ਤੇ ਜਾ ਕੇ ਲੋਕਾਂ ਦੀ ਮਦਦ ਵੀ ਕਰਦੇ ਨੇ।
And he's done that, from my understanding, for the last several years, as a teenager growing up into an adult.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਹਾਂ ਤੱਕ ਮੈਨੂੰ ਪਤਾ ਹੈ ਉਹ ਬਚਪਨ ਤੋਂ ਲੈ ਕੇ ਟੀਨੇਜ ਤੋਂ ਲੈ ਕੇ ਹੁਣ ਤੱਕ ਵੀ ਉਹ ਲੋਕਾਂ ਦੀ ਉੱਥੇ ਮਦਦ ਵੀ ਕਰਦੇ ਨੇ ਤੇ ਵਾਲੰਟੀਅਰ ਵਰਕ ਵੀ ਕਰਦੇ ਨੇ ਗੁਰਦੁਆਰੇ 'ਚ।
And he does so regularly, helping other individuals in need.
ਹਾਂ, ਦੂਸਰੇ ਬੰਦਿਆਂ ਦੀ ਮਦਦ ਕਰਦੇ ਨੇ ਰੈਗੂਲਰਲੀ, ਰੋਜ਼ ਜਦੋਂ ਵੀ ਕਰਦੇ ਨੇ ਜਾ ਕੇ ਸੰਡੇ ਨੂੰ।
Certainly, Mr. Singh, this was just a tragic accident. He understands the gravity of the situation.
ਕਹਿੰਦੇ ਨੇ ਮਿਸਟਰ ਸਿੰਘ ਜਿਹੜੇ ਨੇ ਇਸ ਗੱਲ ਨੂੰ, ਜੋ ਹਾਦਸਾ ਹੋਇਆ ਹੈ ਉਹ ਬਹੁਤ ਦੁੱਖ ਭਰਾ ਹੈ ਤੇ ਉਸ ਗੱਲ ਨੂੰ ਉਹ ਸਮਝਦੇ ਨੇ।
Certainly, if Mr. Singh could change the outcome of the day, he would.
ਕਹਿੰਦੇ ਨੇ ਅਗਰ ਉਹਨਾਂ ਦੇ ਵੱਸ ਚ ਹੁੰਦਾ ਤੇ ਸ਼ਾਇਦ ਉਹ ਗੱਲ ਨਾ ਹੁੰਦੀ।
The tragic accident occurred at the County Line Road coming north on 131 with speed limit changes.
ਕਹਿੰਦੇ ਨੇ ਉਹ ਕਾਉਂਟੀ ਜਿਹੜਾ ਹੈ 131 ਤੇ ਉਹ ਜਿਹੜਾ ਕੰਟਰੀ ਰੋਡ ਤੇ ਹੋਇਆ ਹੈ ਜਿੱਥੇ ਸਪੀਡ ਜਿਹੜੀ ਹੈ ਬਦਲ ਜਾਂਦੀ ਹੈ।
And around the curve, and I don't know what happened with how Mr. Singh ended up in the southbound lane.
ਕਹਿੰਦੇ ਮੈਨੂੰ ਨਹੀਂ ਪਤਾ ਕਿ ਕਰਬ ਤੇ ਉੱਤੇ ਜਾ ਕੇ ਕੀ ਹੋਇਆ ਹੈ।
Mr. Singh's indication is that the pickup truck that was driving with a trailer towed behind it.
ਕਹਿੰਦੇ ਕਿ ਮਿਸਟਰ ਸਿੰਘ ਜਿਹੜੇ ਨੇ ਦੱਸਿਆ ਕਿ ਜਿਹੜਾ ਪਿਕਅਪ ਟਰੱਕ ਸੀ ਉਹਦੇ ਪਿੱਛੇ ਟ੍ਰੇਲਰ ਸੀ ਜਿਹੜਾ।
And the trailer was fishtailing.
ਉਹ ਕਹਿੰਦੇ ਜਿਹੜਾ ਟ੍ਰੇਲਰ ਸੀ ਉਹ ਫਿਸ਼ ਟ੍ਰੇਲਰ ਸੀ।
And I don't have an explanation what happened after that. It was
ਕਹਿੰਦੇ ਉਸ ਤੋਂ ਬਾਅਦ ਮੈਨੂੰ ਨਹੀਂ ਪਤਾ ਕਿ ਕੀ ਹੋਇਆ ਸੀ।
I did submit a couple of letters, at least as a way of an explanation, and Mr. Singh would further explain regarding the bond violation.
ਕਹਿੰਦੇ ਨੇ ਮੈਂ ਆਲਰੇਡੀ ਜਿਹੜੇ ਨੇ ਪੇਪਰ ਜਿਹੜੇ ਨੇ ਸਬਮਿਟ ਕਰਦੇ ਨੇ ਕਿ ਜੋ ਵੀ ਉਸ ਵਕਤ ਹੋਇਆ ਹੈ ਜਾਂ ਜੋ ਉਹਨਾਂ ਦੀ ਮਾਈਲੇਜ ਸੀ ਸਾਰੇ ਮੈਂ ਪੇਪਰ ਸਬਮਿਟ ਕਰਤੇ ਨੇ ਕੋਰਟ ਨੂੰ
In cases like this, Judge, there is, nobody wins. There is no good outcome. We suddenly have somebody who's deceased.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਇਸ ਕੇਸ ਵਿੱਚ ਕੋਈ ਜਿੱਤਿਆ ਤੇ ਕੋਈ ਹਾਰਿਆ ਨਹੀਂ ਐਂਡ ਆਈ ਹੈ ਕਿ ਇੱਕ ਬੰਦੇ ਦੀ ਜਾਨ ਗਈ ਹੈ
And certainly Mr. Singh has to live with the trauma of being involved in an accident that caused death.
ਕਹਿੰਦੇ ਨੇ ਮਿਸਟਰ ਸਿੰਘ ਨੂੰ ਇਸ ਗੱਲ ਨਾਲ ਜੀਣਾ ਪਵੇਗਾ ਕਿ ਉਹਨਾਂ ਦੀ ਵਜ੍ਹਾ ਤੋਂ ਕਿਸੇ ਦੀ ਜ਼ਿੰਦਗੀ ਚਲੀ ਗਈ
Mr. Singh has his own childhood trauma as well, where he lost his mother at a young age.
ਕਹਿੰਦੇ ਨੇ ਮਿਸਟਰ ਸਿੰਘ ਦੀ ਆਪਣੀ ਜ਼ਿੰਦਗੀ ਵਿੱਚ ਜਿਹੜਾ ਹੈ ਉਸ ਗੱਲ ਦਾ ਬਹੁਤ ਤਕਲੀਫ ਤੇ ਹੈ ਕਿ ਉਹਨਾਂ ਦੀ ਮਾਂ ਬੜੀ ਛੋਟੀ ਉਮਰ ਵਿੱਚ ਚਲੀ ਗਈ ਸੀ ਉਹਨਾਂ ਵਾਸਤੇ
And then about 7 or 8 years ago, lost his father and has no other family support of his own either.
ਹਾਂ ਕਹਿੰਦੇ ਉਹਨਾਂ ਨੂੰ ਕੋਈ ਵੀ ਫੈਮਿਲੀ ਸਪੋਰਟ ਨਹੀਂ ਉਹਨਾਂ ਦੇ ਫਾਦਰ ਦੀ ਵੀ ਡੈਥ ਹੋ ਗਈ ਸੀ
Suddenly Mr. Singh understands how Niall Boland also feels because of this tragic accident.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਸਮਝਦੇ ਨੇ ਕਿ ਉਹਨਾਂ ਦਾ ਬੇਟਾ ਜਿਹੜਾ ਹੈ ਨਾਇਲ ਬੋਲਿੰਗ ਜੋ ਹੈ ਉਹ ਕਿਸ ਤਰ੍ਹਾਂ ਮਹਿਸੂਸ ਕਰ ਰਿਹਾ ਹੋਏਗਾ
And suddenly Mr. Singh extends his condolences as well to the Boland family.
ਕਹਿੰਦੇ ਮਿਸਟਰ ਸਿੰਘ ਜਿਹੜੇ ਨੇ ਉਹ ਵੀ ਆਪਣਾ ਜਿਹੜਾ ਨਾ ਆਪਣੇ ਅਫਸੋਸ ਦਾ ਇਜ਼ਹਾਰ ਜਿਹੜਾ ਹੈ ਉਹਨਾਂ ਦੇ ਨਾਲ ਉਹਨਾਂ ਦੀ ਫੈਮਿਲੀ ਬੋਲਿੰਗ ਫੈਮਿਲੀ ਦੇ ਨਾਲ ਕਰਦੇ ਨੇ
That's all I have, Judge.
ਮੈਨੂੰ ਇਹੀ ਕਹਿਣਾ ਸੀ
Ms. Carey.
Mr. Boland's son wrote that this was not an accident, but a preventable tragedy.
ਕਹਿੰਦੇ ਨੇ ਮਿਸਟਰ ਬੋਲਿੰਗ ਦੇ ਬੇਟੇ ਨੇ ਲਿਖਿਆ ਹੈ ਕਿ ਇਹ ਜਿਹੜਾ ਹੈ ਨਾ ਇਹ ਟ੍ਰੈਜਿਕ ਹਾਦਸਾ ਤੇ ਹੈਗਾ ਲੇਕਿਨ ਇਹ ਬਚਾਇਆ ਜਾ ਸਕਦਾ ਸੀ
And it was preventable.
ਕਹਿੰਦੇ ਇਹ ਬਚਾਇਆ ਜਾ ਸਕਦਾ ਸੀ
I find it interesting that the defendant's counsel stated that the defendant thought the victim was fishtailing a little.
ਕਹਿੰਦੇ ਕਿ ਮੈਨੂੰ ਇੰਟਰਸਟਿੰਗ ਲੱਗਿਆ ਕਿ ਜਿਹੜਾ ਡਿਫੈਂਡੈਂਟ ਨੇ ਕਿਹਾ ਕਿ ਉਹ ਜਿਹੜਾ ਉਹਦਾ ਜਿਹੜਾ ਟ੍ਰੇਲਰ ਸੀ ਉਹ ਫਿਸ਼ ਟ੍ਰੇਲਰ ਸੀ
There was a lot of traffic that morning.
ਕਹਿੰਦੇ ਉਸ ਦਿਨ ਬਹੁਤ ਸਾਰੀ ਟ੍ਰੈਫਿਕ ਸੀ ਸੜਕ ਤੇ
There were a lot of witness statements.
ਕਹਿੰਦੇ ਬਹੁਤ ਸਾਰੀ ਉੱਥੇ ਜਿਹੜੇ ਸਨ ਬਾਕੀ ਵੀ ਜਿਹੜੇ ਲੋਕ ਸਨ ਗਵਾਹ ਸਨ
And no one else said that.
ਕਿਸੇ ਹੋਰ ਨੇ ਇਹ ਗੱਲ ਨਹੀਂ ਕਹੀ
The driver of the vehicle,
ਜੋ ਡਰਾਈਵਰ ਜਿਹੜਾ ਗੱਡੀ ਦਾ ਡਰਾਈਵਰ ਸੀ
the defendant was trying to pass.
ਜਿਹੜਾ ਜਦੋਂ ਉਹ ਪਾਸ ਕਰਨ ਦੀ ਕੋਸ਼ਿਸ਼ ਕਰ ਰਿਹਾ ਸੀ ਉਹਨਾਂ ਨੂੰ ਡਿਫੈਂਡੈਂਟ
Reported he saw the defendant coming up behind him at a high rate of speed. He rear-ended.
ਉਹਨੂੰ ਇਹ ਲੱਗਦਾ ਸੀ ਕਿ ਉਹ ਪਿੱਛੋਂ ਆ ਕੇ ਗੱਡੀ ਮਾਰ ਦੇਗਾ ਪਿੱਛੋਂ
He then saw the defendant put on his left blinker and get into the southbound lane.
ਕਹਿੰਦੇ ਉਹਨੇ ਦੇਖਿਆ ਕਿ ਉਹਨੇ ਜਿਹੜਾ ਨਾ ਖੱਬੇ ਪਾਸੇ ਦਾ ਜਿਹੜਾ ਨਾ ਇੰਡੀਕੇਟਰ ਜਿਹੜਾ ਬਲਿੰਕਰ ਦਿੱਤਾ ਸੀ ਕਿ ਉਹ ਸਾਊਥ ਬਾਉਂਡ ਤੇ ਜਾਣ ਲੱਗਾ
He reported about the time defendant got parallel to his driver window, the accident occurred.
ਕਹਿੰਦੇ ਜੋ ਕਰਨ ਹੀ ਲੱਗਾ ਸੀ ਤੇ ਉਸੇ ਵਕਤ ਜਿਹੜਾ ਹਾਦਸਾ ਹੋ ਗਿਆ
The people are surprised there weren't more injury or death because of this accident.
ਕਹਿੰਦੇ ਲੋਕੀ ਹੈਰਾਨ ਸਨ ਕਿ ਕੀ ਹੋਇਆ ਮਤਲਬ ਕੋਈ ਜ਼ਖਮੀ ਹੋਏਗਾ ਜਾਂ ਮਰ ਜਾਏਗਾ ਇਸ ਤਰ੍ਹਾਂ ਦਾ ਵਾਕਿਆ ਸੀ
Another witness stated
ਇੱਕ ਹੋਰ ਉੱਥੇ ਗਵਾਹ ਉਹਨੇ ਕਿਹਾ
the defendant seemed to be tailgating.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਿਹੜਾ ਡਿਫੈਂਡੈਂਟ ਹੈ ਉਹ ਤੇਜ਼ ਆ ਰਿਹਾ ਸੀ
And when he tried to pass, he struck the victim's vehicle.
ਕਹਿੰਦੇ ਕਿ ਉਹ ਜਿਹੜਾ ਸੀ ਉਹ ਤੇਜ਼ ਆ ਰਿਹਾ ਸੀ ਤੇ ਜਿਹੜਾ ਉਹਦਾ ਟਰੱਕ ਹੈ ਉਹਨੇ ਵਹੀਕਲ ਨੂੰ ਕਰੀਬ ਆਇਆ ਉਹਦੇ।
Third witness reported
ਜਿਹੜਾ ਤੀਸਰਾ ਗਵਾਹ ਹੈ ਉਹ ਕਹਿੰਦਾ ਹੈ
watching the defendant whip into the southbound lane. He thought there wasn't enough time for defendant to pass.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਦੋਂ ਉਹਨੂੰ ਡਿਫੈਂਡੈਂਟ ਨੂੰ ਨੇ ਵੇਖਿਆ ਕਿ ਉਹਦੇ ਕੋਲ ਇੰਨਾ ਟਾਈਮ ਨਹੀਂ ਹੈਗਾ ਸੀ ਕਿ ਉਹਨੂੰ ਉਹ ਪਾਸ ਕਰ ਸਕਦਾ ਸਾਊਥ ਬਾਉਂਡ ਤੇ ਜਾਣ ਵਾਸਤੇ।
The fourth witness
ਜਿਹੜਾ ਚੌਥਾ ਵਿਟਨੈਸ ਹੈ
reported her attention was drawn to the defendant, believing he did not have enough time to
ਉਹ
pass.
ਕਹਿੰਦੇ ਮੈਨੂੰ ਉਹਨੂੰ ਚੌਥੇ ਵੇ ਨੂੰ ਇਹ ਲੱਗਦਾ ਕਿ ਉਹਦੇ ਕੋਲ ਇੰਨਾ ਟਾਈਮ ਨਹੀਂ ਸੀ ਕਿ ਉਹਨੂੰ ਪਾਸ ਕਰ ਸਕਦਾ, ਇੰਨਾ ਟਾਈਮ ਨਹੀਂ ਹੈਗਾ ਸੀ ਉਹਦੇ ਕੋਲ।
And the crash happened almost immediately as defendant entered the southbound lane.
ਕਹਿੰਦੇ ਇੱਕਦਮ ਹਾਦਸਾ ਹੋਇਆ, ਜਿਵੇਂ ਉਹ ਸਾਊਥ ਬਾਉਂਡ ਲੇਨ ਦੇ ਕੋਲ ਪਹੁੰਚਿਆ ਤੇ ਉਹਦੇ ਕੋਲ ਇੰਨਾ ਟਾਈਮ ਨਹੀਂ ਸੀ ਤਾਂ ਫੌਰਨ ਹੀ ਹਾਦਸਾ ਹੋ ਗਿਆ।
As the court can imagine, this was a horrific scene.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਕੋਰਟ ਸਮਝ ਸਕਦਾ ਕਿ ਕਿੰਨਾ ਖੌਫਨਾਕ ਵਾਕਿਆ ਹੋਏਗਾ ਉਸ ਵਕਤ।
The victim's vehicle ended up under the semi truck.
ਕਹਿੰਦੇ ਜਿਹਦਾ ਹਾਦਸਾ ਹੋਇਆ ਉਹਦੀ ਜਿਹੜੀ ਗੱਡੀ ਸੀ ਉਹ ਟਰੱਕ ਦੇ ਥੱਲੇ ਚਲੀ ਗਈ।
And he was dragged quite a long way.
ਉਹਨੂੰ ਖਿੱਚਦਾ ਕਾਫੀ ਦੂਰ ਤੱਕ ਲੈ ਗਿਆ।
This was the 131 was closed for hours.
ਕਹਿੰਦੇ ਨੇ ਉਹ ਜਿਹੜੀ 134 ਜਿਹੜੀ ਹੈ ਨਾ ਉਹ ਕਾਫੀ ਘੰਟਿਆਂ ਵਾਸਤੇ ਬੰਦ ਕਰ ਦਿੱਤੀ।
The debris cleanup was horrific because of the nature of the injuries.
ਕਹਿੰਦੇ ਉੱਥੇ ਬੜਾ ਮੁਸ਼ਕਿਲ ਨਾਲ ਸਾਰੀ ਸਫਾਈ ਕੀਤੀ ਗਈ ਜੋ ਹਾਦਸਾ ਹੋਇਆ ਉਹਦੀ ਵਜ੍ਹਾ ਤੋਂ।
The defendant was in a hurry to get somewhere and totally disregarded the other vehicles on the road.
ਕਹਿੰਦੇ ਉਹ ਛੇਤੀ ਨਾਲ ਕਿਧਰ ਜਾਣਾ ਚਾਹ ਰਿਹਾ ਸੀ, ਉਹਨੇ ਉਸ ਚੀਜ਼ ਦਾ ਧਿਆਨ ਨਹੀਂ ਕੀਤਾ।
It was preventable.
ਕਹਿੰਦੇ ਉਹ ਬਚ ਸਕਦਾ ਸੀ ਵਾਕਿਆ।
And needless.
ਕਹਿੰਦੇ ਉਹ ਬਚ ਸਕਦਾ ਸੀ ਜੋ ਹੋਇਆ ਸੀ ਉਹ ਮਾਮਲਾ।
He does, upon information and belief, he's not from Michigan, the defendant. He does not have a criminal record that we know of, but he doesn't have a perfect driving record. He had a speeding ticket in 2023.
ਕਹਿੰਦੇ ਨੇ ਉਹ ਮਿਸ਼ੀਗਨ ਤੋਂ ਨਹੀਂ ਹੈਗਾ ਲੇਕਿਨ ਉਹਦਾ ਰਿਕਾਰਡ ਜਿਹੜਾ ਹੈ ਉਹ ਬਿਲਕੁਲ ਸਹੀ ਹੈ, ਇੱਕ ਟਿਕਟ ਹੈਗਾ।
And it also under our understanding.
ਕਹਿੰਦੇ ਅਸੀਂ ਜੋ ਸਮਝ ਰਹੇ ਹਾਂ ਸਾਡੇ ਮੁਤਾਬਕ
that his license was suspended in California for a period of time.
ਕਹਿੰਦੇ ਨੇ ਉਹਦਾ ਲਾਇਸੈਂਸ ਜਿਹੜਾ ਕੈਲੀਫੋਰਨੀਆ ਵਿੱਚ ਕਾਫੀ ਦੇਰ ਵਾਸਤੇ ਸਸਪੈਂਡ ਕਰ ਦਿੱਤਾ ਗਿਆ ਸੀ।
Your Honor, because the defendant is not from here.
ਉਹ ਕਹਿ ਰਹੀ ਜੱਜ ਸਾਹਿਬ ਨੂੰ ਕਿ ਕਿਉਂਕਿ ਡਿਫੈਂਡੈਂਟ ਜਿਹੜਾ ਮਿਸ਼ੀਗਨ ਤੋਂ ਨਹੀਂ ਹੈਗਾ।
Because this was preventable.
ਇਹ ਹਾਦਸਾ ਰੁਕ ਸਕਦਾ ਸੀ, ਬਚ ਸਕਦਾ ਸੀ।
The people are going to ask for a jail sentence. This death caused, obviously, great, I don't even have the word to express what this family is going through, the Boland family, not to mention the victims. I forget, I'm sorry.
ਕਹਿੰਦੇ ਕਿ ਮੈਂ ਐਕਸਪ੍ਰੈਸ ਨਹੀਂ ਕਰ ਸਕਦੀ ਕਿ ਜੋ ਇਹ ਹਾਦਸਾ ਹੋਇਆ ਹੈ ਉਹਨਾਂ ਦੀ ਫੈਮਿਲੀ ਤੇ ਕੀ ਬੀਤ ਰਹੀ ਹੈ, ਮੈਂ ਇਸ ਗੱਲ ਨੂੰ ਕਹਿ ਵੀ ਨਹੀਂ ਸਕਦੀ।
Not to mention the trauma it caused to the witnesses.
ਕਹਿੰਦੀ ਜੋ ਟਰਾਮਾ ਜਿਹੜਾ ਜਿਹੜਾ ਕਿ ਉਹ ਜਿਹੜੇ ਵਿਟਨੈਸ ਸਨ ਜਿਹੜੇ ਗਵਾਹ ਸਨ ਉਹ ਵੀ ਜਿਹੜਾ ਨੇ ਉਹ ਵੀ ਉਸ ਚੀਜ਼ ਤੋਂ ਬੜੇ ਪਰੇਸ਼ਾਨ ਹੋਏ ਨੇ ਵੇਖ ਕੇ
And the first responders.
ਔਰ ਤੇ ਜਿਨ੍ਹਾਂ ਨੇ ਜਾ ਕੇ ਸਭ ਤੋਂ ਪਹਿਲੇ ਵੇਖਿਆ ਹੈ, ਉਹਨਾਂ ਨੂੰ ਵੀ ਬਹੁਤ ਧਚਕਾ ਲੱਗਿਆ ਇਸ ਗੱਲ ਤੋਂ
The victim's son said
ਜੋ
it.
ਉਹਦਾ ਬੇਟਾ ਹੈ
The defendant's choices that day have consequences, and the people are going to ask for a jail sentence of the maximum 1 year. Thank you.
ਹਾਂ ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹਦਾ ਬੇਟਾ ਕਹਿੰਦਾ ਹੈ ਕਿ ਜੋ ਹੋਇਆ ਉਹਦਾ ਨਤੀਜਾ ਜਿਹੜਾ ਹੈ ਜੋ ਨਿਕਲਦਾ ਹੈ 1 ਸਾਲ ਦੀ ਸਜ਼ਾ ਜਿਹੜੀ ਹੈ ਨਾ ਉਹ ਕਹਿੰਦੇ ਨੇ ਉਹਦਾ ਨਤੀਜਾ ਹੋਣਾ ਚਾਹੀਦਾ
I just want to add one thing if I could. Speak up. I wanted to add one thing if I could.
ਉਹ ਕਹਿੰਦੇ ਨੇ ਸ਼ਾਰਾ ਨੇ ਤੁਹਾਡਾ ਵਕੀਲ ਕਹਿ ਰਿਹਾ ਕਿ ਮੈਂ ਕੋਈ ਗੱਲ ਕਰਨਾ ਚਾਹਨਾ
Just in response to the residency, Mr. Singh intends to live in Michigan. He signed up for an apartment for a year in the Lansing area.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮਿਸਟਰ ਸਿੰਘ ਦਾ ਜਿਹੜਾ ਇਰਾਦਾ ਸੀ ਮਿਸ਼ੀਗਨ ਵਿੱਚ ਰਹਿਣ ਦਾ ਉਹਨਾਂ ਨੇ ਪ੍ਰਾਪਰਟੀ ਲੈਣਾ ਚਾਹ ਰਹੇ ਸਨ ਲੈਂਸਿੰਗ ਵਿੱਚ ਇੱਥੇ ਸੈਟਲ ਹੋਣ ਵਾਸਤੇ
Mr. Singh intends to live near his Sikh temple.
ਉਹ ਆਪਣੇ ਸਿੱਖ ਟੈਂਪਲ ਦੇ ਕੋਲ ਰਹਿਣਾ ਚਾਹ ਰਹੇ ਸਨ
And part of his way of coping with this is to participate in volunteering through the temple to deal with the problem he's going to deal with through this accident.
ਉਹ ਆਪਣੇ ਟੈਂਪਲ ਦੇ ਕੋਲ ਜਿਹੜਾ ਰਹਿਣਾ ਚਾਹ ਰਹੇ ਸਨ ਜਿੱਥੇ ਉਹ ਇਸ ਵਕਤ
He does not intend to go back to California this time.
ਜਾਂ ਉਹ ਕੈਲੀਫੋਰਨੀਆ ਦੇ ਵਿੱਚ ਹੈਗੇ ਸਨ ਜਿੱਥੇ
Mr. Singh, you have the right to address the court before sentencing. Is there anything you would like me to know?
Mr. Singh, ਤੁਸੀਂ ਕੁਝ ਕਹਿਣਾ ਚਾਹੁੰਦੇ ਹੋ? Are you saying no?
Mr. Singh, in regard to the alleged probation or bond violations, what can you tell me about that?
ਕਹਿੰਦੇ ਨੇ ਜਿਹੜਾ ਤੁਹਾਨੂੰ ਜਿਹੜਾ ਬੌਂਡ ਜਿਹੜਾ ਭਰਨਾ ਉਹਦੇ ਮੁਤਲਕ ਤੁਸੀਂ ਕੋਈ ਗੱਲ ਕਰਨਾ ਚਾਹੁੰਦੇ ਹੋ?
In particular, that you violated tether conditions with unauthorized stops on May 16th, 17th, and 18th.
ਕਹਿੰਦੇ ਜੋ ਤੁਸੀਂ May 17, 18 ਜਿੱਥੇ ਵੀ ਜਿੱਥੇ ਤੁਸੀਂ ਸਟਾਪ ਕੀਤੇ ਨੇ
ਮੈਂ ਕਹਿਣਾ ਚਾਹੁੰਦਾ ਹਾਂ
ਕੀ ਕਹਿ ਰਹੇ ਹੋ?
ਮੈਂ ਕਹਿਣਾ ਚਾਹੁੰਦਾ ਹਾਂ ਲਾਈਕ ਉਹ ਜੋ ਵਾਇਲੇਸ਼ਨ ਹੋਈਆਂ ਆ
Can you come up over there?
You may.
He wants to talk about the violation, sir, Your Honor.
Okay. What can you tell me about those dates?
ਕਹਿੰਦੇ ਨੇ ਉਹ ਜਿਹੜੇ ਉਹਨਾਂ ਦਿਨਾਂ ਵਿੱਚ ਕੀ ਹੋਇਆ ਸੀ ਦੱਸੋ?
ਪਹਿਲੇ ਦਿਨ ਲਾਈਕ ਮੈਂ ਇੱਥੇ ਕੈਲੀਫੋਰਨੀਆ ਤੋਂ ਨਹੀਂ ਹੈਗਾ ਮੈਂ ਕਿਸੇ ਦੀ ਕਾਰ ਲਈ ਸੀਗੀ ਆਪਣੇ ਫਰੈਂਡ ਦੀ ਜਿਨ੍ਹਾਂ ਦੇ ਕੋਲ ਰਿਹਾ ਇੱਥੇ ਆ ਕੇ
Oh, he's saying that he's not from California. He borrowed the car from from some friend.
Yeah. ਤੇ ਮੈਂ GPS ਵਾਲਿਆਂ ਨੂੰ ਟਾਈਮ ਦਿੱਤਾ ਸੀ 4 o'clock ਦਾ ਤੇ ਮੈਂ 20 ਮਿੰਟ ਲੇਟ ਹੋ ਗਿਆ ਸੀ ਕਿਉਂਕਿ ਉਹ ਟ੍ਰੈਫਿਕ ਸੀਗਾ ਮੈਂ ਕਾਰ ਬੈਕ ਕਰਨੀ ਸੀ ਤੇ ਉਹ ਮੈਨੂੰ ਵਾਪਸ ਘਰੇ ਛੱਡਣ ਗਏ ਸੀ
He said that he was late for 20 minutes for the GPS people because he has to go home. He was 20 minutes late.
ਦੂਜੇ ਕਮਿਸ਼ਨ ਸੀਗੀ ਸਵੇਰ ਤੋਂ ਲਾਈਕ 10 ਵਜੇ ਤੋਂ ਸ਼ਾਮ 7 ਵਜੇ ਦੀ
Yeah, he said that he has a permission from 10 to 3. ਤੁਸੀਂ ਕਹਿ ਰਹੇ ਹੋ?
Like 10 to 7, I think so.
10 to 7, he thinks so. He had a permission. So.
And when I go to like I have a permission. ਮੇਰੀ permission temple ਜਾਣ ਦੀ ਸੀਗੀ ਪਰ ਉਦੋਂ ਸਿੱਖ ਪਰੇਡ ਸੀਗੀ ਤੇ ਉਹਨਾਂ ਨੇ ਸਿੱਖ ਪਰੇਡ like downtown park 'ਚ ਰੱਖੀ ਸੀਗੀ.
He has a Sikh parade on that day, and they put it in the park for the Sikh parade. So he needs to go there.
ਹਾਂਜੀ ਤੇ ਉੱਥੇ ਫਿਰ ਮੈਂ ਲਾਈਕ ਆਪਣਾ ਵਲੰਟੀਅਰ ਦਾ ਕੰਮ ਕੀਤਾ ਸੀ, ਫੂਡ ਵਗੈਰਾ ਬਣਾਉਂਦਾ ਸੀ, ਉਹ ਮੇਰੇ ਕੋਲ ਬਣਾਉਂਦੇ ਦੀਆਂ ਪਿਕਚਰ ਵਗੈਰਾ ਵੀ ਹੈਗੀਆਂ ਕੰਮ ਕਰਦੇ ਦੀਆਂ ਤੇ
Yeah,
proof
he
ਵੀ
was
ਹੈਗਾ
doing,
ਤੁਹਾਡੇ
Mr. Singh, wait a second. He was volunteering over there, making foods for them, and he got the pictures of all that.
Is there anything else?
ਐਂਡ ਤੀਜੇ ਦਿਨ ਜਿਹੜੀ ਵਾਇਲੇਸ਼ਨ ਨਹੀਂ ਪਾਈ ਆ, ਮੈਂ ਟੈਂਪਲ ਜਾਣ ਦੀ ਪਰਮਿਸ਼ਨ ਲਈ ਸੀਗੀ ਤੇ ਉਹ ਮੁੰਡਾ ਜਿਹੜਾ ਮੈਨੂੰ ਛੱਡਣ ਗਿਆ ਸੀ ਤੇ ਅਸੀਂ 3 ਜਣੇ ਸੀਗੇ ਤੇ ਉਹ ਤੀਜੇ ਮੁੰਡੇ ਨੂੰ ਕੰਮ ਤੇ ਛੱਡਣ ਗਿਆ ਸੀ, ਪਰ ਮੈਂ ਉੱਥੇ ਸਟਾਪ ਨਹੀਂ ਸੀ ਕੀਤਾ ਤੇ ਉਹਨੇ ਉਹ ਵਾਇਲੇਸ਼ਨ ਪਾ ਦਿੱਤੀ ਸੀ।
He said that there were 3 of them and they need to go for the volunteer work, but they just put the violation like because they were just 3 over there. Then they went for, he got the permission, but that happened.
Okay. Anything else you want me to know?
No, it's okay.
कुछ और कहना चाहते हो?
नहीं.
No.
Okay, you can go back to your seat.
Okay.
वापस जा सकते हो.
I realize we're doing things a little unorthodox when it comes to the violation allegation.
कहते हैं कि मैं समझ रहा हूं कि जो भी वायलेशन जो औरत ते इल्जाम लगे ने और मुतल्लिक मैं गल करना चाहांगा.
Ms. Matsky, what can you tell me about the violations?
ਉਹਨਾਂ ਨੂੰ ਪੁੱਛ ਰਹੇ ਨੇ ਕਿ ਕੀ ਵਾਇਲੇਸ਼ਨ ਹੋਏ ਨੇ.
All 3 days had activities planned.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਿਹੜੇ ਨਾ ਜਿਹੜੀ ਤਿੰਨੋਂ ਦਿਨ ਦੀਆਂ ਜਿਹੜੀਆਂ ਐਕਟੀਵਿਟੀ ਸਨ ਜੋ ਵੀ ਉਹਨਾਂ ਨੇ ਦੱਸਿਆ ਸੀ ਉਹ ਪਲਾਨ ਕੀਤੀਆਂ ਹੋਈਆਂ ਸਨ.
On Friday, he was to move into his apartment.
ਕਹਿੰਦੇ ਫਰਾਈਡੇ ਨੂੰ ਤੁਸੀਂ ਆਪਣੇ ਅਪਾਰਟਮੈਂਟ ਮੂਵ ਹੋਣਾ ਸੀ.
He went, I'm not really sure where he went, but it was not just to move in the apartment, and the only approved thing was to move from one location to the new location.
ਕਹਿੰਦੀ ਮੈਨੂੰ ਨਹੀਂ ਇਸ ਚੀਜ਼ ਦਾ ਅੰਦਾਜ਼ਾ ਕਿ ਉਹ ਕਿੱਥੇ ਸੀ, ਲੇਕਿਨ ਉਹਨੂੰ ਅਪਰੂਵ ਨਹੀਂ ਹੈਗਾ ਸੀ ਕਿ ਇੱਕ ਜਗ੍ਹਾ ਤੋਂ ਦੂਸਰੀ ਜਗ੍ਹਾ ਉਹ ਜਾ ਸਕੇ.
On Saturday, he was to be at the temple all day long.
ਸੈਟਰਡੇ ਨੂੰ ਉਹਨੇ ਸਾਰਾ ਦਿਨ ਜਿਹੜਾ ਸੀ ਟੈਂਪਲ ਜਾਣਾ ਸੀ.
He did not go to the temple at all on Saturday, but he did leave his house.
ਕਹਿੰਦੇ ਉਹ ਘਰ ਛੱਡ ਕੇ ਚਲਾ ਗਿਆ ਸੀ ਲੇਕਿਨ ਟੈਂਪਲ ਬਿਲਕੁਲ ਨਹੀਂ ਗਿਆ ਸਾਰਾ ਦਿਨ.
On Sunday, he was also to go to the temple.
ਉਹਨੇ ਸੰਡੇ ਵੀ ਟੈਂਪਲ ਜਾਣਾ ਸੀ.
He did go to the temple, but he also went very far east.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਟੈਂਪਲ ਗਿਆ ਸੀ ਲੇਕਿਨ ਕਿਧਰੇ ਹੋਰ ਵੀ ਗਿਆ ਸੀ.
Which was not proved.
ਕਹਿੰਦੇ ਉਹਨੂੰ ਇਜਾਜ਼ਤ ਨਹੀਂ ਮਿਲੀ ਸੀ.
We had talked about not making unapproved stops multiple times prior.
ਕਹਿੰਦੇ ਕਿ ਕਾਫੀ ਜਗ੍ਹਾ ਤੋਂ ਜੋ ਇਜਾਜ਼ਤ ਜਿਹੜੀ ਜਗ੍ਹਾ ਤੇ ਨਹੀਂ ਮਿਲੀ ਸੀ ਉਹਨਾਂ ਨੇ ਕੀਤਾ ਮਲਟੀਪਲ ਟਾਈਮ.
Mr. Gurumurthy, anything in response to that?
ਪੁੱਛ ਰਹੇ ਨੇ ਤੁਹਾਡੇ ਵਕੀਲ ਕੋਲੋਂ ਕਿ ਕੁਝ ਕਹਿਣਾ ਚਾਹੁੰਦੇ ਹੋ?
My understanding for the Saturday violation is that. Ms. Rasul, do you want me to speak up a little louder?
ਹਾਂ ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਦੱਸਣਾ ਚਾਹ ਰਿਹਾ ਕਿ ਸੈਟਰਡੇ ਦੇ ਮੁਤਲਕ ਕੀ ਗੱਲ ਹੈ.
So Saturday, there's it's a Sikh festival called Baisakhi, which is the Christmas essentially for Sikhs. And there's a parade that would be held downtown Lansing through the temple, but not at the temple.
Okay, ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਿਹੜਾ ਜਿਸ ਤਰ੍ਹਾਂ ਵਿਸਾਖੀ ਜਿਹੜੀ ਹੈ ਉਹ ਕ੍ਰਿਸਮਸ ਦੀ ਤਰ੍ਹਾਂ ਹੁੰਦੀ ਹੈ, ਉਸ ਦਿਨ ਵਿਸਾਖੀ ਦੀ ਪਰੇਡ ਸੀ, ਉਹ ਟੈਂਪਲ ਵਿੱਚ ਨਹੀਂ ਹੁੰਦੀ, ਟੈਂਪਲ ਤੋਂ ਬਾਹਰ ਉਹਨਾਂ ਨੇ ਅਰੇਂਜ ਕੀਤੀ ਹੋਈ ਸੀ.
And my understanding is that is where there were either food stalls and other things set up, which is what Mr. Singh indicated, where he was cooking or again volunteering for the temple.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉੱਥੇ ਖਾਣ ਪੀਣ ਦੀ ਜਿਹੜਾ ਵੀ ਜੋ ਵੀ ਸਾਰੇ ਸਟਾਲ ਵਗੈਰਾ ਉੱਥੇ ਹੀ ਲਾਏ ਗਏ ਸੀ.
Mr. Singh did not know that the parade that would be downtown, not at the temple. So he sought permission to go to the temple, but it was not at the temple.
ਹਾਂ ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹਨਾਂ ਨੂੰ ਉੱਥੇ ਹੀ ਖਾਣ ਪੀਣ ਦਾ ਸਾਰਾ ਇੰਤਜ਼ਾਮ ਉੱਥੇ ਸੀ, ਇਸ ਪਾਸੇ ਉਹ ਟੈਂਪਲ ਨਹੀਂ ਗਏ ਤੇ ਉਹ ਉੱਥੇ ਹੀ ਸਨ ਪਰੇਡ ਵਿੱਚ.
The the Sunday violation, Mr. Singh indicates that it was
Sunday wale din
Mr. Singh indicates that it's a ride sharing situation where the individual that was giving the ride to the temple dropped somebody else first and then dropped him to the temple.
हाँ मिस्टर सिंह कहते ने कि ਉਹ ਟੈਂਪਲ ਜਾਣਾ ਸੀ ਲੇਕਿਨ ਉਹਨਾਂ ਨੂੰ ਪਹਿਲੇ ਕਿਸੇ ਨੂੰ ਡ੍ਰੌਪ ਕਰਨਾ ਸੀ ਕਿਸੇ ਜਗ੍ਹਾ ਤੇ
And as to the Friday, my understanding again is Mr. Singh moved from one apartment to the other, but had to go return moving the vehicle. And I think that's what he was trying to explain, that he was not, I think he was in a vehicle that had California tags, but it was not trying to go to California. It was a rented vehicle that he was, again, returning back, that was borrowed or rented. And got stuck in traffic and was 20 minutes late in getting back to his apartment.
हाँ कहते ने ਇਸ ਵਾਸਤੇ ਉਹ 20 ਮਿੰਟ ਜਿਹੜੇ ਸਨ ਉਹ ਲੇਟ ਹੋ ਗਏ ਸਨ ਉਹਨਾਂ ਨੇ ਕਿਸੇ ਨੂੰ ਡ੍ਰੌਪ ਕਰ
Ms. Carey, do you want to respond to any of that?
No, thank you.
ਉਹ ਕਿਆ ਪੁੱਛ ਰਹੇ ਨੇ ਕਿ ਤੁਸੀਂ ਕੋਈ ਗੱਲ ਕਹਿਣੀ ਹੈ ਉਹ ਕਹਿੰਦੀ ਨਹੀਂ
No, thank you.
ਉਹ ਕਹਿ ਰਹੀ ਹੈ ਨਹੀਂ ਸ਼ੁਕਰੀਆ
Well, these are always tough cases for a court to decide.
ਉਹ ਕਹਿੰਦੇ ਨੇ ਕਿ ਇਹ ਕੋਰਟ ਵਾਸਤੇ ਨਾ ਬੜੇ ਮੁਸ਼ਕਿਲ ਕੇਸ ਨੇ ਡਿਸਾਈਡ ਕਰਨਾ
First of all, I'm not going to find that there was a violation of the bond.
ਕਹਿੰਦੇ ਮੈਂ ਫਸਟ ਆਫ ਆਲ ਮੈਂ ਇਸ ਗੱਲ ਤੇ ਫਾਈਟ ਨਹੀਂ ਕਰਨਾ ਚਾਹੁੰਦਾ ਕਿ ਜਿਹੜੀ ਕੇਸ ਜਿਹੜੀ ਵਾਇਓਲੇਸ਼ਨ ਹੋਈ ਹੈ
Because there was not a plea taking presented to the court for that.
ਹਾਂ ਕਹਿੰਦੇ ਨੇ ਉਹਦੇ ਵਾਸਤੇ ਜਿਹੜੀ ਹੈ ਕਿਉਂਕਿ ਮੈਂ ਇਸ ਵਾਸਤੇ ਗੱਲ ਨਹੀਂ ਕਰਾਂਗੇ ਕਿ ਉਹਦੇ ਵਾਸਤੇ ਕੋਈ ਵੀ ਪਲੀ ਜਿਹੜੀ ਹੈ ਨਾ ਕੀਤੀ ਨਹੀਂ ਗਈ ਕੋਰਟ ਦੇ ਵਿੱਚ ਇਹਦੇ ਖਿਲਾਫ
However, I believe I can take what was presented to the court and consider that for sentencing purposes.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਉਹਦੇ ਬਾਵਜੂਦ ਮੈਂ ਇਸ ਚੀਜ਼ ਨੂੰ ਕੰਸੀਡਰ ਕਰ ਸਕਦਾ ਕਿ ਇਹਦੇ ਮੁਤਲਕ ਕੀ ਸਜ਼ਾ ਹੋ ਸਕਦੀ ਹੈ
It has been said multiple times today
ਕਹਿੰਦੇ ਨੇ ਕਾਫੀ ਦਫਾ ਇਹ ਗੱਲ ਦੁਹਰਾਈ ਗਈ ਹੈ
that essentially
ਕਿ ਜ਼ਰੂਰਤ ਪੈਣ ਤੇ
there will be no winners in this case.
nobody ਕਹਿੰਦੇ ਕਿ ਇਹਦੇ 'ਚ ਕੋਈ ਵੀ ਜਿੱਤ ਨਹੀਂ ਸਕਦਾ ਇਸ ਗੱਲ ਵਿੱਚ
No matter my sentence,
ਕਹਿੰਦੇ ਨੇ ਜੋ ਵੀ ਮਰਜ਼ੀ ਹੋ ਜਾਏ ਜੋ ਵੀ ਸਜ਼ਾ ਦਿਆਂਗਾ
Mr. Bolin is not coming back to his family.
ਕਹਿੰਦੇ ਨੇ ਮਿਸਟਰ ਬੋਲਿੰਗ ਜਿਹੜੇ ਆ ਉਹ ਵਾਪਸ ਆਪਣੀ ਜ਼ਿੰਦਗੀ 'ਚ ਵਾਪਸ ਆਪਣੀ ਫੈਮਿਲੀ 'ਚ ਨਹੀਂ ਆ ਸਕਦੇ
And his family will live with that emptiness
ਕਹਿੰਦੇ ਉਹਨਾਂ ਦੀ ਫੈਮਿਲੀ ਜਿਹੜੀ ਹੈ ਉਹ ਇਸ ਜਿਹੜਾ ਇਹ ਖਾਨਾ ਉਹਨਾਂ ਦਾ ਭਰ ਨਹੀਂ ਸਕਦਾ ਉਹ ਇਸ ਤਰ੍ਹਾਂ ਹੀ ਉਹਨਾਂ ਦੀ ਜ਼ਿੰਦਗੀ ਖਾਲੀ ਰਹੇਗੀ
for the rest of their existence.
ਹਾਂ ਸਾਰੀ ਜ਼ਿੰਦਗੀ ਉਹਨਾਂ ਦੀ ਲਾਈਫ ਜਿਹੜੀ ਹੈ ਇਸ ਤਰ੍ਹਾਂ ਹੀ ਗੁਜ਼ਰੇਗੀ ਜਦੋਂ ਤੱਕ ਉਹ ਜ਼ਿੰਦਾ ਨੇ
And it is a generational loss.
ਕਹਿੰਦੇ ਨੇ ਪੂਰੀਆਂ ਨਸਲਾਂ ਦਾ ਜਿਹੜਾ ਨੁਕਸਾਨ ਹੈ
There will be other grandkids or great grandkids
ਕਹਿੰਦੇ ਨੇ ਉਹਨਾਂ ਦੇ ਬੱਚਿਆਂ ਦੇ ਬੱਚੇ ਜਿਹੜੇ ਨੇ ਉਹਨਾਂ ਦੇ ਗ੍ਰੇਟ ਚਿਲਡਰਨ ਜਿਹੜੇ ਨੇ ਉਹ ਵੀ ਮਹਿਸੂਸ ਕਰਨਗੇ ਇਸ ਲਾਸ ਨੂੰ
that will only know Mr. Bolin through stories.
ਕਹਿੰਦੇ ਨੇ ਉਹ ਮਿਸਟਰ ਬੋਲਿੰਗ ਨੂੰ ਜਿਹੜਾ ਨਾ ਯਾਦ ਕਰਨਗੇ ਸਿਰਫ ਕਹਾਣੀਆਂ ਦੇ ਤੌਰ ਤੇ ਉਹਨਾਂ ਦੀ ਗੱਲਾਂ ਕੀਤੀਆਂ ਜਾਣਗੀਆਂ
And not having the impact of him present in their lives.
ਉਹਨਾਂ ਨੂੰ ਜਿਹੜਾ ਉਹ ਵੇਖ ਨਹੀਂ ਸਕਣਗੇ ਉਹਨਾਂ ਦੀ ਜ਼ਿੰਦਗੀ 'ਚ
I wish the black robe came with a magic wand.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਸੋਚਣਾ ਕਿ ਕਾਸ਼ ਇਸ ਤਰ੍ਹਾਂ ਹੋਏ ਕਿ ਮੇਰੇ ਕੋਲ ਜਾਦੂ ਦੀ ਕੋਈ ਛੜੀ ਹੋਵੇ
And that I could bring him back.
ਕਿ ਮੈਂ ਉਹਨਾਂ ਨੂੰ ਵਾਪਸ ਲੈ ਕੇ ਆ ਸਕਾਂ
But I can't.
ਲੇਕਿਨ ਮੈਂ ਨਹੀਂ ਕਰ ਸਕਦਾ
We've also heard this referred to as both an accident
ਕਹਿੰਦੇ ਨੇ ਮੈਂ ਇਸ ਗੱਲ ਨੂੰ ਪਹਿਲੇ ਵੀ ਰੈਫਰ ਕਰ ਚੁੱਕਿਆ ਜਿਹੜੇ ਦੋਵੇਂ ਐਕਸੀਡੈਂਟ ਹੋਏ ਨੇ ਉਹਨਾਂ ਦੇ ਬਾਰੇ 'ਚ
and an avoidable tragedy.
ਕਹਿੰਦੇ ਨੇ ਇਹਨੂੰ ਅਵੋਇਡ ਕੀਤਾ ਜਾ ਸਕਦਾ ਸੀ ਇਹ ਚੀਜ਼ ਰੋਕੀ ਜਾ ਸਕਦੀ ਸੀ
Mr. Gurumurthy indicated that this happened near a speed limit change at County Line Road.
ਕਹਿੰਦੇ ਤੁਹਾਡੇ ਜਿਹੜਾ ਵਕੀਲ ਹੈ ਉਹਨੇ ਦੱਸਿਆ ਕਿ ਜਿੱਥੇ ਕਾਉਂਟੀ ਰੋਡ ਤੇ ਜਿੱਥੇ ਸਪੀਡ ਚੇਂਜ ਹੋਈ ਹੈ ਉੱਥੇ
But the court will take judicial notice
ਕਹਿੰਦੇ ਕੋਰਟ ਜਿਹੜਾ ਹੈ ਇਹਦੇ ਨੋਟ ਇਹਦਾ ਨੋਟਿਸ ਲਏਗਾ ਇਸ ਗੱਲ ਦਾ
that the speed limit changes
ਕਿ
several
ਜਿਹੜੀ
miles back
ਕਹਿੰਦੇ ਸਪੀਡ ਲਿਮਿਟ ਜਿਹੜੀ ਹੈ ਨਾ ਉਹ ਕਾਫੀ ਮੀਲ ਪਿੱਛੇ ਜਿਹੜੀ ਹੈ ਉਹ ਚੇਂਜ ਹੋ ਜਾਂਦੀ ਹੈ
to the south
ਸਾਊਥ ਉੱਤੇ
where the expressway for 131
ਜੋ ਐਕਸਪ੍ਰੈਸਵੇ ਜਿਹੜਾ ਹੈ 131 ਜਿਹੜਾ ਹੈ
meets the 2-lane 131.
ਹਾਂ ਜਿੱਥੇ ਜਾ ਕੇ ਦੋ ਲਾਈਨਾਂ ਮਿਲਦੀਆਂ ਨੇ 131 ਦੇ ਉੱਤੇ
To go,
ਜਾਂਦੀ ਹੈ ਚੜਾਈ ਜਿਹੜੀ ਹੈ
which with the court's experience with semis
ਕਹਿੰਦੇ ਨੇ ਕਿ ਕੋਰਟ ਨੂੰ ਇਸ ਚੀਜ਼ ਦਾ ਤਜਰਬਾ ਹੈ ਕਿ ਜਿਹੜੇ ਸੈਮੀ ਟਰੱਕ ਹੁੰਦੇ ਨੇ
take some speed reduction
ਕਹਿੰਦੇ ਨੇ ਉਹ ਆਪਣੀ ਸਪੀਡ ਜਿਹੜੀ ਹੈ ਨਾ ਘਟਾ ਲੈਂਦੇ ਨੇ
the court is well experienced
ਕਹਿੰਦੇ ਕੋਰਟ ਨੂੰ ਕਾਫੀ ਤਜਰਬਾ ਹੈ ਇਸ ਗੱਲ ਦਾ
in the operation of semi trucks or tractors and trailers
ਹਾਂ ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਿਸ ਤਰ੍ਹਾਂ ਟਰੈਕਟਰ ਟ੍ਰੇਲਰ ਜਿਹੜੇ ਸਮਾਂ ਟਰੱਕ ਚੱਲਦੇ ਨੇ ਕੋਰਟ ਨੂੰ ਪਤਾ ਹੈ ਕਿ ਕਿਸ ਤਰ੍ਹਾਂ ਉਹਨਾਂ ਨੂੰ ਆਪਰੇਟ ਕੀਤਾ ਜਾਂਦਾ
having been in a family
ਹਾਂ ਫੈਮਿਲੀ ਦੇ ਨਾਲ ਹੁੰਦੇ ਹੋਏ
that has operated these types of vehicles since the 1940s.
ਹਾਂ ਕਹਿੰਦੇ 1940 ਤੋਂ ਜਿਹੜੀਆਂ ਨੇ ਇਹ ਗੱਡੀਆਂ ਇਸ ਤਰ੍ਹਾਂ ਦੀਆਂ ਚੱਲ ਰਹੀਆਂ ਨੇ
Additionally, the court holds a commercial driver's license.
ਜਿਹੜੇ ਨੇ ਕਮਰਸ਼ੀਅਲ ਡਰਾਈਵਰ ਜਿਹੜੇ ਲਾਇਸੈਂਸ ਜਿਹੜੇ ਹੋਲਡ ਕਰਦੇ ਉਹਨਾਂ ਨੂੰ ਪਤਾ ਇਸ ਗੱਲ ਦਾ
I hear every day from those in the business
ਕਹਿੰਦੇ ਨੇ ਮੈਂ ਹਰ ਰੋਜ਼ ਸੁਣਨਾ ਜਿਹੜੇ ਇਸ ਬਿਜ਼ਨਸ ਵਿੱਚ ਹੁੰਦੇ ਨੇ
that the restrictions that the federal government places on commercial drivers
ਕਹਿੰਦੇ ਜੋ ਉਹਨਾਂ ਤੇ ਪਾਬੰਦੀਆਂ ਲਾਈਆਂ ਕਮਰਸ਼ੀਅਲ ਡਰਾਈਵਰ ਤੇ ਜਿਹੜੀ ਫੈਡਰਲ ਗਵਰਨਮੈਂਟ ਨੇ
keeps increasing and creates a burden.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹਨਾਂ ਤੇ ਬਰਡਨ ਜਿਹੜਾ ਪੈਂਦਾ ਪਿਆ ਜਿਹੜੀ ਰੈਸਟ੍ਰਿਕਸ਼ਨ ਲਾਉਂਦੇ ਨੇ ਹਰ ਸਾਲ
I can tell you, Mr. Singh,
ਕਹਿੰਦੇ ਮਿਸਟਰ ਸਿੰਘ ਮੈਂ ਤੁਹਾਨੂੰ ਦੱਸਣਾ
you are the reason these laws exist.
ਕਹਿੰਦੇ ਤੁਹਾਡੀ ਵਜ੍ਹਾ ਤੋਂ ਹੀ ਇਹੋ ਜਿਹੀ ਜਿਹੜੀ ਪਾਬੰਦੀਆਂ ਨੇ ਵੱਧਦੀਆਂ ਪਈਆਂ ਨੇ
This was an unavoidable disaster.
ਕਹਿੰਦੇ ਨੇ ਇਹ ਜਿਹੜਾ ਹਾਦਸਾ ਹੈ ਨਾ ਇਹ ਬਚ ਸਕਦਾ ਸੀ
A disaster that could be avoided.
ਕਹਿੰਦੇ ਨੇ ਇਹ ਹਾਦਸਾ ਬਚ ਸਕਦਾ ਸੀ ਅਗਰ ਕੋਸ਼ਿਸ਼ ਕੀਤੀ ਜਾਂਦੀ ਤੇ
Witnesses described you tailgating another semi.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਵਿਟਨੈਸ ਦੱਸਦੇ ਨੇ ਕਿ ਤੁਸੀਂ ਬਿਲਕੁਲ ਗੱਡੀ ਪਿੱਛੇ ਲਾਈ ਸੀ ਦੂਸਰੀ ਗੱਡੀਆਂ ਦੇ ਸਮੇਂ ਦੇ ਪਿੱਛੇ ਲਾਈ ਹੋਈ ਸੀ ਤੁਸੀਂ
Swerving across the center line to pass.
ਜਿਹੜੀ ਦਰਮਿਆਨ ਵਾਲੀ ਲੇਨ ਸੀ ਤੁਸੀਂ ਉਹਨੂੰ ਕੋਸ਼ਿਸ਼ ਕਰ ਰਹੇ ਸੋ ਪਾਸ ਕਰਕੇ ਅੱਗੇ ਜਾਣ ਦੀ
And the explanation of the vehicle that you struck
ਜਿਹੜੀ ਤੁਸੀਂ ਗੱਡੀ ਜਿਹੜੀ ਜਾ ਕੇ ਗੱਡੀ ਮਾਰੀ ਹੈ ਉਹਨੂੰ ਵੇਖਦੇ ਹੋਏ
trailers fishtailing
ਟ੍ਰੇਲਰ ਜਿਹੜਾ ਸੀ ਉਹ ਫਿਸ਼ ਟੇਲਿੰਗ ਕਰ ਰਿਹਾ ਸੀ
makes absolutely no sense.
ਕਹਿੰਦੇ ਨੇ ਉਹਦੀ ਕੋਈ ਗੱਲ ਜਿਹੜੀ ਨਾ ਸਮਝ ਨਹੀਂ ਆਉਂਦੀ ਹੈ
It is reported that you struck Mr. Boland's pickup
ਕਹਿੰਦੇ ਨੇ ਕਿ ਇਹ ਜਿਹੜੀ ਨਾ ਗੱਲ ਸਮਝ ਜਾਈਏ ਕਿ ਤੁਸੀਂ ਜਾ ਕੇ ਉਹਨਾਂ ਮਿਸਟਰ ਬੋਲਿੰਗ ਦੇ ਵਿੱਚ ਜਾ ਕੇ ਗੱਡੀ ਮਾਰੀ ਹੈ head on ਤੁਸੀਂ ਸਿੱਧੀ ਜਾ ਕੇ ਗੱਡੀ ਮਾਰੀ ਹੈ ਉੱਥੇ
I did not see in the report
ਕਹਿੰਦੇ ਨੇ ਮੈਂ ਰਿਪੋਰਟ ਵਿੱਚ ਨਹੀਂ ਵੇਖਿਆ
an allegation
ਕਿ ਕੋਈ ਤੁਹਾਡੇ ਤੇ ਲੱਗਿਆ ਹੋਏ ਇਲਜ਼ਾਮ ਲੱਗਿਆ ਹੋਏ
that you were sideswiped by his trailer causing the accident.
ਹਾਂ ਕਿ ਤੁਹਾਨੂੰ ਉਹਨੇ ਜਿਹੜਾ ਹੈ ਨਾ ਤੁਹਾਨੂੰ ਉਹਨੇ ਸਾਈਡ ਕੀਤੀ ਹੈ ਕਿ ਤੁਹਾਡੀ ਉਹਦੀ ਵਜ੍ਹਾ ਤੋਂ ਤੁਹਾਡੀ ਗੱਡੀ ਜਿਹੜੀ ਜਾ ਕੇ ਲੱਗੀ ਹੈ
I too saw some of these speeding incidents that Ms. Carey referenced.
ਕਹਿੰਦੇ ਕਿ ਮੈਨੂੰ ਤਜਰਬਾ ਹੈਗਾ ਜਿਹੜੇ ਸਪੀਡਿੰਗ ਐਕਸੀਡੈਂਟ ਹੁੰਦੇ ਨੇ ਜਿਹੜਾ ਮਿਸ ਕੈਰੀ ਨੇ ਦੱਸਿਆ
As they are referenced in People's Exhibit number 1.
ਕਹਿੰਦੇ ਨੇ ਉਹ ਰੈਫਰੈਂਸ ਹੈਗਾ ਐਗਜ਼ਿਬਿਟ ਨੰਬਰ 1 ਦੇ ਮੁਤਾਬਿਕ
And could not help but realize
ਕਹਿੰਦੇ ਨੇ ਉਹ ਸਾਨੂੰ ਹੈਲਪ ਨਹੀਂ ਕਰ ਸਕਦਾ ਰਿਅਲਾਈਜ਼ ਕਰਨ ਤੇ
that they were in a commercial vehicle as well.
ਕਿ ਉਹ ਕਮਰਸ਼ੀਅਲ ਵਹੀਕਲ ਹੋ ਸਕਦੀ ਹੈ
I understand the urge
मैं
for a driver
मैं समझना कि ਜਿਹੜਾ ਡਰਾਈਵਰ ਹੈ ਉਹ ਕੀ ਚਾਹੁੰਦਾ ਹੈ
to make good time in their deliveries
ਕਹਿੰਦੇ ਨੇ ਮੈਨੂੰ ਪਤਾ ਹੈ ਕਿ ਉਹਨਾਂ ਨੇ ਆਪਣੇ ਟਾਈਮ ਦੇ ਹਿਸਾਬ ਨਾਲ ਡਿਲੀਵਰੀ ਕਰਨਾ ਚਾਹੁੰਦੇ ਨੇ
and oftentimes
ਅਕਸਰ ਔਕਾਤ ਜਿਹੜਾ ਹੈ
there is an incentive to do so.
ਕਹਿੰਦੇ ਉਹਨਾਂ ਨੂੰ ਉਸ ਗੱਲ ਦਾ ਸਮ ਟਾਈਮ ਜਿਹੜਾ ਹੈ ਫਾਇਦਾ ਵੀ ਮਿਲ ਜਾਂਦਾ ਹੈ ਟਾਈਮ ਤੋਂ ਪਹਿਲੇ ਡਿਲੀਵਰੀ ਕਰਨ ਦਾ
While I am not saying that is what happened here,
ਕਹਿੰਦੇ ਮੈਨੂੰ ਨਹੀਂ ਲੱਗਦਾ ਕਿ ਇੱਥੇ ਇਹ ਗੱਲ ਹੋਈ ਹੈ
I am aware that that does happen.
ਕਹਿੰਦੇ ਨੇ ਮੈਨੂੰ ਨਹੀਂ ਪਤਾ ਕੀ
Is left
ਹੁਣ ਸੋਚੀ ਪੈ ਗਿਆ ਦੱਸਦਾ ਪਿਆ ਕਿ ਕੀ ਹੁਣ ਕਰਨਾ ਹੈ
a decision for sentencing
ਆਪਣਾ ਫੈਸਲਾ ਸੁਣਾਉਣ ਤੋਂ ਪਹਿਲੇ ਜੋ ਹੈ ਡਿਸੀਜਨ ਕਰਦਾ ਪਿਆ ਫੈਸਲਾ ਕਰਦਾ ਪਿਆ
that is both going to serve as a punishment
ਕਿ ਕਹਿੰਦੇ ਨੇ ਤੇ ਸਜ਼ਾ ਤੁਹਾਨੂੰ ਜਿਹੜੀ ਹੈ ਪਨਿਸ਼ਮੈਂਟ ਮਿਲਣੀ ਚਾਹੀਦੀ ਹੈ
and a deterrence to others
ਤਾਂ ਕਿ ਦੂਸਰਿਆਂ ਨੂੰ ਵੀ ਇਸ ਗੱਲ ਦਾ ਪਤਾ ਲੱਗੇ ਕਿ ਕੀ ਸਜ਼ਾ ਕੀ ਹੋਣੀ ਚਾਹੀਦੀ ਹੈ
in operating with the complete disregard that you shown back on March 18th.
ਹਾਂ ਕਹਿੰਦੇ ਤਾਂ ਕਿ ਲੋਕਾਂ ਨੂੰ ਪਤਾ ਚੱਲੇ ਕਿ ਜਿਸ ਤਰ੍ਹਾਂ ਤੁਸੀਂ ਗੱਡੀ 18 ਤਰੀਕ ਨੂੰ ਚਲਾਈ ਹੈ ਉਹਦੀ ਵਜ੍ਹਾ ਤੋਂ ਪਤਾ ਹੋਣਾ ਚਾਹੀਦਾ ਕਿ ਤੁਹਾਨੂੰ ਕੀ ਸਜ਼ਾ ਮਿਲੀ ਹੈ
At least as the court is aware, you have no prior criminal history.
ਕਹਿੰਦੇ ਨੇ ਕੋਰਟ ਨੂੰ ਪਤਾ ਹੈ ਕਿ ਤੁਹਾਡੀ ਪਹਿਲੇ ਕੋਈ ਕ੍ਰਿਮੀਨਲ ਹਿਸਟਰੀ ਨਹੀਂ ਹੈਗੀ
There is no allegation of drug or alcohol use.
ਤੁਹਾਡੀ ਕੋਈ ਵੀ ਤੁਸੀਂ ਜਿਹੜਾ ਕੋਈ ਸ਼ਰਾਬ ਤੇ ਕੋਈ ਡਰੱਗ ਦਾ ਤੁਹਾਡਾ ਯੂਜ਼ ਨਹੀਂ ਹੈਗਾ
So there is nothing that I can rehabilitate you for using probation.
ਹਾਂ ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਤੁਹਾਨੂੰ ਕਿਸੇ ਵੀ ਸ਼ੈ ਵਾਸਤੇ ਤੁਹਾਨੂੰ ਪ੍ਰੋਬੇਸ਼ਨ ਵਾਸਤੇ ਨਹੀਂ ਭੇਜ ਸਕਦਾ
Which is one of the goals of probation.
ਉਹ ਪ੍ਰੋਬੇਸ਼ਨ ਦਾ ਮਤਲਬ ਇਹ ਹੀ ਹੁੰਦਾ ਜਿਨ੍ਹਾਂ ਦੇ ਇਹੋ ਜਿਹੀ ਗੱਲਾਂ ਹੋਣ ਉਹਨਾਂ ਨੂੰ ਭੇਜ ਦੇਣ
So essentially that leaves me with
ਕਹਿੰਦੇ ਨੇ ਇਹ ਫਿਰ ਉਸ ਤੋਂ ਬਾਅਦ ਜਿਹੜਾ ਮੈਨੂੰ ਜ਼ਰੂਰੀ ਹੈ
what to do.
ਕਿ ਮੈਂ ਕੀ ਕਰਾਂ
It was referred or suggested in one of the impacts today.
ਕਹਿੰਦੇ ਨੇ ਮੈਨੂੰ ਜਿਹੜਾ ਮੈਨੂੰ ਦੱਸਿਆ ਗਿਆ ਹੈ ਤੇ ਮੈਨੂੰ ਸਮਝਾਇਆ ਗਿਆ ਹੈ ਜਾਂ ਮੈਨੂੰ ਮਸ਼ਵਰਾ ਦਿੱਤਾ ਗਿਆ ਹੈ
that you essentially speak to others in truck driving schools
ਕਿ ਤੁਸੀਂ ਜਿਹੜੇ ਬਾਕੀ ਟਰੱਕ ਡਰਾਈਵਿੰਗ ਸਕੂਲਸ ਦੇ ਨਾਲ ਤੁਸੀਂ ਗੱਲ ਕਰੋ
or other young drivers
ਜਾਂ ਜਿਹੜੇ ਹੋਰ ਜਿਹੜੇ ਯੰਗ ਡਰਾਈਵਰ ਨੇ ਉਹਨਾਂ ਦੇ ਨਾਲ
on how to or on what not to do when driving.
ਹਾਂ ਕਹਿੰਦੇ ਨੇ ਕਿ ਨਾ ਜਿਹੜੀ ਕੀ ਸ਼ਾਵਾਂ ਕਰਨੀ ਚਾਹੀਦੀਆਂ ਕੀ ਸ਼ਾਵਾਂ ਨਹੀਂ ਕਰਨੀਆਂ ਚਾਹੀਦੀਆਂ ਨੇ
While I am not going to order that,
ਕਹਿੰਦੇ ਨੇ ਮੈਂ ਆਰਡਰ ਜਦੋਂ ਕਰਾਂਗਾ
I think it is something that you would be a good candidate for.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਤੁਸੀਂ ਮੇਰੇ ਦੇ ਨਹੀਂ ਚਾਹੇ ਕਿ ਤੁਸੀਂ ਜਿਹੜੇ ਹੋ ਸਹੀ ਬੰਦੇ ਹੋ ਇਹ ਲੋਕਾਂ ਨੂੰ ਸਮਝਾਉਣ ਵਾਸਤੇ ਕੀ ਕੀ ਕਰਨਾ ਚਾਹੀਦਾ ਜਾਂ ਨਹੀਂ ਕਰਨਾ ਚਾਹੀਦਾ
Sir, I want you to understand
ਕਹਿੰਦੇ ਨੇ ਮੈਂ ਚਾਹਨਾ ਕਿ ਤੁਸੀਂ ਸਮਝੋ
that I don't believe that this was on purpose.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਯਕੀਨ ਕਰਦਾ ਕਿ ਇਹ ਪਰਪਸ ਨਹੀਂ ਸੀ ਇਹਦਾ ਕੋਈ ਮਤਲਬ ਨਹੀਂ ਸੀ
Or that you're a bad person because of it.
ਕਹਿੰਦੇ ਕਿ ਮੈਂ ਨਹੀਂ ਸਮਝਦਾ ਕਿ ਤੁਸੀਂ ਭੈੜੇ ਬੰਦੇ ਹੋ ਇਸ ਵਜ੍ਹਾ ਤੋਂ
Good people make mistakes.
ਕਹਿੰਦੇ ਚੰਗੇ ਬੰਦਿਆਂ ਕੋਲੋਂ ਵੀ ਗਲਤੀਆਂ ਹੋ ਜਾਂਦੀਆਂ
And I wish I could say this was a mistake.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਸੋਚਣਾ ਕਿ ਮੈਂ ਕਹਿ ਸਕਾਂ ਕਿ ਇਹ ਗਲਤੀ ਹੈ ਲੇਕਿਨ
But from what I read in the report,
ਜੋ ਮੈਂ ਰਿਪੋਰਟ ਵਿੱਚ ਪੜ੍ਹਿਆ ਹੈ
your intention that day was to get around the other semi as quickly as you could.
ਤੁਹਾਡੀ ਮੈਨੂੰ ਜੋ ਸਮਝ ਵਿੱਚ ਆਇਆ ਕਿ ਤੁਸੀਂ ਦੂਸਰਾ ਜਿਹੜਾ ਸੈਮੀ ਟਰੱਕ ਸੀ ਉਹਦੇ ਅੱਗੇ ਪਾਸ ਕਰਕੇ ਅੱਗੇ ਜਾਣਾ ਚਾਹ ਰਹੇ ਸੀ
Without regard
ਕਿਸੇ ਚੀਜ਼ ਨੂੰ ਸਮਝੇ ਬਗੈਰ
to other human life.
ਕਿ ਬਾਕੀ ਕਿਸੇ ਇਨਸਾਨ ਦੀ ਜ਼ਿੰਦਗੀ ਨੂੰ ਕੀ ਨੁਕਸਾਨ ਹੋ ਸਕਦਾ
as is commonly said, actions have consequences.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਿਸ ਤਰ੍ਹਾਂ ਕਿਹਾ ਜਾਂਦਾ ਹੈ ਕਿ ਜੋ ਵੀ ਤੁਸੀਂ ਕਰਦੇ ਹੋ ਉਹਦੇ ਨਤੀਜੇ ਵੀ ਭੁਗਤਣੇ ਪੈਂਦੇ ਨੇ।
And because of your actions,
ਤੁਹਾਨੂੰ ਉਹਦਾ ਨਤੀਜਾ ਭੁਗਤਣਾ ਪਏਗਾ।
While I believe you causing the death was an accident,
ਕਹਿੰਦੇ ਨੇ ਮੈਨੂੰ ਯਕੀਨ ਹੈ ਕਿ ਤੁਹਾਡੀ ਵਜ੍ਹਾ ਤੋਂ ਜੋ ਕਿਸੇ ਦੀ ਜ਼ਿੰਦਗੀ ਤੁਸੀਂ ਐਕਸੀਡੈਂਟ ਕੀਤਾ ਹੈ।
moving violation was not.
ਕਹਿੰਦੇ ਮੂਵਿੰਗ ਵਾਇਲੇਸ਼ਨ ਜਿਹੜੀ ਹੈ ਨਾ ਉਹ ਨਹੀਂ ਹੈਗੀ, ਲੇਕਿਨ ਤੁਸੀਂ ਤੁਹਾਡੀ ਵਜ੍ਹਾ ਤੋਂ ਐਕਸੀਡੈਂਟ ਹੋਇਆ।
And as I said,
ਕਹਿੰਦੇ ਜਿਸ
and
ਤਰ੍ਹਾਂ ਮੈਂ
as I
ਕਹਿਣਾ
said,
ਜਾਂ
there's
ਜਿਸ ਤਰ੍ਹਾਂ ਮੈਂ
nothing I
ਕਹਿਣਾ
can do
ਕਹਿੰਦੇ ਮੈਂ ਕੁਝ ਨਹੀਂ ਕਰ ਸਕਦਾ
to bring Mr. Bolin back.
ਕਿ ਮਿਸਟਰ ਬੋਲਿੰਗ ਨੇ ਮੈਂ ਵਾਪਸ ਨਹੀਂ ਲੈ ਕੇ ਆ ਸਕਦਾ।
But I can impose a sanction
ਕਹਿੰਦੇ ਨੇ ਕਿ ਮੈਂ ਸੈਂਕਸ਼ਨ ਲਾ ਸਕਣਾ
that will, as previously stated, deter others
ਕਿ ਜੋ ਬਾਕੀਆਂ ਨੂੰ ਸਮਝਾ ਸਕੇ
and make the Bolin family
ਜਿਹੜੀ ਬੋਲਿੰਗ ਫੈਮਿਲੀ ਹੈ
feel as though
ਜਾਂ ਉਹਨਾਂ ਨੂੰ ਜੋ ਨੁਕਸਾਨ ਪਹੁੰਚਿਆ ਹੈ
they have received some justice out of this case.
ਤਾਂ ਕਿ ਉਹਨਾਂ ਨੂੰ ਇਨਸਾਫ ਮਿਲਣਾ ਚਾਹੀਦਾ ਹੈ ਇਸ ਕੇਸ ਵਿੱਚੋਂ।
The statute only requires
ਕਹਿੰਦੇ ਨੇ ਜੋ ਇਹ ਜਿਹੜਾ ਹੈ ਇਹਦਾ ਮਕਸਦ ਜਿਹੜਾ ਹੈ ਸਿਰਫ ਇਹ ਕੀ ਮੰਗਦਾ ਹੈ
that there be a moving violation causing death.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਜਿਹੜਾ ਗੱਡੀ ਚੱਲਦੀ ਜਿਹੜੀ ਹੈ ਉਹਨੇ ਜਿਹੜਾ ਨਾ ਕਿਸੇ ਦੀ ਜ਼ਿੰਦਗੀ ਲਿੱਤੀ ਹੈ।
It doesn't contemplate
ਕਹਿੰਦੀ ਹੈ ਉਸ ਚੀਜ਼ ਨੂੰ ਉਹਦਾ ਕੋਈ ਉਹਨੂੰ ਗੱਲ ਨੂੰ ਕਰਦੀ ਨਹੀਂ ਕਿ ਕਲੀਅਰ ਨਹੀਂ ਕਰਦੀ ਕਿ ਤੁਸੀਂ ਨਹੀਂ ਕਰ ਸਕਦੇ ਉਸ ਚੀਜ਼ ਨੂੰ।
the driver's actions
ਜੋ ਡਰਾਈਵਰ ਹੈ ਉਹਦਾ ਐਕਸ਼ਨ ਜਿਹੜਾ ਹੈ ਉਹਨੇ ਜੋ ਕੀਤਾ ਹੈ
or malice in causing the death.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਕੋਈ ਹੋਰ ਸ਼ੈ ਨੇ ਉਹਨੇ ਕਾਜ਼ ਨਹੀਂ ਕੀਤਾ, ਡਾਕਟਰ ਉਹਦੇ ਐਕਸ਼ਨ ਨੇ ਕੀਤਾ ਹੈ।
The court must also
ਕਹਿੰਦੇ ਨੇ ਕੋਰਟ ਜਿਹੜਾ ਹੈ ਨਾ ਉਹਨੂੰ ਜ਼ਰੂਰੀ ਕਰਨਾ ਹੈ
assure that any penalty I assess
ਕਹਿੰਦੇ ਜੋ ਵੀ ਕੋਈ ਪੈਨਲਟੀ ਹੈ ISS ਦੀ
fits the crime.
ਉਹ ਜਿਹੜਾ ਕ੍ਰਾਈਮ ਦੇ ਮੁਤਾਬਕ ਹੋਵੇ, ਜੋ ਜੁਰਮ ਉਹਦੇ ਮੁਤਾਬਕ ਹੋਵੇ।
I might have a little more sympathy
ਕਹਿੰਦੇ ਨੇ ਮੈਨੂੰ ਹੋ ਸਕਦਾ ਥੋੜੀ ਹਮਦਰਦੀ ਹੋਵੇ
if this had been in a snowstorm,
ਕਹਿੰਦੇ ਨੇ ਅਗਰ ਕੋਈ ਸਨੋ ਸਟਾਰਮ ਹੁੰਦਾ,
a blown tire,
ਜਾਂ ਟਾਇਰ ਫਟ ਜਾਂਦਾ
or icy roads.
ਔਰ ਆਈਸੀ ਰੋਡ ਹੁੰਦਾ।
We have none of that here.
ਕਹਿੰਦੇ ਕੁਝ ਵੀ ਨਹੀਂ ਸੀ ਇਸ ਤਰ੍ਹਾਂ ਦਾ।
We have clear roads,
ਬਿਲਕੁਲ ਸੜਕਾਂ ਸਾਫ਼ ਸਨ,
dry roads,
ਬਿਲਕੁਲ ਖੁਸ਼ਕ ਸਨ,
36 degrees,
36 ਡਿਗਰੀ ਟੈਂਪਰੇਚਰ ਸੀ,
and visibility of 10 miles.
ਵਿਜ਼ਿਬਿਲਿਟੀ ਜਿਹੜੀ ਸੀ 10 ਮਾਈਲ ਸੀ।
The only thing causing death that day
ਕਹਿੰਦੇ ਜਿਹੜਾ ਮੌਤ ਦਾ ਬਾਇਸ ਬਣੀ ਗੱਲ
was your actions.
ਤੁਹਾਡਾ ਐਕਸ਼ਨ ਸੀ ਜੋ ਤੁਸੀਂ ਕੀਤਾ।
As such,
ਇਹਦੀ ਵਜ੍ਹਾ ਤੋਂ
I find it appropriate
ਮੈਂ ਸਮਝਣਾ ਕਿ ਇਹ ਗੱਲ ਮੁਨਾਸਬ ਹੈ
to impose a jail sentence
ਕਿ ਮੈਂ ਜੇਲ੍ਹ ਦੇ ਜਿਹੜਾ ਨਾ ਤੁਹਾਨੂੰ ਸਜ਼ਾ ਸੁਣਾਵਾਂ
to the maximum allowed under the law,
ਜਿਹੜੀ ਮੈਕਸਿਮਮ ਹੈ ਲਾਅ ਦੇ ਮੁਤਾਬਕ,
to 1 year,
1 ਸਾਲ
365 days,
365 ਦਿਨ
with 7 days credit.
7 ਦਿਨਾਂ ਦਾ ਕ੍ਰੈਡਿਟ ਦੇ ਕੇ।
There is also a Crime Victims' Rights Fund fee
ਕਹਿੰਦੇ ਨੇ ਕ੍ਰਾਈਮ ਰਜਿਸਟਰ ਜਿਹੜਾ ਉਹਦੀ ਫੀ ਵੀ ਹੈਗੀ ਹੈ
of $75,
$75,
a state minimum fee
ਕਹਿੰਦੇ ਸਟੇਟ ਦੀ ਮਿਨੀਮਮ ਫੀ
of $50,
$50 minimum fee है,
a $2,000 fine,
$2,000 फाइन है,
$150, no, I'm gonna raise that, $250 court costs.
$250 ਜਿਹੜੀ ਆ ਕੋਰਟ ਦੀ ਕਾਸਟ ਹੈ।
Mr. Gurmurthy, you're retained?
Yes.
ਉਹਨਾਂ ਨੇ ਪੁੱਛਿਆ ਮਿਸਟਰ ਗਰੂਮਨ ਨੂੰ ਕਿ ਉਹ ਮੰਨਦੇ ਨੇ ਇਸ ਗੱਲ ਨੂੰ, ਉਹ ਕਹਿੰਦੇ ਨੇ ਯੈਸ।
Ms. Carey, is there anything I have missed in a judgment of sentence?
People would request that you leave restitution open. I know there is likely a civil suit. I think it's already started or getting started, but I would ask that you leave restitution open. We don't have an amount at this time.
The court will set Mr. Gurmurthy?
I just want to have a translation.
Oh, sorry, thank you. Can you repeat that, Ms. Carey?
Yeah.
People request
ਕਹਿੰਦੇ ਨੇ ਲੋਕੀ ਰਿਕੁਐਸਟ ਕਰ ਰਹੇ ਨੇ
that restitution be held open.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਉਹ ਜਿਹੜਾ ਜੋ ਕਹਿ ਰਹੇ ਨੇ ਕਿ ਇਹ ਜਿਹੜਾ ਨਾ ਜੋ ਪੈਸਿਆਂ ਦੀ ਗੱਲ ਹੈ ਇਹਨੂੰ ਖੁੱਲਾ ਹੋਣੇ ਰਹਿਣ ਦੇਣਾ ਚਾਹੀਦਾ।
The amount is undetermined.
ਕਹਿੰਦੇ ਨੇ ਹੁਣ ਅਸੀਂ ਡਿਟਰਮਿਨ ਜੋ ਕਰਨਾ ਹੈ ਜੋ ਅਸੀਂ ਸੋਚਣਾ ਹੈ।
And it is our understanding there is a civil suit.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਇਸ ਵਾਸਤੇ ਕਿ ਜਿਹੜਾ ਉਹਨਾਂ ਦੇ ਜਿਹੜਾ ਸਿਵਲ ਜਿਹੜਾ ਮੁਕੱਦਮਾ ਹੋਣਾ ਹੈ ਉਹਦੀ ਵਜ੍ਹਾ ਤੋਂ
Or will be coming.
ਔਰ ਜਾਂ ਸ਼ਾਇਦ ਬਾਅਦ ਵਿੱਚ ਹੋਵੇ।
The court will set restitution at 0.
ਕਹਿੰਦੇ ਨੇ ਜਿਹੜਾ ਕੋਰਟ ਹੈ ਨਾ ਉਹ ਜਿਹੜਾ ਨਾ ਹੁਣੇ ਉਹਦੇ ਤੇ $0 ਦੀ ਰੱਖੇਗਾ ਅਮਾਉਂਟ।
Which will allow it to be brought back before the court.
ਕਹਿੰਦੇ ਨੇ ਦੁਬਾਰਾ ਫਿਰ ਕੋਰਟ ਦੇ ਸਾਹਮਣੇ ਲੈ ਕੇ ਆਣਗੇ।
Anything else, Ms. Carey?
No, sir, thank you.
Mr.
ਕਹਿੰਦੇ ਨੇ
Gurmurthy?
ਹੋਰ ਕੋਈ ਗੱਲ ਨਹੀਂ ਹੈਗੀ।
No, Your Honor, except I need the medical examiner's report.
Yeah. ਉਹ ਕਹਿੰਦੇ ਹੋਰ ਕੋਈ ਗੱਲ ਨਹੀਂ।
Mr. Singh, I must tell you
ਕਹਿੰਦੇ ਨੇ ਮਿਸਟਰ ਸਿੰਘ ਮੈਂ ਤੁਹਾਨੂੰ ਦੱਸਣਾ ਚਾਹਨਾ
that because you have been sentenced to a term of jail,
ਕਹਿੰਦੇ ਤੁਹਾਨੂੰ ਜਿਹੜਾ ਸਜ਼ਾ ਮਿਲੀ ਹੈ ਜੇਲ੍ਹ ਦੀ
you have the right to appeal that decision.
ਕਹਿੰਦੇ ਤੁਹਾਨੂੰ ਰਾਈਟ ਹੈਗਾ ਕਿ ਤੁਸੀਂ ਅਪੀਲ ਕਰ ਸਕਦੇ ਹੋ।
And if you wish the assistance of an attorney to assist you
ਕਹਿੰਦੇ ਨੇ ਕਿ ਤੁਸੀਂ ਚਾਹੁੰਦੇ ਹੋ ਤੁਹਾਡਾ ਵਕੀਲ ਤੁਹਾਨੂੰ ਇਹਦੇ ਵਿੱਚ ਮਦਦ ਕਰੇ
and cannot afford one,
ਅਗਰ ਤੁਸੀਂ ਅਫੋਰਡ ਨਹੀਂ ਕਰ ਸਕਦੇ ਕੋਈ ਇੱਕ ਵਕੀਲ
you must request one by the court within 14 days from today's date.
ਹਾਂ ਕਹਿੰਦੇ 14 ਦਿਨ ਦੇ ਅੰਦਰ ਅੰਦਰ ਤੁਸੀਂ ਵਕੀਲ ਜਿਹੜਾ ਹੈ ਕੋਰਟ ਕੋਲੋਂ ਕਹਿ ਕੇ ਤੇ ਕਰ ਸਕਦੇ ਹੋ ਅਗਰ ਤੁਸੀਂ ਅਫੋਰਡ ਨਹੀਂ ਕਰ ਸਕਦੇ ਤੇ।
Do you understand that?
ਤੁਸੀਂ ਗੱਲ ਸਮਝ ਗਏ ਹੋ? Yes, he said he got it.
Additionally, any balance that remains unpaid
ਕਹਿੰਦੇ ਨੇ ਜੋ ਵੀ ਕੋਈ ਬੈਲੈਂਸ ਜਿਹੜਾ ਨਹੀਂ ਪੇ ਕੀਤਾ ਗਿਆ
for more than 56 days
65 ਦਿਨਾਂ ਤੋਂ ਉੱਤੇ
will have a 20% penalty assessed.
ਕਹਿੰਦੇ ਉਹਨਾਂ ਤੇ 20% ਜਿਹੜੀ ਹੈ ਪੈਨਲਟੀ ਪਵੇਗੀ।
I understand that you will be in jail during that period,
ਕਹਿੰਦੇ ਮੈਨੂੰ ਪਤਾ ਹੈ ਕਿ ਤੁਸੀਂ ਜੇਲ੍ਹ ਵਿੱਚ ਹੋਗੇ ਇਸ ਦੌਰਾਨ ਵਿੱਚ
but that assessment still applies.
ਕਹਿੰਦੇ ਨੇ ਕਿ ਫਿਰ ਵੀ ਉਹ ਜਿਹੜੀ ਅਸੈਸਮੈਂਟ ਹੈ ਉਹ ਫਿਰ ਵੀ ਤੁਹਾਡੇ ਕੇਸ ਵਿੱਚ ਅਪਲਾਈ ਹੁੰਦੀ ਹੈ।
Do you have any questions for me?
ਕੋਈ ਸਵਾਲ ਹੈਗਾ ਤੁਹਾਡਾ? He said no.
One last time, Ms. Carey, anything else for the record?
No, thank you.
Mr. Gerb, sorry.
No. ਉਹ ਕਹਿੰਦੇ ਨੇ no, ਕੋਈ ਸਵਾਲ ਨਹੀਂ ਹੈਗਾ।
Mr. Gurmurthy?
No.
ਕਹਿੰਦੇ ਨੇ no.
Mr. Singh, you must go with the bailiff.
ਹਾਂ ਕਹਿੰਦੇ ਤੁਸੀਂ ਤੁਹਾਨੂੰ ਇਹਨਾਂ ਦੇ ਨਾਲ ਜਾਣਾ ਹੋਏਗਾ ਹੁਣ ਜਿਹੜੇ ਆਣਗੇ ਤੁਹਾਨੂੰ ਲੈਣ ਵਾਸਤੇ ਬੈਲਫ।
We are adjourned.
I'm gonna apologize, I was not there before.
Yes, you may get your exhibits. Ms. Carey,
can
you
I-
may get yours.
I'm done here, sir.
You are. Thank you very much. I appreciate your assistance today.
Thank you very much, Your Honor.
You can set it out.
Yeah.
Yeah, we can set it out.
Will Mr. Hartel, will all counsel approach, please?
Yes, Your Honor.
I'm trying to exit.
No, you're Okay, call State of Michigan versus Jamie Andrew Moore. This is case number 25682 SM. Appearances, counsel.
Joanne Curie for the people.
Robert Hartzell for Mr. Moore, who joins me at the table, Your Honor.
And we are set today, you may have a seat. We are set today for a plea and sentence. Court next calls the people of the state of Michigan versus Austin Scott Elkins.
Mr. Carnes, Your Honor.
Elkins is in jail.
They're here. Here's his assessment, if you want to take a look at that real fast. I'm just doing this real quick.
All right, this is the people of the state of Michigan versus Austin Scott Elkins, case number 251370. SM, appearances, counsel.
Nate Carnes on behalf of the people.
Robert Hartzell for Mr. Elkins, who joins me at the table, Your Honor.
And we are here for a bond violation hearing to violating the condition of no contact back on May 15th of 2025. Mr. Hartel, what are we doing?
Your Honor, it's my understanding that the defendant will enter a guilty plea to having found a disorderly person disturbing the peace, and the people will dismiss both charged counts as well as the bond violation.
Disturbing the peace, you said?
Yes, Your Honor.
All right. Just a moment. Mr. Hartel?
That is accurate, Your Honor.
So I want to make sure I understand it, and Mr. or counsel, that is that the defendant will plead guilty to what would be an added count 3 of disturbing the peace. In exchange for that, the domestic violence and the disorderly jostling will be dismissed along with the bond violation. Is that correct?
That's correct, Your Honor.
Mr. Elkins, have you heard the conversation we just had back and forth?
Yes, Your Honor.
And is that how you wish to resolve this case? Are you sure? Like, All right, we are back on the matter of people of the state of Michigan versus Austin Scott Elkins, case number 251370 SM. We left off, Mr. Hartel, are you satisfied that we're ready to move forward?
Yes, thank you.
Mr. Elkins, did you have an adequate opportunity to discuss your concerns with your attorney?
Yes, sure.
And you wish to proceed with the plea? Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Mr. Elkins, back on April 14th of this year, were you on probation or parole? Were you on bond? Were you on bond in any, April 14th of this year? You were on bond? What court were you on bond with?
Circuit court.
Okay, Mr. Hartel, are you aware of whether that's active? Any?
I've been advised it was a financial issue with probate court, Your Honor.
Okay, all right, all right. Mr. Elkins, did you read and sign this advice of rights form? Talk about your rights to an attorney and your rights to a trial?
Yes, Your Honor.
Did you understand those rights? Most importantly, do you understand that by entering a guilty plea today to disturbing the peace, you'll be giving up those rights? You won't have a trial of any kind. Other than the plea agreement, has anybody promised you anything in order to get you to plea today? Has anybody threatened you in any way? And I need you to speak right up. So
No, Your Honor.
everything we do is recorded, so I need to make sure the
Yeah.
recording equipment's getting you.
Sorry.
Is it your own free choice to plead today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements in which to get the defendant to plea that have been not made part of the record today?
No, Your Honor.
No.
Then to the allegation, Mr. Elkins, that on or about April 14th, 2025, in the city of Cadillac here in Wexford County, that you did commit the offense of disturbing the peace. How do you plead? In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on April 14th of this year, were you in the city of Cadillac?
Yes, Your Honor.
And did you have some sort of disturbance?
Yes.
Can you explain that to me?
There was a cat in the house. My mom didn't want it. She went to work. She said it better be gone. She said it better be gone by the time she gets home from work, in which case it wasn't. And she got home, into a little arguing match. I went to go shut the basement door on her so I didn't have to hear her elbow got caught in the door frame in the door. And then she called the cops. They came out. And there was a lot of yelling going on outside, out front.
And with that yelling, do you believe caused a disturbance?
Yeah, there was people out there, there was neighbors. Yeah, I wouldn't say it was a disturbance.
Do counsel believe that the defendants provided a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Elkins, I find you guilty of disturbing the peace. Pursuant to the plea agreement, the domestic violence and the disorderly jostling will be dismissed. Are we able to sentence today, Mr. Carnes?
Yes, Your Honor.
Is there any victim impact?
Yes, Your Honor. Ms. McNamara is here. She is one of the original victims and the mother of the domestic violence victim, as well as the mother.
Ms. McNamara, can you please state your name for the record?
Elizabeth McNamara.
And what is it you would like me to know?
That Austin, he's not a violent person. It was just a situation that had happened. So my concerns with his future with substance use, I just feel like something needs to take place with that. If he does get out, maybe some probation, some drug testing for his own well-being and safety and health.
Okay.
I don't fear my son. I'm not scared of him. I just want him to do better with saying no to people and doing the right thing.
All right.
Because he does have a lot of potential and he is a great person. He just messed up.
Anything else?
That's all.
All right, thank you. Elocution, Mr. Hartel?
Yes, thank you, Your Honor. If I was understanding some of what his mother was saying, I do thank her for being here today. I believe there was a request to lift the no contact order in the mix there, if I understood that correctly. She thinks she wasn't afraid of him. And if I'm mistaken, I apologize. But I would ask the court to consider that. I know that is his primary residence prior to the situations going on. I do believe a family structure could help a young man with being able to do well, avoiding drugs, avoiding issues. I realize that isn't the place where this all occurs, so there's some potential irony in what I'm saying, but I do believe she has his best wishes at heart as well. I would ask the court to consider time served and released even without supervision, but if the court felt that the only way to meet his mother's wishes and for the best interest of society as well was to give him a short period of probation, I would ask the court at a minimum to still let him go home today, to let him be released from jail, not have no contact with her or that property. I know that he does have a younger sibling that he wishes to be around as well. If there is any supervision, a term condition of the probation of just no threatening contact with anyone, I believe could overcome any concerns the court may have. Thank you.
Thank you, Your Honor. I am disturbed by some of the allegations I'm hearing about with the defendant and substance use. I am asking for a period of probation. I think substance use would also maybe explain some of the underlying behavior in this file. I do note the defendant was on probation and probate court, did very well at the end there. So I know he can stay clean, work hard, etc. I hope he can do that again. I do think he has sat sufficient jail time for this at this time. But again, I just ask the court to put him on a period of probation. I think it does serve the interests of society as well as the interests of the time.
Mr. Elkins, I just realized that during the plea taking process, I said counts 1 and 2 would be dismissed, but I forgot to tell you that that the bond violation would also be dismissed. Was that your understanding of the plea agreement?
Yes, that was mine.
And knowing all that, then do you still wish to enter your guilty plea today?
Wait, can you say that again?
With the added term that your bond violation will be dismissed, do you still wish to plead guilty today?
Yes, Your Honor.
So in other words, you reaffirm the plea that you already provided today? You reassert that plea?
Yeah.
All right. Mr. Elkins, you have the right to address the court when it comes time for sentencing. Is there anything you'd like me to know today?
I think that's it, Your Honor.
Well, Mr. Carnes alluded to your juvenile history, and you do have quite a lengthy history. You understand that, and you're relatively, well, I shouldn't say relatively, you are young. You're what, 18?
I just turned 18.
When did you turn 18?
March 18.
Happy birthday. Not quite the way you should be spending this, right?
Sorry.
And so in your past, I show a larceny less than 200 and a couple of attempt and resist police officers, joyriding, attempted tampering with electronic monitoring, attempted resist and obstruct, possession of marijuana, and MIP.
Yes.
Your mother had indicated that she thinks there might be some substance use issues going on. Is she accurate in that? Okay. And was that at play during the events of April 14th?
I mean, I've always smoked weed, so.
And you don't have a medical card?
No, I do not.
And you obviously are aware that that's against the law for you to be doing that, correct? Do you think it's such a problem that you can't stop on your own?
I feel I could stop.
And Mr. Carnes is accurate when he states that at least at the end of your probation in the juvenile court, you were doing pretty well. And so we would hope that, that probation would have taught you something. So I want you to be honest with me. Is there such a family dynamic here that it's more volatile for you to be within that dynamic?
Family dynamic?
Yes.
Yes.
Okay.
Volatile me.
That it causes more issues than it had you been separated. So being with family causes more issues than if you were not with family.
I mean, yes, at times, but that could be due
just being ignorant and stubborn and not wanting to listen to my mom at times.
You know, you're racking up such a history that you kind of remind me of a juvenile we had a couple of years ago that had racked up such a history in the juvenile court that his first or second adult conviction landed him in prison.
I know what you're talking about.
You're quickly going down that road. And what are we going to do to correct that?
What we need to do.
I'll buy onto that if you do.
Yes, Your Honor.
What are your thoughts on lifting the no contact order today?
I think that's my only residence to stay at. I want to with my mom. I want to have a relationship with her, my little brother.
And if I say it's okay to go back to her, are we going to have these same issues again?
No.
The rest of no contact on point.
Yeah, or based on my prior conversations with Ms. McNamara, she wants to contact.
Mr. Elkins, is there anything else you'd like me to know? Well, I'm going to take an unusual step of placing somebody on probation for disturbing the peace. Normally, I wouldn't do that because I think our probation services are better spent somewhere else. But for you, I think you need it. As I said, you did well in juvenile probation. So I think you need that structure. Did you graduate school?
No.
How far did you go?
And I finished 10th grade.
Okay.
I'm supposed to be in 11th grade this year.
You're supposed to be in 11th grade? Like just finishing up 11th grade?
Yeah, but I haven't done any schoolwork this year. I want to get my GED. That's all.
I'm going to make that a term of your probation, is that you get your GED. All right. So I'm going to place you on probation for 18 months. That is a lot longer than I normally would for this type of offense. But what I'm hoping is probation is not only to structure, it's to help rehabilitate you. And I think hopefully we can do that with what we're going to try to do. All right. So during that 18 months, you're not to violate any law, report as ordered, not leave the state of Michigan without the consent of your probation officer, keep your contact and employment information current. You are eligible for early release. So when we get to that 9-month mark, if you're successful with probation and you've done everything that we've asked you to do, you can be dismissed. Now, if you think that you should be dismissed and your probation officer doesn't, you can petition the court and we'll have a hearing on the matter. During that time, I'm going to order that you not consume alcohol or illegal controlled substances, and that is going to include recreational marijuana. Those are illegal for you to have anyways, so we're just going to bolster that a little bit. I'm going to order that you be subject to testing pursuant to the requirements of your probation officer. I'm going to order it. I can't believe I'm going to order it, but no bars where the primary source of alcohol, the primary source of business is the sale of alcohol. Restaurants that serve it are fine, but no bars. No alcohol or illegal drugs where you reside. I'm not going to order that you attend a recovery program, but you know, if you and your probation officer discuss it and think it might be beneficial, you know, that's going to be up to you guys. I'm going to order any counseling pursuant to your probation officer. I'm going to order that you get your GED. Have you ever had a job before?
I was working on it before.
What do you mean you were working on?
I was filling out applications.
Had you submitted it? What did you work on it? I'm going to lift the no contact order. Don't make me regret that. And I'm also going to order any additional programming that your probation officer determines is appropriate. There is a $75 crime victims' rights fee, $50 state minimum fee. Attorney fee, Mr. Hartel?
Waived.
We will waive the attorney fee. I'm only going to order the bare minimum because you're going to have some work to do for us. And I don't want to overburden you with fines and costs. So that's $125. Any balance that remains unpaid for more than 56 days, there will be a 20% penalty that gets added to that. There's 15 days jail with 15 days credit. Technically, because I have sentenced you to a term of jail, even though it's time served, you do have the right to appeal that decision. If you decide that you want to appeal that and cannot afford an attorney to assist you, you have 14 days from today's date in which to request an attorney to assist you. Do you understand that? Sure. Mr. Hart, Mr. Carnes, is there anything I missed in a judgment of sentence?
No, Your Honor.
Oh, I'm also gonna add that you not act in any violent, threatening, or intimidating behavior, and that you not purchase or possess a firearm or weapon.
Yes, Your Honor.
Mr. Hartel?
I wouldn't see any omissions, but just to confirm, this will not be under HYTA, just regular probation, correct? Your Honor?
Correct.
Thank you.
At least that was not the plea agreement.
Don't worry.
That's been yanked.
Understood, understood. Thank you.
Well, let's back up. I understand that that's been yanked by you, but because of his age, the court doesn't need your consent, Mr. Carnes, to put him on probation or HIDA.
That's correct.
So Mr. Hartel, is there a request for HIDA?
Yes, Your Honor, I apologize for not mentioning it earlier, but I do believe that would be appropriate since he did, if I understand correctly, finish well on juvenile probation. I obviously wasn't his attorney for that point, but I do believe that's been stated a few times. I know he's motivated to try to find work, to do well. And although a relatively small misdemeanor, a clean adult background check goes a long way, especially when you have limited education, limited work experience. He's got to compete the best he can. It would help. Thank you.
Mr. Elkins, are you familiar with what we commonly refer to as HIDA, but it's the Holmes Youthful Trainee Act? Are you aware of what that is? So what that is because of your age, the law understands or presumes that young people do stupid things. And because of that, the law has built into it a mechanism that allows us to put you on a period of probation. If you're successful with that period of probation, the charge is removed from your public record. It's gone. If you're not successful with it, the charge stands. And it's up to the judge to determine whether or not you're successful or unsuccessful. Do you understand that?
Sure.
Is that something that you want to take advantage of?
Sure.
Are you sure?
Yes.
Okay. Despite the defendant's prior juvenile history, and while I would understand why Mr. Carnes would not offer HIDA, I find these as waiting that you are Holmes Youthful Trainee Act. Any violation that you have regarding bond, or I'm sorry, probation, will be brought before the court, and the court will make a determination as to whether or not this will stay off of your public record. All right. But what that does mean is because this is pursuant to HIDA, the conviction does not enter. So that means that you are no longer eligible for the early release. So you would have to serve the full 18 months. I forgot to mention that to you. So knowing that, do you still want to go through with HIDA?
No.
Okay. So what you're basically telling me is you don't think you're going to be successful on probation.
Well, I do. I just want to be eligible for.
Okay. And so by selecting that option, no, it's entirely up to you. I can't force you to do it, but that's entirely up to you. So if you don't want to take advantage of HIDA, I'm not going to. Are you sure you want to take advantage of it? I don't want to feel as though I'm pressuring you to take it.
I just, the clarification helped a lot.
Okay, so you understand that by accepting HIDA probation, you're not eligible for that early release, and you'll have to serve the full 18 months. All right. Mr. Hartel, do you think we've covered that enough?
I do, and I have full faith in him as well.
Mr. Elkins, do you have any questions for me at all about what we just talked about?
No, I understand completely.
All right, then we will sentence pursuant to HYTA, and as such, you're not eligible for early termination. I believe there's nothing else that will have to change in a judgment of sentence. So you will be released today as soon as your paperwork is processed. I don't know if that will be sufficient time for you to check in with probation. If it's not, you need to check with them first thing tomorrow morning. Do you have any questions for me?
Where would I check in?
District Court probation is on the ground floor. were you doing testing while you were out? No, you weren't. Okay. So it's gonna be on the ground floor. Okay, anything else, council?
No, thank you.
All right, we are adjourned on that case.
I could have some time to talk to Mr. Moore, Your Honor.
You may. Okay, court next calls the people of the state of Michigan versus Warren. Mr. Grimmerly, how do you pronounce the last name?
It would be, first of all, it would be Warren, last name would be Singh.
Singh. I'm sorry for that. Appearances counsel.
Joanna Carey for the people.
Thank you, Honorable Gurumurthy, and we have Mr. Singh, and he's here seated to my right as well. Then we have Ms. Rasul, who's going to transfer.
All right. If I didn't say it, this is case number 2590. Okay, court calls the people of the state of Michigan versus Jamie Andrew Moore. This is case.
Moore joins with the table, Your Honor.
We are set today, you may have a seat. We are set today for a plea and sentence. I know we tried this back on the 22nd and some questions came up, in particular, the possibility of double jeopardy. I have reviewed and done my own research. I don't believe that applies here, but I'll leave it up to counsel to argue otherwise if they feel as though that's necessary. Mr. Hartel?
I don't feel additional allocution on that is necessary, Your Honor.
Ms. Carey?
Or do I?
All right. So it's my understanding we have a plea agreement in this case. And my understanding is that the defendant will plead no contest to all counts as charged. Is that correct?
Yeah.
That would be the understanding.
All right. Ms. Carey, I believe I returned your exhibit last time we were here. Actually, I think Mr. Carnes was covering you. Do you have that? Mr. Moore, while she's looking for that, will you please raise your right hand? You solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth.
Yes, sir.
All right. It's my understanding then that you'll be pleading no contest to all counts 1 through 4. Count number 1 being computers using a crime to commit an offense with a maximum imprisonment of 1 year or less. That is a 1-year misdemeanor and or a $5,000 fine, reimbursement to the government for expenses incurred, and consecutive sentencing may be imposed for the underlying conviction. In count number 2, you'll plead no contest to telecommunications malicious use. Regarding Ms. Carla Filkins, that is a 6-month misdemeanor and or a fine of $1,000. In count number 3, you'd plead no contest to telecommunication services malicious use. Regarding Marcus Pesha, that is a 6-month misdemeanor and or a fine of $1,000. And then in count number 4, it is alleged, or I'm sorry, you would plead no contest to telecommunications malicious use in regards to Renee Pesha. That again is a 6-month misdemeanor and or a fine of $1,000. Is that your understanding of how the case will be resolved today?
If I may, Your Honor, just to reiterate, there's also the agreement that the other cases would not be pursued.
Correct. Thank you for that. And so additionally, there will be no charges arising out of the Wexford County Police Report 83-25-00625 or the City of Cadillac Police Report. Ms. Carey, do you have that number? It ran into other letters on my sheet and I can't read what it says. I know it's a 25, I want to say 804 maybe? 884.
It's the same. It would have been one.
Okay, so it all arises out of the same occurrence?
Correct.
All right. Mr. Moore, is that now your understanding of the plea agreement?
Yes, sir.
And is that a full and accurate recitation of the plea agreement?
Yes, sir.
And I know we went through this last time, but I still need to cover it today. Did you read and sign the advice of rights form, talked about your rights to an attorney and your rights to a trial?
I did, yes, sir.
Did you understand those rights?
Yes, sir.
And do you understand that by entering a no contest plea today, you'll be waiving those rights and you won't have a trial of any kind?
Yes, sir.
Has anybody promised you anything in order to get you to plea today, other than the agreement?
No, sir.
Has anybody threatened you in order to get you to plea?
No, sir.
And is it your own free choice to plea today?
Yes, sir.
Now, do you understand that by entering a no contest plea, that it will allow the court to review in this case, a police report, which was already admitted as People's Exhibit number 1. I'll be able to use that to determine whether or not there's a factual basis and whether or not, and to use that for sentencing purposes. Do you understand that?
Yes, sir.
Additionally, the reason for the no contest plea is for potential civil liability. So if any person's listed in the complaint decides that they want to sue you civilly, a guilty plea could be used against you. This would allow you to accept the responsibility as if you are guilty without saying you're guilty. Do you understand that?
Understood. Yes, sir.
Then to the allegation that on or about January 21st, 2025, here in the city of Cadillac of Wexford County, in count number 1, that you did use a computer to commit a crime with a maximum imprisonment of 1 year or less, in particular, malicious use of a telecommunications device. How do you plead?
No contest.
To count number 2, malicious use of a telecommunications services in regards to Carla Filkins. How do you plead?
No contest.
In count number 3, malicious use of a telecommunications services in regard to Marcus Pesha. How do you plead?
No contest.
And in count number 4, malicious use of telecommunications services in regards to Renee Pesha. How do you plead?
No contest.
Last time we were here, I had the opportunity to review People's Exhibit number 1. Counsel, do you believe that People's Exhibit number 1 forms a factual basis in which to accept the plea?
I do.
Yes, Your Honor.
And that the court rules have been complied with?
Yes, sir.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. In particular, Mr. Moore, I find that back on January 21st of this year, you had sent messages, and those messages were threatening in nature. I'm sorry, People's Exhibit number 1 also includes the Michigan Department of State Police incident number 6441025. In particular, to the message that was sent to Ms. Filkins, it states as follows: "You're gonna do something about the water in Cadillac, or what, you stupid dumb bitch? You'll be lucky if one scary night someone don't come to your home and pull you from your sleep and pull you to the streets and put a bullet in your head, you corrupt dumb bitch." Additionally, there was a message sent to Mr. Pesha that says, "Just seen your wife reporting city council meetings on Facebook. You, sir, and your dumb little bitch of a wife should be pulled from your house while you sleep and a bullet put in your head. You're scumbag, corrupt loser, bitch, who should be shot dead in front of the whole community of Cadillac, just to show an example. Your wife is a scumbag, corrupt loser, or bitch too, you stupid fat fuck." I apologize for the language that was used, but I believe it's appropriate to place that language on the record to get the defendant's full intent when sending those messages. It's also my belief, based on the reading of the reports, that those had come in through a Facebook Messenger, which would meet the requirements for use of a computer to commit the crime. And additionally, I also find that these messages were sent to or regarding all persons involved, and that all persons involved would have seen these messages, and that they were sent with the intent to terrorize, frighten, intimidate, harass, or disturb the peace of each of these individuals. Additionally, I find that based on my reading of the report and by defendant's own admission, let me just find this here. He also admits to sending the messages and classifies them as an emotional overreaction, but had no plan to follow through with the threats. While he had no plan to follow through with the threats, at least as he describes, I do find that based on recent case law arising out of the Michigan Court of Appeals and the Michigan Supreme Court, I believe that these messages do show the intent of sending the messages was to threaten, terrorize, harass these individuals, and that the defendant knew that when sending those messages, that is the effect that they would have. As such, Mr. Moore, I find you guilty in count number 1 of using a computer to commit a crime with a maximum imprisonment of 1 year, which is a telecommunications services malicious use. Count number 2, telecommunications services malicious use regarding Ms. Filkins. Count 3, telecommunications malicious use regarding Marcus Pesha. And count 4, telecommunications malicious use regarding Renee Pesha. I also find that the interests of justice are well served in allowing the defendant to enter a no contest plea, in that a guilty plea could be used against him in a potential civil liability case. I also find that the plea is knowing, voluntary, and accurate. Pursuant to the plea agreement, those additional cases will not be brought. Ms. Carey, are we able to sentence today?
We are, and I have 2 of the victims here who would like to speak.
All right. Who wants to go first? Mr. Pesha, could you just state your name for the record, please?
Marcus Pesha.
And what is it you would like the court to know?
Thank you, and good afternoon, Your Honor, and officials of the court. Your Honor, words have meaning. Words can be weaponized, and words have consequences. You're here today because Mr. Moore read words on a social media platform posted by people that, in my opinion, was published to create an environment rife with chaos and mayhem, an environment to facilitate a crisis that does not exist by the malicious spreading of lies, misinformation, and attacks on my and my wife's character and credibility. Words have meaning. They can be weaponized, and they do have consequences. Mr. Moore could have read those words and reached out through a variety of methods to contact me, or a member of my staff, or a member of any number of state agencies, or even the feds, to gain information. Information that would provide the factual truth of what was being, in my opinion, falsely propagated on social media. However, Mr. Moore did not reach out to learn the truth. Rather, Mr. Moore directly messaged me on the social media platform's messaging feature to threaten me and my wife. And further, as I understand, also posted his profoundly alarming and disgusting threats in at least one publicly available social media group for an unlimited number of people to see, share, and spread. All things that could have led to, and still could lead to, disturbingly violent outcomes. Mr. Moore's actions have detrimentally impacted my life and my wife's. Mr. Moore's actions have also had a negative effect on my children, my family, my friends, and even colleagues. Mr. Moore's actions have caused stress, anxiety, and an emotional roller coaster of feelings. The shock and horror to see words about my wife and I being drug out of bed in the middle of the night, dragged through the streets, shot in the head, and displayed in the town square are evil, and they do have an impact. Stress, sleepless nights, being on edge, they're still with me. They're still with my wife and others. Behavior Mr. Moore has exemplified, it needs to stop. It is not okay. nor is it something that can be simply forgotten, forgiven, or excused. Words have meaning, words can be weaponized, and words have consequences, and I appreciate the court's time. Thank you.
Thank you. Ms. Wilkins?
Good afternoon, Your Honor and officials of the court. I came today not with a prepared statement, but I would like to speak from the heart today. Words do matter, and J.B. Moore chose to use his words for harm and for evil. And that impacted my family, my 85-year-old mother, my son, who is a Marine, my other children, my grandchildren. It impacted me. It was a game changer for me. I served the city of Cadillac for 11 years with tremendous honor. When I received a death threat for caring for my community over things that Mr. Moore read on Facebook and other social media that weren't necessarily true, people were just putting their words out there because that's what they can do on social media. And on January 21st, the very first thing before I walked out of the house that morning, I received that message from Mr. Moore on Facebook chat. And I was terrified. I called my husband home. I called the public safety director, and we spent the rest of the day not planning for our business that we needed to conduct that evening for the city of Cadillac. We spent our day trying to, first of all, understand what was happening. And how could we take care of our communities type of threats coming forward to us? It wasn't just about us. It was about people that are out there that can do such horrendous things with their words. And I just want the court to understand what that's done. Thank you.
Thank you, Bo. Elocution, Mr. Hartel?
Yes.
Well, first of all, I had ordered a pre-sentence investigation report on this. Did both parties receive that?
I did.
Mr. Hartel?
I did as well, Your Honor.
All right. Elocution?
Yes, thank you, Your Honor. Anytime there's civil liability possibility for the no contest, I'm obviously a bit cautious to overly allocute. However, I have had discussions with my client quite a bit about the situation. I would ask the court to equally factor in the goals of whatever punishment is given today. I believe that with supervision, any concerns the court may have for education of my clients, public safety, can be incorporated into terms of that probation. I realized that recommendation for a jail sentence was in the PSI, and the reasoning was explained in there as well. I certainly asked the court not to give a higher amount than was recommended in the PSI. I realized the court could, but I would ask the court still to consider just probation in this situation. I believe my client has done well on bond. I know there was some concerns that the people had mentioned that were being dismissed as part of this plea. We have our own position on whether he was or was not guilty of those particular things. I'm glad they're dismissed. You don't have to worry about it. My point is, he's always come to court. He reported to the PSI on time. He's a hardworking individual. In fact, I'm very proud to be able to say this part because I was proud of him when I saw it.